Broadcasting, we can commence. I declare open this second hearing of the Senate Environment and Communications Legislation Committee's inquiry into the Environment Protection Reform Bill 2025 and 6 related bills. I begin by acknowledging the traditional custodians of the land on which we meet and pay my respects to their elders past and present. I extend that respect to any Indigenous, Aboriginal or Torres Strait Islander people here today. These are public hearings being video streamed live via the Parliament's website, and a Hansard transcript is being made. If there are no objections, the committee authorises media recording and photography of the committee's proceedings in accordance with Senate Resolution Number 3. Remind any media in the room or media attending today that permission can be revoked at any time, and the media must follow the directions of the committee secretariat staff. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. The committee generally prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in private session. The Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy, should be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. I'm not sure that will necessarily apply today, but we'll see. If a witness objects to answering a question, they should state the ground on which the objection is made, and then the committee will determine whether it will insist on an answer having regard to the ground on which it's claimed. And if the committee determines to insist on an answer, then a witness can request that an answer be given in camera. Commonwealth officers appearing today, if any, are also reminded of the Senate order specifying the processes by which claims of public interest immunity can be raised, and a copy of the order is available from the Secretariat. I remind senators here today and online of their obligations under the Behaviour Code of Australian Parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. And I now welcome the representatives from the Australian Industry Group and the Business Council of Australia. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. That's right, there's nodding at the table. Yes. For the Hansard record, will the witnesses here please state your full name and capacity in which you appear today?
Brand Black, Chief Executive, Business Council of Australia.
Thank you.
Andrew Fatale, Director of Infrastructure and Planning at the Business Council of Australia.
Louise McGrath, Head of Industry Development and Policy, Australian Industry Group.
Thank you very much. We've received your submissions and are grateful for those. I invite you to make a short opening statement if you have one. If you could keep it as short as possible, because I'm sure we've got lots of questions from senators here online, and then at the conclusion of any remarks I'll invite senators to ask questions. Thank you.
Thank you, Chair. I appreciate the opportunity to appear here because getting this reform right is so important. It's ultimately about what Australians desperately need: homes, critical infrastructure, renewable energy to power our future, and a better environment. That's how high the stakes are for getting this reform right. The Business Council and our members believe that with common sense changes, the proposed laws before us can do a better job of both protecting the environment and allowing us to build what Australians need most for our future. We appreciate the engagement the government and the opposition have provided during this process, and with meaningful adjustments, we believe this Parliament can deliver a set of laws the community can back in. That's the proposal we have put forward in our submission. It's also a similar proposal put forward by an alliance of 26 industry associations representing every part of the economy, businesses big and small. We believe that long-lasting reform which delivers for both the environment and the economy is possible with bipartisan goodwill. To get it right, we consider, and our alliance of 26 organisations agrees, that the following changes are key: addressing unacceptable impacts, clarifying the powers of the EPA, ensuring social and economic factors are appropriately considered by retaining accountability and transparency, guaranteeing faster approvals and one-state accreditation at a minimum, maintaining existing assessment approaches, providing flexibility around the new sunset period for non-controlled actions, and noting the importance of supporting emissions reduction, ensuring emissions disclosures are not considered as part of the assessment processes and rather rely on existing reporting requirements rather than creating new ones. With considered amendments, we believe these bills can achieve the shared goal of a system that protects the environment and unlocks the housing, energy and infrastructure projects that Australians desperately need. we remain hopeful that the major parties of government can agree to the sensible and practical amendments that business is asking for, and which will ultimately deliver better outcomes for our economy and better outcomes for the environment. Thank you very much.
Thank you.
Thank you. The Australian Industry Group thanks for the opportunity to present this Senate inquiry. We need more housing emissions reduction above politics for EPBC reforms. Faster, more predictable environmental assessments are vital for Australia's economy and our environment, requiring both good rules and enduring political support. Reforming the EPBC is a crucial puzzle piece to deliver the scale of investment Australia needs to support communities into the future, build more housing stock and meet our net zero ambitions. The bill before Parliament has many positive elements, but perhaps the most important one is a single-touch process for assessing projects rather than separate state and federal processes. Even with the bill's provisions, it will take further work to deliver credible state enforcement of new national standards, and federal and state environment ministers need to make that a priority. Any delay in this bill will slow down these further stages of work. Broad political support is critical to ensure this reform will be enduring, which is the only way to give full confidence to unlock investment. The business community has raised important nuances as part of the consultation relating to matters like the specificity of definitions or the transition from current assessment pathways to a new streamlined option, but we believe they can be addressed. The main game is to make assessments work better so that things like housing and clean energy projects aren't stuck in a regulatory mire. Thank you.
Thank you. I was going to go... do you have a preference? I was going to go to Senator Duniam first, but...
Yep, sure.
Senator Duniam.
The anti-emission reduction party.
Senator Hanson-Young.
Thank you for that commentary from the anti-jobs party. We can do it all day.
Well, perhaps let's get it out of our systems now and not do it all day.
Renewable jobs.
No, it's
sustainable jobs.
You know, jobs that protect our environment. You know, ecotourism,
functioning economy. You know,
tourism.
Senator Hanson-Young, Senator Duniam, you will get sick of me saying this today, but this process will work better if you ask questions of the witnesses and allow them to respond. So, Senator Duniam, you have
I entirely agree, Chair, so let's get on with that. Thank you very much. Thank you very much for your submissions and the opening statements there. I want to go, if I can, first to the Business Council, and the first of the issues that were raised was around unacceptable impacts and the definitions as they currently exist. Can we just sort of dig into that a little bit more? Why is it, as it's currently structured, a concern to you?
Well, we don't take issue with the idea that there should be some classification of unacceptable impacts incorporated into the legislation. But what we are clear on is that there should be clarity as to what is unacceptable and what is not. And in that regard, I might just reference, if I can, briefly from page 48 of Professor Samuel's report, where he noted, and I'm paraphrasing but only very slightly, strong protections are needed for those matters most at risk of being lost, including clear rules about unacceptable impact. So I would stress that point. The clarity of the rules with respect to unacceptable impact is key. And what we're concerned about is that the existing definitions of unacceptable impacts deliver anything but. What it does is enhance vagueness, and the consequence of that, as we see it, is that there is the very real potential that projects that are presently capable of being assessed would no longer be capable of being assessed. Now, that's not to say that they would be approved, but we don't consider that it is appropriate that projects that are presently capable of being assessed now would be incapable under the new system.
Right. So, do you have any are you aware of any projects or applications that are currently on foot or may have already been approved that would be adversely impacted by the vagueness that you talk about in your last answer?
So precisely to that point, I think one of the challenges that we've got is because the provisions are so vague, we can't say definitively what projects they would capture and what projects they wouldn't capture. And you've just got to look at the language. The use of phrases like seriously impairs or viability are inherently unclear. And the consequence of that, we would say, is that this exposes a system which is intended to deliver clarity, as per Professor Samuel's report. The system is intended to deliver clarity, and these types of expressions do not deliver that. So what we're suggesting is that the approach that should be taken in terms of managing unacceptable impacts moving forward is that we replace the complex unacceptable impacts table construct with a single clear criterion of unacceptable impacts in the legislation. That should set the threshold at a level allowing potentially significant impacts to protected matters to continue to be assessed whilst ruling out clearly unacceptable impacts as intended. And then in terms of how you fill out or provide greater elaboration on what an unacceptable impact is, our position is that that should be set out subsequently in standards.
Okay. And so just on the setting out of standards beyond that point, is there not a risk if, you know, you've got your criterion set out in legislation and then further data to be considered or taken into account in the standards, that there is a risk that that vagueness reappears once the standards are being drafted and brought before Parliament?
Well, that's why we think it's appropriate to have a reasonable consultation period with respect to standards.
Yeah.
And it's important to be able to understand how they are going to be applied. But I think this goes back to the task that we're set upon now at a broader level, and that is that this is extremely difficult. This is a complex and incredibly highly needed piece of reform, but it is deeply complex, and there is a prospect through this reform process that we will need to make changes and make amendments as we go. We won't get everything right straight off the bat. So to the extent that you've got scope through standards to make these types of changes, that is a good thing that allows us to test what we think works on paper by reference to what we see on the ground.
Okay, and so you've provided this advice to government directly about the single criterion, the universal criterion to be put in place?
We have. That's certainly the position that we've set out in our submission as well.
Okay. And have you had any feedback from government about that proposal?
We know that in our engagement there is an openness to considering all of the proposals that we've put forward. That is to say, we haven't had a definitive position put to us one way or the other as to acceptance or non-acceptance, but there is an openness to considering what we've put forward, and we're grateful for that.
Okay, if I can just move to perhaps I might do the environmental protection orders and the guardrails that you talk about there in your submission under recommendation 3. What do you think is you talk about clear time limits with extensions available via court injunction processes, etc. What do you think is a sort of fair time limit to be attached to an EPO?
Well, and I should state from the outset, to be clear, we don't object to the Chief Executive of the EPA having the opportunity to make these types of orders. Our position is simply that we believe that these types of orders, which really are an exercise of quite extraordinary administrative power, should be subject to the types of procedural fairness requirements and natural justice requirements that you'd expect when those types of powers are exercised. And so what we're saying is two key things. Firstly, if you are going to issue an oral direction, there should be a requirement that you are to provide written reasons for why you've delivered your oral direction within a reasonable period, and I would have thought that that would be a matter of days. And then thereafter, if there is an intention on the part of the CEO of the EPA to continue an order beyond a reasonable period, I would have thought a week or something of that nature, but we haven't engaged specifically with our members with respect to that time frame. But I would have thought a reasonable period, after a reasonable period rather, you would expect that the maker of an order should be required to go to court if they wish for that order to continue. And again, that's the same type of procedural fairness requirement that you'd expect to apply in any situation where administrative power of this nature is exercised, if you take the criminal justice system as an analogy, ultimately it's for the state to make its case against an individual. And we would say, whilst we accept wholeheartedly the idea that sometimes there will be an urgent need for these types of powers to be applied, after that reasonable period, it should be appropriate for the CEO, if they wish to continue to have that order in operation, to go back and make their case.
Okay. So then we might just go to the EPA then. You have mentioned again in your submission around the scope and powers of the EPA, and that the focus should be on enforcement and compliance and assurance, which is consistent with Professor Samuel's recommendations. What underpins your contention that that's what the scope of the EPA should be constrained to?
Look, there are a few points that I'd make in that regard, and I do acknowledge that there has been a change in the drafting with respect to the powers of the EPA in this bill relative to the position that was put forward last year, and there is an improvement relative to last bill. Our position essentially stems from, again, what we would describe as good governance. So in the first instance, we don't think it is appropriate for a regulator to also be engaged in a project approval process. Just as a matter of principle, that doesn't strike us as the right approach that should be taken in government, period. I would also say that it is critical that at the end of the day, a minister needs to be accountable for these types of decisions. Again, that's good practice. The OECD has made that point. When you are dealing with complex matters that involve weighing up, in some instances balancing, and often looking at competing different social, environmental and economic considerations, what you need to make sure that you're doing is putting the onus of making, to make that decision on the shoulders of somebody who bears sufficient accountability. And that is a minister. That is appropriately a minister. That is somebody who is responsible to the Parliament and to the people of Australia as a consequence of that. And we also think that as a general proposition, a minister is the best person to do that balancing exercise, not just because of the accountability, but because of their broader responsibilities to the Parliament and to the Australian people.
Yeah, okay. So that then takes me to the statement of expectations arrangement between a minister and the CEO of the EPA. What do you think, I mean, how best to govern a relationship where there has to be a stream of accountability from the minister, who ultimately is responsible under our system of government, to the public around decisions that are made, and what's your view about the best way to structure that relationship between minister and CEO?
So we think it is appropriate to have a statement of expectations. You see that with respect to other regulators across government, the ACCC, APRA, ASIC, the Fair Work Ombudsman. They're all examples of regulators and government officials that have that statement that applies to them. And I think it's probably useful to take a look at the type of expectation that is enunciated in those types of documents. And I've got the Fair Work Ombudsman's statement here, and I'll just read, if I can, 2 sentences from it. Ministerial statements of expectations provide greater clarity about government policies and objectives relevant to the regulator in carrying out its statutory functions. This statement sets out my expectations of the Fair Work Ombudsman and their office, the Office of the Fair Work Ombudsman, for the performance of functions under the Act. We think that it is entirely reasonable for ministers to be clear in terms of how they propose the powers of regulators should be exercised by those regulators. And in circumstances where those powers aren't exercised in accordance with a statement of expectations, it is only fair and appropriate that there should be a dismissal power that exists as well.
And so, well, look, you've mentioned that, the power to terminate, so that's clear that if government's intentions aren't being followed through, you would support that termination power. Just back to the EPA and its powers more broadly. So assessment versus compliance, assurance and enforcement. Is it your view that assessment should stay with the department as opposed to with the EPA, or what's the...
That's correct. So we would consider that assessment and approvals should continue to rest with the department.
Yeah. And so your fundamental belief that that should be the case is based in what? Why do you think that should remain the case?
I mentioned before that as a matter of good governance, it is appropriate to have a distinction between who is ultimately undertaking project assessments and approvals and who is ultimately responsible for compliance and enforcement. We take no issue whatsoever with the idea that there should be a strong compliance and enforcement entity with respect to environmental standards. But we do think that it is very clear that as a matter of good governance, you should not have those two functions under the same roof.
Okay, and given the difference in role of a statutory agency versus a government department, that is a key distinction as well in how the role of an EPA may not be best suited for assessment and approval?
I think that's right. At the end of the day, it is the minister who should be making the decision, and ultimately the department is responsible for providing the minister with the advice on which he or she makes the approval.
And knowing I'll probably have to share the call shortly, just on net gain and the net gain test as proposed, what's your view on that? I mean, I understand that it's got a few thorns on it. How do you describe the problem and what's the best solution?
Look, again, I do stress from the outset, we don't object to the idea of net gain, and I wish to make that clear. What we are concerned about is that this is another example where there is a lack of clarity as to what it means. And because we are dealing with a lack of clarity, we think that the appropriate course is not to include that requirement in legislation. Rather, it would be set out in a standard, and thereafter you could fill in what that means. You could elaborate on what net gain means through a regulation. So we think that that's the appropriate way of delivering the result of net gain, but in such a way that enables us to undertake a proper consultation, including by reference to the testing that you'd expect with people who have that on-ground experience.
Yeah. Okay, thanks,
Thank you, Senator Duniam. Senator Hanson-Young.
Thank you. Thanks, Mr Black and colleagues for being here, and Ms Gareth. I'm keen to understand right from the beginning. I know your submission goes through a number of areas you'd like to see, from your perspective, improvements. I get that. But as it is, would you be prepared to... is this package as it is a step forward for you from the status quo?
We think that the package is capable of delivering a step forward. We don't think that we're there yet. So that's why we've made the suggestions for amendments that we think are really important. If we were able to deliver those changes, we believe that there is a step forward both for the environment and for business. And ultimately, if we're unable to deliver those dual outcomes, then there's little point proceeding with this reform. It has to ultimately deliver those two outcomes.
We also believe it is a step forward and has potential to be a significant step forward. However, as per our submission, there are a few details we think are a little vague we would like more clarity on. But as a package.
But as a package, I mean, if you're forced to choose this or the status quo, you'd take this?
Yes.
Mr Black?
My position is that we need to see improvements on this package in order to deliver a net benefit over the status quo. But we think that those amendments are capable of being delivered. We think that the position that we're putting forward is a reasonable position. It's fair and it's balanced, and ultimately it would improve this package such that we can get the types of approvals that are required to deliver housing, infrastructure, critical minerals and so on.
And are the reports correct that suggest that the BCA would prefer that this package was passed through the Senate with the support of the coalition and the government?
So our position has always been that we think that of major reform of this nature, the best thing that can happen is that if you have bipartisan support from the two parties of government. And the reason why we say that is that we think it's important that it's that type of approach that delivers reform longevity. So if we can get it right in terms of the right sorts of amendments, that's the sort of outcome that we would seek to secure.
I mean, that's if you accept that you think the coalition could ever be in government again, but it feels less and less likely that that's the case. But anyway, that's my commentary.
Given the coalition, I'm free.
Senator Hanson-Young and Senator Duniam do not rise to this.
Mr. Black, your concerns seem to be primarily, if I'm correct, I mean, I know you've got other areas you'd like tightened up, but from my perspective, for what I'm hearing from you and what I've seen in terms of the public commentary from BCA and some of your members, is that this issue around the unacceptable impacts, and you've been talking to Senator Duniam about that. What is the definition you would like?
Well, we've suggested some proposals, but I think there is a level of clarity that we'd be looking to achieve at a high level. Andrew, did you wish to speak to that and provide a little bit more detail, if that's possible?
So I think the consideration that we're looking for is something that makes clear what the bar is that is being set in the legislation. And at the moment, as Brown has outlined, that clarity isn't there in the wording. So the best way forward would be to say, okay, there's a table there with 11 pages worth of proposals. Take that out and put in something that is singular and clear. And, you know, we'd look to be consulted on that, obviously, but that would make it far easier for business to understand, well, this is the clarity that the test is providing. At a bare minimum, though, there needs to be some changes to the wording in the table if it's to remain. And I think, you know, in the submission, I've discussed some of the issues that we see around why isn't there that clarity, because there's not a good differentiation between what is a significant impact, which is something that's going to be assessed by the Act, and what is an unacceptable impact. So if the intent is to provide that clarity, that isn't, you know, the table that is put in there.
Well, is what you're saying that the government's trying to have a bet each way? To give an indication that there's areas that are unacceptable for logging or unacceptable for mining or unacceptable for bulldozing, but don't actually want to give any clarity about where those areas are. Is that what you're saying?
So what we're saying is that we think that there is a way through this that involves a little bit more consultation with all affected stakeholders, and rather than having this confirmed in legislation from the outset, the better approach is to be clear with a broader but clear statement in the legislation, and then allow for consultation in terms of how this might operate in a standard. And just to give you an example of the kind of ambiguity that we're talking about, at the moment, a significant impact is capable of being assessed. Now, that doesn't mean it will be approved, but it's capable of being assessed. Under the bill, an unacceptable impact is defined as something that seriously impairs or is likely to seriously impair the viability of a listed threatened species, or, and then it goes on. But seriously impairs and significant, one might argue, are synonyms. And the consequence of that is that something that is accessible now would be potentially, we're not clear, but it may potentially be incapable of assessment under this bill.
But that's the point. We're trying to obviously update environment laws so that they protect more things, that they actually stop destruction in places where it is clearly unacceptable.
Senator, I understand where you're coming from, but I think the challenge is that it's not clear. So if there was a clear statement as to what is unacceptable, that would be very useful, and that would be consistent with what Professor Samuel has said. But at the moment, that ambiguity renders this issue entirely unclear. So we're saying adopt a different approach that delivers the clarity so that things that are genuinely unacceptable can't proceed.
Is there anywhere, any area or any species that the BCA is willing to accept is off limits?
This is the point that I'm coming to in terms of why we need clarity and consultation in relation to...
But is there anywhere that you think would be acceptable for being off limits? Can't bulldoze there, can't log there, can't mine there.
This is precisely the process that we're talking about as being necessary to involve experts and stakeholders so that you can get these types of experts' opinions.
But you still haven't answered the question, Mr Black.
No, I am answering the question.
No, you're saying you'd like more consultation. I'm asking you, does the BCA accept any areas, any animal, threatened wildlife that should be off limits for business?
Of course there would be. Of course there would be.
Places that are not protected now?
What we're saying is of course there would be and should be areas and species that are appropriately protected, but how you go about delivering those protections and how you go about defining those protections within this context of looking at what is unacceptable and what is not should be clear. And to your point, I mean, you're asking me, are we capable of articulating specifics? We would like to be able to see those types of specifics rather than have the ambiguity. And that's why it's important to have a standard.
Do you think that native forests that are the critical habitat for endangered species should be off limits?
I think, again, this goes to the process that should be undertaken with respect to consultation and engagement around what these look like.
That's a pretty basic question. There's critical habitat. The animal is threatened. It's endangered. It's their critical habitat. Should that habitat be able to be logged?
But I don't think it is a basic question. I think there are what we need to be able to do is look at the impacts on a project-by-project basis by reference to clarity around what is unacceptable and what is not. And what we're seeing at the moment is that there is not that clarity in the bill. And what we're saying is, let's afford a basis for us to deliver that clarity through a process with appropriate expert guidance.
Do you think that if the Threatened Species Committee came up with a list of areas where these are the animals that are the Australian wildlife that is on the endangered list, they need to be protected, otherwise they're going to go extinct, and they said this habitat is off limits, do you think the BCA would ever accept that?
Again, that is a hypothetical. We'd have to have a look at it and consider it properly and discuss it with our members. But
do you think critical koala habitat along the eastern seaboard should be off limits?
Of course there are going to be areas and species that we should be looking to protect. We're not taking issue with that in any way, shape or form. But we don't think it's for us to say this species is capable of being protected and this species isn't. We think that there should be a proper process guided by experts that delivers that result.
On the EPA, I heard you answering some questions to Senator Duniam about how you believe the powers should be limited, their role should be limited to monitoring and enforcement. Yes, is that a fair summary?
Monitoring, enforcement, assurance, compliance.
Yep.
Yes.
Okay. What is your view on having NOPSEMA given more decision-making power over approvals?
Well, our view with respect to this legislation is that the decision-making power should rest with the minister.
So NOPSEMA shouldn't be able to just run the process and give a tick for a project?
What we're talking about here, did you have some?
I was just going to say it's the issue of the NOPSEMA powers in the bill isn't one that we've greatly engaged our members on. We've been focused on the issues in the submission. So it's not something that we've taken a firm view around.
Can you see why I'm asking?
I can understand your question, yes, but I'm just, in all honesty...
That your position is, if I understand it, what you've just said to me, Mr Black, and perhaps clarify. I want to be clear here. Your principal position is that the minister should make the decision.
That's correct.
And we know that the EPA will be able to be delegated decision-making power.
Well, we see that under the bill as it's drafted, but our view would be that the better approach is for the minister to have the decision-making authority, but for him to take advice in that regard from the department.
Of course, the minister of the day often delegates their decisions to department officials anyway. Do you see a problem with that?
Well, the reason we see that we think that there is an advantage to having the department continue to undertake the assessment, and that is ultimately the department is directly responsible to the minister, first and foremost. But secondly, we think that the department is in a stronger position to undertake that balancing exercise that I mentioned before with respect to multiple different factors.
Because if the EPA shouldn't be able to make decisions and it should stay in the hands of the minister, I struggle to see how, on principle, you could accept NOPSEMA being able to make decisions out of the hands of the minister as well. So otherwise there seems to be, if the principle is the minister's in charge, then surely the minister's in charge.
That is the position that we've taken with respect to the EPA, and as Andrew has said, the broader point that you're making in terms of NOPSEMA is not one that we've consulted our members on.
If you would like to take that on notice, I'd be interested to see whether you have a different position on that or a consistent one. I mean, I'm not questioning the consistency. I'd just like to know if it is consistent.
I'm very happy to.
Does the industry group have anything to add on that?
No, we don't share the view of the separation of powers between department and national EPA. We believe that national EPA should have the approvals power as well, but ultimately the minister being responsible.
Yes, that if the minister doesn't want to defer those powers to the EPA, the minister can make that decision. Do you have a position on NOPSEMA being able to have decision-making powers?
No, we don't. Can I take that on notice as well, please?
Yes, please. Thank you. What about the unacceptable impacts? Are you as prickled by the unacceptable impacts definition in this Act?
No, we do think there could be a little bit more clarity, but perhaps we're not as exercised on that topic.
Senator Hanson, do you have one or two more questions?
I've got lots, excuse me, but happy to share the call.
Right.
Yep.
Okay, thank you. Senator Walker.
Thanks, Chair. I've just got some additional follow-on questions for you, Ms McGrath. In your view, do you think, well, the view of your organisation, do you believe these reforms are urgent? And if so, why?
Well, as I said in my opening statement, there is a lack of investment that is required, or a certainty to facilitate the investment that is required to put housing, emissions reduction and the like into the country. We think the current status quo is unacceptable and we want movement on a single national environmental approvals process.
Thank you. I know in some of your public commentary you've noted the proposed reforms would make it faster, simpler and cheaper to get a yes or a no or a fix this decision without compromising protection for the environment. Could you explain why a fast no or a fast yes is important?
Business needs confidence for investment. Sometimes those decisions, capital is quite mobile within the global economy. We need fast no's and fast yeses so we can make those decisions very quickly.
What are some of the practical improvements for your members that you see in the legislative package?
Primarily the single national touch for approvals. I've been at our group for a very long time. Never once has a member said to me, please make there different rules in every state and territory because that makes my business easier to run. We always want a single economic market and to be operating in that single economic market. And a single touch national approval process will give us that.
Could you give an example of how you think this would benefit a specific kind of project? Just an example for the committee.
Look, one doesn't come to mind, but I'll have to take that on notice.
Just my final question. Do you see
I can help you with that if you wish.
Yeah, sure.
I mean, if you were to take a housing project, at the moment, you would require a state approval, and in some instances, you'd require a federal approval under the EPBC. Of course, housing is so important. There's a national target of 1.2 million within the next now 4 years. We're presently short on it, but it's a good thing to have a target. If you are able to have a single touch, and I do stress we're not proposing that the powers, or rather the obligations, be lessened with respect to that single touch. The state should be accredited to undertake a federal assessment by reference to the federal standard that a federal assessment would use. But if you can do that on a single desk rather than doing that on 2 desks, that means you're getting more homes out of the ground faster.
Thank you. Just some further questions for Business Council. Following the Economic Reform Roundtable earlier this year, I note you welcomed the government's decision to fast-track reform to the EPBC Act. Why do you think that this reform is urgent?
So it's a very good question, and we did welcome, and we continue to welcome the decision to fast-track these reforms. What we've always said is that we want to get it right. So at the time, I think there was a discussion around these reforms proceeding before the middle of next year, and that was bringing it forward from whatever date it was, and I can't recall off the top of my head, I'm sorry, Senator, but there was a date that had been previously articulated before then, and we said, well, it's a great thing if we can get these reforms done and dusted by the middle of next year. We continue to be of the view that that is an appropriate bookend. If we can get the reforms right with the right amendments and we can move earlier, that is a good thing. But we do stress our priority is getting it right and then using that, we would say, middle of next year as a bookend for making sure that we deliver the reforms within that timeframe.
Thank you. I know you've already touched on it already, but would you mind explaining, in your view, some of the key improvements for industry with the current package?
Yes, certainly. So the key things, and I should stress, the positions that we've put forward in our submission, I appreciate from time to time there will be differences between industry associations, but the positions that we've put forward in our submissions are supported by 25 other industry associations, and that includes the Australian Energy Producers, the Australian Chamber of Commerce and Industry, Energy Networks Australia, the Australian Energy Council, the Australian Investment Council, Master Builders Australia, the Australian Retailers, the Property Council, the Farmers Federation, the Minerals Council. So we think that there is a level of consistency across industry as to what the key concerns are. We do see that if we can get these reforms right, there are some real benefits that accrue, of course, for the environment, but we also see that if we're able to deliver particularly that single touch, then that will make a significant difference. And I think the critical thing to note there is that we are in a competitive global environment right now in order to try and secure investment. And Australia has a productivity problem. In the last 12 months, our productivity increased by only 0.1%. We need our productivity to improve in order to raise our living standards. As Ken Henry noted, these are some of the most impactful reforms you can make in order to deliver improvements to Australia's productivity and to drive living standards. So from our perspective, if we can do that by fast-tracking processes, by having that single touch point, then that is a significant difference for Australia.
Your organisation has been particularly supportive of accrediting state governments, which was a recommendation of the Samuel Review. Could you tell us why, in your view, you think that's important?
It just goes to that point that I was making before. We're not seeking to have a diminution in the obligations that states would have in undertaking assessments. Indeed, they would be applying the same requirements to the same standards that you'd expect at a federal level. But if you can deliver that single touch point, so a single desk making the consideration, that reduces the overall time associated with assessments. I mentioned before that there are other countries that are taking these types of approaches. In the United States, they have a process called the Fast 41 process, which fast-tracks certain types of investments. In Canada, the government there has just announced that a provincial, or their equivalent of a state, approval is sufficient for federal purposes. So in other words, there is no further federal process. It's that type of competitiveness that we're up against. And for Australia to be competitive, we need to be making sure that our processes are efficient as possible.
Thank you. The core of the Samuel review was about measures that deliver improvements for business and the environment. Is strengthening environmental protection something you also see as an imperative for business?
Yes, it is, and our members see that as being fundamentally important. That's why we think that it is so critical that we get it right and we deliver a net benefit for the environment and a net benefit for business. It's not just a single aim here at play, it's two objectives, and we're confident that with the right type of reforms we can do that.
Did you have a contribution? No. Okay. Thank you, Chair.
Thank you very much. Senator Thorpe, I'll come to you now.
Thank you, Chair, and we love the Dorothy Dixes from the government side.
Senator Thorpe, to your questions, please. I've pulled other people up on this committee already today for the editorialising, so questions to the witnesses.
Don't you love it? Thank you, Chair. Mr Black, in your public statements, the Business Council says that respecting First Nations peoples and embedding our perspectives is central to responsible business. Yet your submissions to this inquiry and other reviews like the Native Title Review consistently push for faster approvals, reduced consultation and limits on who can challenge environmentally harmful decisions. Mr Black, will you support a legally enforceable First Nations standard that embeds free, prior and informed consent?
Look, we're not proposing that we cut corners with any of the propositions that we've put forward. We're calling for a streamlining of the existing processes. Of course, there are changes that are coming through this series of reforms in this package, as suggested by Professor Samuel, but we're not calling for corners to be cut. We're saying that we want to see if we can streamline those processes, and that particularly goes to the point that I made before in relation to the single touch, single desk, and the importance that that would deliver, or the important outcomes that that would deliver for a business in terms of smoother approval processes. But we're not proposing to cut corners.
That's great to know. So in that case, is free, prior and informed consent something that you would support in law, or is that just a public statement to make us feel good?
Andrew, did you have any consultation that's been undertaken?
So, as I understand, Senator, the government is developing the standard, the national standard for engagement with Indigenous and First Nations people. We haven't seen that, so it's difficult for us to comment on what will be proposed. Obviously, when that is available, we'll engage with that process.
So coming back to my question, and let's be relevant here, if you could please answer whether you support, does the Business Council of this country, which operates on stolen land with stolen resources, do you support free, prior and informed consent to be embedded in law? Yes or no?
Well, I think my colleague has addressed that question. This is something that
I don't think so, with all due respect. I understand that there's a First Peoples or First Nations standard being developed. Putting that aside, my question is quite direct and quite simple. You state in your submissions that you respect First Peoples. So in that breath, do you support free, prior and informed consent, which is a human right in terms of the rights of Indigenous peoples around the world, which this country signed up to? My question is, with respect, do you support free, prior and informed consent being in law when it comes to protecting our water and our environment?
As I say, I think my colleague has addressed that, and we would have to consult with our members.
Okay. So you argue that stronger environmental protections will undermine investor confidence. Why does the BCA frame First Nations rights, environmental protection and community scrutiny as a threat to investment rather than a requirement for projects that are extracting stolen wealth on stolen land? Like, the resources belong to us, okay? And it was taken by force at gunpoint. And I know that, you know, people cash in on this, particularly the extraction companies, to only rape and pillage our land. So in terms of your version of efficiency, will you see us anything other than a threat to investment? Why can't we be seen as part of the solution and not the threat?
Well, I should say I think our members do see their engagement with Indigenous communities as being fundamental to the way in which they do business. It's something that they take great pride in, and I know that from the direct engagement that I've had, not just with the CEOs of our businesses, but also with the people that operate directly all across Australia, including in Indigenous communities. We take our commitment to engagement with Indigenous communities very seriously, and it is a source of great pride, not something that is just done in order to tick a box. I would stress we don't see stronger environmental protections as undermining business confidence. What we see is inferior systems with the existing EPBC Act as undermining confidence. And we know, for instance, that if you look at renewable energy projects as an example, there were 76 renewable energy projects that went into the EPBC system in calendar years 2023 and 2024 alone. Not a single one has come out. To our minds, what that shows is that it's a broken system. That's what undermines confidence. If we can get it right, and yes, this process should involve engagement with and working directly with Indigenous communities right across the country. If we can get it right, then these are important reforms that should deliver outcomes for all Australians, and I would hope including Indigenous Australians.
Includes major companies with long histories of environmental and cultural destruction, often apologising after the fact. So we lost our sacred places and spaces, and irreversible harm to our future generations, not just for our future generations, but for all generations. So why should First Peoples trust the Business Council to act in the public interest when so many of your members have repeatedly prioritised corporate profit over protecting country, water and culture?
Our members know that our capacity to continue to hold social licence is dependent upon our ability to work with communities, and we endeavour to do that each and every day. We are looking for systems and processes in this bill that ultimately deliver, as I mentioned, not just a good outcome, a beneficial and improved outcome for business, but stronger protections for the environment and stronger and better outcomes for communities right across Australia. And we believe that that is an outcome that is capable of being delivered.
Senator Thorpe, I'll have to move the call on, so if you've got one more question.
Just got one.
Great, thank you.
Thanks, Chair. Mr Black, can you tell me what your interpretation of free, prior and informed consent is, and how you consult? What is your version of consultation?
Senator, if you don't mind, I'd take that question on notice and happy to come back to you.
Thank you very much.
Thank you, Senator Thorpe. Now to Senator Smith.
Thank you very much, Chair, and
just in advance, Senator Smith, sorry to interrupt you. 5 minutes. Thanks.
Okay. Thank you, Chair, or perhaps not. Thank you. Welcome to our witnesses. If I might just start with the Business Council of Australia, Mr. Black, there are 10 substantive recommendations in your submission. Can you provide us with some information about which ones of those have been accepted by the government and which ones have been rejected by the government and which ones might still be up for negotiation between yourself and the government?
I don't think at this stage I could provide that type of clarity on any of the recommendations. We are hopeful that all of those recommendations are capable of being supported by the government and also by the opposition.
Does the Business Council's support for the legislation require acceptance of all 10 of the substantive recommendations?
We regard all of these recommendations as being important. We're very happy to have conversations with the government and the opposition with respect to how these work in practice and what type of amendments these recommendations translate into, but these are all important recommendations.
What's the practical difference for the Business Council and the signatories to your letter what's the practical difference of passage of the bill next week in November and passage of the bill in the first sitting week of February?
Well, as I said a little earlier, our focus is very much on making sure that we get the amendments right. Now, from our perspective, if we were able to deliver the right amendments in the next few days, that'd be terrific, and we'd be happy to proceed early. But if we need additional time, and I mentioned before that I think it's appropriate that there is at least a bookend of the middle of next year, but if we need additional time to get it right, then we should take the time to get it right. This is important reform. It's groundbreaking reform if we can do it.
We shouldn't rush to failure is what you're saying, Mr Black.
I'm saying that we should take the time that we need to make sure we get the right amendments.
A question to the Australian Industry Group. Did I understand you correctly that you would be happy with the passage of this bill in its current form?
We do think, as per our submission, that there is still some clarity required in certain aspects. Overall, we are happy with many elements of the bill. We do think some of this clarity could potentially be removed from the legislation and put into the regulation.
That would create more risk though, wouldn't it?
Well, I think that it could, but it also could give us some flexibility as circumstances change. We want this to be a permanent body, and we think that there needs to be some flexibility as circumstances change.
So passage of the bill in its current form carries risks for members of the AIG?
Just as I've outlined, that some of the definitions in terms of what net gain is, we'd like some more clarity on that, and the clearly unacceptable impact, we'd like some clarity on that definition as well.
Just turning back to the conversation we had about statement of expectations, Mr Black, of course there's another element or another piece of the statement of expectations high, and that is the statement of intent. So government issues a statement of expectations to an agency. The agency then responds to that statement of expectations, responds to government with a statement of intent, i.e. how it intends to give effect to those expectations that the government has made of the agency. So is it your submission that the statement of expectations and the statement of intent provides for a much stronger governance model over the CEO and his or her administration of the agency?
I think that's correct, and that strikes us as a reasonably appropriate way of managing the types of obligations that you'd expect agency heads to comply with in these circumstances.
Well, statement of expectations and statement of intent are a very, 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 very common. I find it hard to recall a situation or an agency that doesn't have one. So they're very, very common across the Commonwealth public service, as you say, as a governance mechanism. So I'm curious to understand why it's not part of the governance model here. Is it an oversight or is it a...
No, I mean, I think what I would say there is that we, the key point for us is starting with a statement of expectations, But to your point, Senator, it would make sense that there is a response to that statement of expectations, and that would come by way of the statement of intent.
Correct. Yep. Just turning to the matter of greenhouse emissions, if I can. In your public letter, you state that the legislation should rely on existing reporting requirements rather than creating new ones. So in the creation of new ones, are you suggesting that the greenhouse emissions reporting requirements are in actual fact a duplication of existing reporting requirements?
So I think it depends on the nature of the business that you're talking about. So from our perspective with our membership, we are broadly comfortable with emissions disclosure because the great majority of our members are doing that in any case already. We are concerned by the prospect that emissions disclosure may be a matter that is taken into account for the purposes of assessment that is inconsistent with Graham Samuel's recommendation. And we think that there is some clarity that's required in the legislation in that regard. But we note that there are, across our alliance of industry associations, there are 26 of them in total. We've all got the same views in terms of those matters that are of importance to us. It's a consistent position across the board. And within that membership, there are industry associations that are concerned by the prospect of increased reporting obligations, and I can understand where they're coming from in that regard.
Thank you, Senator Smith.
Can you identify just one? If I could just finish this point, sure. Senator Gosh.
Yes, please.
Mr. Black, can you identify which of those industry subsets they are? Because of course, when we think about housing, there's no current requirement at the moment for Scope 2 emissions to be reported in the housing sector. So this legislation will put a reporting burden on housing at a time when we're trying to create to restore efficiency to housing construction.
Mr. Senator, I am aware that there are some housing industry associations that do take that view, yes.
But it's not correct, is it? I mean,
thank you very much, Senator Gosh.
Thank you, Senator Smith, and I'll go to Senator Hanson-Young for 5 minutes.
Well, let's be clear. This draft package that includes this disclosure is only so much so as those companies that match with the existing safeguard requirements. Isn't that true?
I don't think that is true in terms of the way the legislation's drafted, but I'll defer to my colleague in that regard.
No, look, my understanding, Senator, is that the legislation has provisions for the minister to set a threshold in terms of regulation, but that hasn't been made clear in terms of the actual level.
So the government hasn't spoken to you about this. You don't believe that it's in relation to the disclosure that's already done as a part of those companies caught by the safeguard mechanism. Is that what you're telling me? So you think a housing project gets caught, do you? 100,000 tonnes?
Well, we don't know. I think my colleague's position was that we don't know what that threshold is at the moment that's proposed under the new bill. So we have taken the view across our membership that we don't have a concern in relation to disclosure because our members are already doing it. But because of that ambiguity in that space with respect to this issue, our position, or we understand the position of other industry associations to be that they are of the view that there is a concern there.
Have you spoken to the government about this issue of the climate disclosures?
We have, and our position in that regard is that there needs to be clarity that the climate disclosures aren't a matter for assessment during the approvals process, and that is entirely consistent with the position that Professor Samuel put forward.
But the way these draft clauses are written makes it clear that these are not considered as part of the approval process.
That's not our position having regard to our reading of the legislation. There has been, of course, and we acknowledge that the minister's made statements of this in public, including at the National Press Club and including with respect to the introduction of the bill. But when you look at the wording of the bill itself, if I can use this expression, it's clear that it's not clear.
So you think disclosure, you think the requirement for disclosure means that disclosure can be factored in to the decisions that are being made either by a state government, an EPA or the minister?
We think that there is a lack of clarity in terms of the existing drafting of the bill as to how the disclosure of emissions would be used. And there is certainly the prospect, therefore, that it could be used for the purposes of assessment. And our position is that that should be, as per Graham Samuel's recommendations, specifically excluded from the legislation. But I do stress we have no... our membership, the BCA, is committed to achieving net zero, and in accordance with 2050. Our concern here, though, is that we think that there are other mechanisms that are best placed to ensure that we deliver on our ambitions in that regard, including the safeguard mechanism, capacity investment scheme and so forth.
So do you think is it that you don't believe disclosure should be in there at all, or you just don't think disclosure, you think disclosure could be in there but it shouldn't mean anything?
So our position is that certainly across our membership, we don't have any issues in terms of disclosure because we're already doing it. We do acknowledge that there are other sectors and other industries that are not doing it, and therefore there is the...
Sure, but you're here to speak on behalf of your members.
That's right, that's right.
And so the BCA does not have a problem with the disclosure, you just don't want anything to be done with the disclosure.
So our position is that we don't have a concern with respect to disclosure for those members that we have, of course, that are already undertaking this type of work. But I do stress we acknowledge that there would be the addition of red tape and a burden that would be placed on the shoulders of some businesses that don't already have that obligation.
Could I, just to wrap this bit up, how many of your members currently are required to make climate disclosures in accordance with the existing rules, the Australian Sustainability Reporting Standard?
I couldn't tell you off the top of my head. I'm sorry. I'd have to take that on notice.
Could you take that on notice? That would be helpful, seeing as
Certainly.
they're the ones that you're saying are fine with it because they already do it. I'm interested to know how many of them.
Of course.
Thank you.
Thank you, Deputy Chair. That concludes this panel session. Thank you to the BCA and the AI Group for being here today. Your evidence and your submissions are appreciated by the committee. You have taken, I think, some questions on notice, so if you could endeavour to provide answers as soon as possible to the Secretariat, that would be much appreciated.
Thank you, Senators.
Thank you. I now welcome representatives from the National Farmers Federation and the Australian Forest Products Association. All right. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. May I just seek an affirmation from those that yes? I see some nods and some yeses, so thank you. For the Hansard record, can you please state your full names and capacity in which you appear today? We'll go the National Farmers Federation first and then Australian Forest Products Association.
Warwick Ragg, General Manager, Natural Resource Management, National Farmers Federation.
Tanami Deed, Policy Officer, Natural Resource Management, National Farmers Federation.
Josephine Peterson, Sustainability Consultant to AgForce, Member of National Farmers Federation.
Diana Hallam, Chief Executive Officer of the Australian Forest Products Association.
Richard Hyatt, Deputy Chief Executive Officer of the Australian Forest Products Association.
Thank you very much. You would have heard me, I think, before talk about opening statements. If you have one that can be tabled, that would be our preference. Otherwise, as short as possible, and I say that respectfully. And then at the conclusion of your remarks, we'll go to questions.
Thank you, Chair. I have a quote. Brief one. Thank you for the opportunity. National Farmers Federation have been engaged in environmental law reform since the inception of the EPBC Act. We've been particularly concerned that the dual consent provisions that see lack of harmonisation of federal and state laws, which bedevil farmers who can be explicitly compliant with one jurisdiction and then subsequently offend another, usually the Commonwealth, is troublesome. Sensible reform that sees alignment, clarity and communication that can provide certainty will be a key outcome we will test the proposed new laws by. I'm joined by my colleagues from Australian Forest Products Association and AgForce Queensland, both members of NFF, who I understand may have some additional comments. Thank you.
Thank you very much. Queensland manages the largest area of agricultural land in Australia, and our producers are central to both food security and environmental stewardship. We support the intent of these reforms, but their success in Queensland will hinge on whether the final system is practical, proportionate and aligned with real land management conditions on the ground. And look forward to discussing this further with you today.
Thank you. Thanks. I have supplied a longer opening statement, but I will be very brief if that's all right. Australia's forest products sector values sustainable environmental management, and the opportunities to fight climate change while ensuring ongoing sustainability of our forest resources and provision of secure and long-term employment and essential products are immense, and this is only going to increase in the future. Ensuring we have the right environmental regulatory settings to protect biodiversity and grow Australia's forest industries is of paramount importance. It's been 5 years since Professor Samuel completed his review of the EPBC Act, and since then there's been a number of new scientific findings and federal court findings that have given some clarity to our intent in these EPBC reforms. Thanks.
Thank you. Senator Duniam.
Thanks, Chair. I've got some questions for AFPA, and I know Senator McDonald has some questions for the Farmers Federation. So I'll try and go through these as quickly as possible, knowing our time constraints. I just want to go to something that was talked about quite a bit last week, and that was the regional forestry agreements. I mean, how do they operate for the benefit of this committee as the comprehensive framework to govern the operations of native forestry in particular?
Thanks, Senator. Regional forest agreements are long-term Commonwealth state bilateral agreements for the conservation and sustainable management of Australia's native and plantation forests. The intention is they safeguard biodiversity, wilderness and other natural and cultural values. We would disagree that they are a loophole to the Environment Protection Biodiversity Conservation Act. And in fact, one only needs to look at the regional forest agreements to see that they reference the EPBC Act in one case 74 times, in another 64 times. And we very much appreciated that clarity also being provided by the Federal Court last year. So in response to a ruling, Justice Perry of the Federal Court confirmed that the regional forest agreements are not an EPBC loophole or regulatory void. And she stated, in other words, a regional forest agreement provides an alternate mechanism by which the objects of the EPBC Act can be achieved by way of this intergovernmental agreement, allocating responsibility to a state for regulation of environmental matters of Commonwealth concern within an agreed framework. It is therefore important to reiterate that entry into a regional forestry agreement does not result in a regulatory void with respect to any particular forestry region on matters of national environmental significance. And we're very, very pleased to have that clarity, because under RFAs we can demonstrate that there have been important biodiversity outcomes which have not been achieved under other settings, such as national parks, for example. So the intent of the regional forestry agreements was to provide a source of timber, but also to manage forests appropriately. And in the decades since they've commenced, that seems to have been borne out by the evidence.
So obviously that is the vehicle by which operations are approved and managed. How much native forestry occurs each year? How much harvesting of native timber occurs on an annual basis under these arrangements?
Thanks, Senator. So each year around 0.5% of native harvest is harvested, or around 65,000 hectares, and that can only 2.8 million hectares of the 131 million hectares of Australian forests are multiple-use native forests available for harvest. And in mainland Australia, every bit of forest that has been harvested previously in around a 40 to 80 year rotation, and the vast majority of this area that is harvested is by selective harvesting. I think over 70%, 90%. Sorry.
Okay, and so under the agreements, that which is harvested must be regenerated, is that correct? Can you just step us through?
Correct. By law, every tree harvested must be regenerated and replaced.
And that happens?
Absolutely, that happens. In the areas where regional forest agreements are active, the environmental protection, state environmental protection authorities monitor that and are very quick to act if they find breaches of regional forest agreements.
How long do those native species have to wait for the new tree to grow?
So, and just in terms of that, so there's often a claim made that we have deforestation in Australia, but if under the RFAs every tree that's harvested must be replanted, that assertion is therefore patently untrue.
Absolutely, Senator. I find it astounding how many definitions of deforestation exist. We like to use the one adhered to by the Australian Government and the United Nations, which is if trees are removed, not replaced, and that land converted to other use, that is deforestation. Fortunately, Australian forest products industry is not in the business of deforestation, not only in the native setting but also in the plantation setting. We replace every tree that is harvested with at least one. So I'm quite confident that even regardless of what method is used for harvesting, every single tree is spoken for and replaced, and that land returned to the basis on which it was originally harvested.
And so then, just in terms of continued operation, I mean, I think your organisation's made the point before about the importance of having access to that resource, and we've just talked through the sustainability of the sector under the existing protections. Just to the laws we're talking about here, with what is proposed, is the Forest Products Association satisfied that there is capacity to continue to meet those standards and for the industry to operate with certainty under what is proposed?
Absolutely. Yeah. We're a very heavily regulated industry. It is important not only for business but also for our social licence that we not only meet but also exceed the expectations. Whether that's environmental, whether that's economic, because of course we have a large number of regional and rural communities that rely on us. No, we are not afraid of adhering to the same standards which we have adhered to for decades. And I would note that reform of EPBC is very important for us, not only to give clarity to the operating environment we exist in, but we note that in Victoria, where a regional forest agreement has been removed, we are seeing increased imports of timber from places as far away as North America and South America, and from countries that have lesser environmental standards than we do. We'd also note that the removal of the RFA is impeding the ability for us to plant forests and maintain plantations. That's putting at risk jobs, and it's certainly undermining our capacity to provide the structural timber needs of the country going forward. So we're very happy to work with the government and the opposition on EPBC reform. That clarity is absolutely vital. We're proud of our industry and we will be proud to meet those standards going forward.
And just a final question, and if the RFAs and the provision they create for industry to operate the way they do aren't there moving forward, or if there is some interference with it, what will that mean for future supply of timber products from Australian forests?
Well, I fear that would put that at risk. I think the supply of timber would be put at risk. The likelihood, in fact, as we are seeing, the inability to harvest and utilise sustainably native timbers from Western Australia has resulted in imports from South America and Victoria imports from North America, undermining our sovereign capability, undermining regional economies and undermining our capacity to house Australians, meet the needs of the housing crisis. I would also say that there is an increasing body of evidence which shows that forests that are not sustainably managed are at increased risk of fire and at also increased risk of going from a carbon sink to a carbon source. So for all those reasons, a carefully, intelligently regulated, sustainable forest industry must continue.
Thanks, Chair.
Thank you, Senator Duniam. Senator McDonald.
Thank you very much, Chair. I'll just confirm you can hear me clearly.
Yes, we can. Thank you.
Terrific. Thank you. Good morning to those representatives. I will dive into some of the detail of the legislation, given the time restraints that we've got. I was really disappointed that I wasn't able to ask a number of these style of questions to the department, which I think would have provided some greater clarity around what the proposed legislation interpretations will be. But if I could turn to the AgForce representative specifically on the interaction of this legislation with the Nature Repair Market Act 2023, I want to ask you about how you see these changes to the EPBC interacting with farmers who are trying to do soil carbon projects, improve pasture, erosion control, those kind of on-farm activities, please.
Thank you very much for your question, Senator. I think that the current reform bill is very vague. There's a lot of standards that haven't been written yet. There's a bilateral agreement with state that hasn't been agreed to yet. We have Queensland systems. There are producers who have agreements for ACCUs and other responsibilities and are trying to do their best to improve emissions efficiency of agricultural production and adhere to other protocols and best management practices. So the vagueness of the bill and the reforms and the fact that agriculture does not have a confirmed seat in understanding how we can contribute to the protocols moving forward are both logical with the current operational realities and have the environmental outcomes that the government will see have operators nervous, I think is the word. When we think of I guess somebody who would like to have a diverse farm system, it is normal for there to potentially be rotational grazing, pasture lays, it goes to cropping, it goes to grazing, and there's a lot of regulations there that would potentially prevent some of those options that producers have around land management. And when we think of sort of the drought cycles that we have in many parts of the country, especially Queensland, the cropping realities of dryland cropping in Queensland are very different compared to high rainfall areas in southern Victoria. And so I think that federal legislation needs to have a really clear remit to be able to recognise the operational differences that we have. And that is also why we're here today, to ensure that National Farmers Federation and also the state farming organisations do have a better input and a more constructive relationship with government moving forward as this bill progresses.
Further to that, I'm wondering if you have any understanding of how this bill, the EPBC changes, will align with the government's Australia's agriculture and land emissions strategy. How will it recognise producers who lower emissions intensity as delivering environmental benefit and not an impact, and be captured by the lack of clarity around the unacceptable impacts definition?
Well, the definition is still undecided, and so part of our submission called for the definition of significant impacts and all the impact definitions to have a clear, non-restrictive engagement with agricultural sectors in terms of how they're defined, but also to ensure that we give producers the options to manage the current agricultural land in the best way possible. So Australia is an outlier when it comes to how land is perceived. When we think of Queensland conditions, trees can grow at a metre per year, and so after a very short period, somebody might be perceived as potentially removing those saplings and or trees, even though only 1 or 2 years has passed. And so I think that there's just a lot of vagueness. Our members are unsure of how the next steps will progress, but I'd be happy to pass over to Mr. Ragg from the National Farmers Federation, as I think that he also has a national perspective on the impacts as well.
Thanks, Josephine, and thank you, Senator. I think I'd just add to that, and this is really complex area, so which piece of legislation do you have to comply with? And there are several. I think I'd characterise it perhaps best this way. As we sit here today, agricultural land is under pressure from renewables, transmission lines, now critical minerals, carbon offsets, housing and others. We have an obligation, we have an expectation that we'll continue to produce food and fibre. That's dealt with in a range of policy documents and legislative arrangements within government. We need to make sure we're clear that we're not using this process to interfere with those other processes, to make sure that we can continue to produce that food and fibre, and we can continue to do it in a sustainable and resilient manner.
So further to that, the EPBC changes bills introduce open-ended fee mechanisms. I can't find any reference to small operator caps. Given the number of farmers that are small or singular family businesses, how do you think they will be able to interact with an understanding of what the potentially additional costs could be, and the new civil penalty formula? How do you see that interacting with, small farmers, family farmers, and food security?
It's disturbingly undefined. We were assured during the consultation process we undertook under the last government that there would be a stratified process put in place so that we could better understand that. We haven't seen that. And you're quite right, some of those fines are mind-bogglingly high, and whilst there's an underlying expectation or an implied expectation that we would see those proportionally applied, we remain concerned that that hasn't been articulated clearly enough, and I don't think it's even in the explanatory memoranda.
Representatives of AgForce started to talk about the concept of rapid growth of vegetation, but how do you see that working with the continuous land use sections of 43A and 43B of the EPBC Act? Again, I had hoped to ask the department questions about interpretation under the Reform Bill, but would you be able to provide what your insight is into, ordinary land management matters, rotational grazing, carrying capacity increases, sowing legumes for nitrogen, or routine channel clearing? How would all of those work under this new legislation?
I'll go to Josephine, but provided they remain protected in that they are existing in continuous use, then those activities should be able to continue to be undertaken. What we're concerned about is that it's adjusted within the legislation and it's not currently proposed to be, or that there are some regulatory or policy interpretations that undermine that certainty that the legislation currently provides us.
And it's that certainty that producers need moving forward with the bill legislation, the ramifications for potentially going against some of the regulations and legislation put forward. Operators are unsure in terms of what that will mean in future and or ensuring that it doesn't regressively change the way that their land is classified. So from a Queensland perspective, we have the PMAVs, or property maps of accessible vegetation. This is a system that has been in the ground for over 20 years, and it is a legal arrangement between the Queensland Government and producers that talks to their land use and ensures that the operator is really clear in regards to the classifications and what they can and can't do, and they can plan their business around this. Because I say again, there is no sustainability without financial sustainability, and producers really need that clarity to be able to plan ahead with all the aspects that Warwick has talked to, all the additional pressures. They need that security and clarity, and that is something that this process and the current contradicting state and federal aspects don't necessarily provide producers with.
Senator, could I just add to that one of the great challenges, should this legislation pass and in whatever form, is that the implementation of standards for matters of national environmental significance through bilaterals will necessitate a really detailed, comprehensive discussion between the Commonwealth and the states to make sure they're got right. So whatever legislation passes, if we can't get that right in the implementation phase, then we might as well have not started.
Senator McDonald, I'll need to share the call in a moment.
Thank you. Mr Ragg, can I just ask you then, I'm going to be sneaky and ask a two-part question. The first is, can you support the legislation in its current form? And then the second is, you've talked about in your submission bioregional planning as the #1 amendment. Could you speak to that, please?
Thank you, Senator. The bill needs improvement. It is, with the functionality of bilaterals and a sensible implementation of bioregional planning, it is more attractive than what we've currently got. We still need to see some additional tweaks. I think it's probably been a bit rushed and we need to get a few things right, a few definitional issues. In response to bioregional planning, whilst we support bioregional planning and we've said in our submission, we need to see an agricultural layer in there. We don't want to see an opportunity for those other sectors that I've described to just go, okay, there's ag land and we're going to go there. We need to protect the integrity, particularly of high production land. And the other thing that we've said is it's important that we think a common sense approach would be to not assess it by IBRA region, but to do it by NRM region, because they don't cross state boundaries, and IBRA regions do, some of them do. So the bilaterals become even more complex if you're trying to do it with IBRA regions that go across jurisdictions. So we need to understand in all of those circumstances what the significant impact is likely to be. Now, whilst there is some merit in a go or no-go zone proposal, it needs again to be got right in implementation and ensure that all factors, including social, economic and cultural, are taken into account, that it's not just an environmental assessment, because this is a complex state of play out in the real world that we need to really understand clearly and get right.
Thank you very much. Thank you, Senator McDonald. I'll now pass the call to Senator Hanson-Young.
Thank you. Mrs Hallam, you mentioned that we needed to keep native forest logging going to build houses. That's your actual position?
Our hardwood industry plays a vital part in contributing to Australia's housing.
So why is so many of our logs, trees that are logged in native forests, sent to the chip mill?
Well,
I mean, you can't have it both ways.
I think you'll find the vast majority of our wood chip industry actually is supplied by plantation hardwoods. And while there is a small portion of our...
Why is any of our native forest going into the chip mill if our hardwood is important for housing?
Yeah. So if I might add, when you harvest a tree and it goes to the mill, around 50 of that tree goes into sawn timber, and then you get the residues. Some goes into other factors, but it's the residues from the trees that you harvest that you use for timber that largely goes to the chip industry.
So what is the percentage of trees that are logged from native forests that are going to the chip mill?
We'll take that on notice.
Yeah, I bet you will.
It's a small. I'm confident it's a small
Well,
portion.
Let's be honest. How much of Australia's how much of what is used in housing right now is from plantation?
Hardwood plantations or softwood plantations?
Well, actually,
hardwood plantations.
You need both, don't you?
Hardwood plantations are unable to supply our housing needs. They are grown to only about 20 years of age, and they are produced predominantly for the chip market. We have yet to replicate the economic conditions that a native forest setting provides to ensure that those materials can go into houses. This is one of the fallacies of the industry.
What about the failure to recreate native forests that they are the homes of animals and our native species and our endangered species?
I'm very pleased you raised that, Senator. As I was having a conversation yesterday, and as the Australian Government Department of Climate Change, Energy, the Environment and Water makes clear, forestry operations are the least prevalent of 11 specified threat categories for forest-dwelling fauna and flora. We are not even in the top 10 of threats to biodiversity in our native forests.
Do you accept that there are some areas where you shouldn't be able to log?
We don't harvest huge areas. There's 131 million hectares of native forestry, and as my colleague Mr Height pointed out before, we are able to access only a minuscule amount of those each year.
And do you think that critical habitat for endangered species should be off limits for logging?
So if you look at the matters that cause extinction, the forestry doesn't even rate in the top 10.
Yeah, I'm asking, should critical habitat be allowed to be logged?
So there's 33 mammals that are known to be extinct in Australia, and the majority, all of them.
None have been attributable to...
That's not my question.
And all of them have been attributed to invasive animals.
That's not my question.
Well, if you look at the regional forest agreements, Senator, you'll see they specify that you cannot remove trees from an area where a threatened species has been identified or within 100 metres of it. So those protections already exist under our regional forest agreements.
So why is there logging in critical koala habitat or in habitat where there's endangered gliders or habitat where there's other endangered bird species?
Well, before logging operations or harvesting operations can commence, a survey has to be undertaken. Those animals have to be identified and those trees cannot be touched, similarly with trees that have the potential to develop a hollow. And fortunately, thanks to the New South Wales Government, we now know that koalas are at less risk in a sustainably managed harvested forest than they are in an adjacent national park.
Except if Senator Faruq is involved.
Very happy to provide that scientific evidence to you.
You seriously think that it's not harmful or damaging to koalas who are on the endangered list to cut down the trees that they live in? Is that what you're putting to us here?
Unfortunately, as the...
Sorry, before we get into it, Senator Hanson-Young's entitled to ask a question and the answer can be provided.
And as the CSIRO provided us with the other day, thank you to the National Koala Monitoring Program, koala numbers, since they were first declared threatened in 2012, koala numbers have doubled and native forestry harvesting operations have continued. So once again, confirming the evidence from the Australian Government that we are not a major risk to forest-dwelling flora and fauna.
I mean, I just think this is laughable. I do, and you can keep spinning as much as you like, but the argument that native forests, that is the home of critical habitat, endangered species, rich with biodiversity, you think should be able to continue to be logged, and I think you are so out of step with the expectations and opinion of the majority of Australians. Over and over again, Australians support protecting critical habitat where we have endangered species.
As do we, Senator. Please do not misrepresent my views. We also want to protect and are proud of the biodiversity contributions we make.
Senator Hanson, just allow the witness to answer.
I would also say, as the Australian Wildlife Conservancy has made clear, further to the science that I have just referred to, and I'm very happy to provide that on record, feral cats are the leading cause of decline of native mammals and the major threat to Australian wildlife. So with all due respect to Taylor Swift and cat owners, if we are serious about stopping this, it's not my industry that should be the target.
Of course, invasive species are a threat. But the idea that a bloke with a chainsaw is not a threat to an animal that lives in that tree is absolute rubbish.
We are not allowed to cut down that tree.
Rubbish.
We are not allowed to cut down that tree, Senator.
Absolute
Under the
rubbish.
regional forest agreements, we cannot cut down that tree.
How much taxpayer money? Could I?
Sorry, Senator Henderson as well.
Look, Senator Henderson, if you're anti-koala, that's your problem.
Okay, let's come back to me for a moment. Senator Henderson, Senator Hanson-Young had the call, and that's how we've gotten off track here. Let's get back on track to questions and answers. Senator Henderson. Senator Hanson-Young, you have the call. Please continue.
Thank you. The next time I see Senator Henderson calling out the coal miners who are destroying koala habitat, I'll take your comments seriously. But I will go now to continue my questions with the
having those further discussions with you.
Senator Hanson-Young, you have the call.
I'd like to know how much currently the forestry industry in Australia is receiving in taxpayer funds.
Well, I know that since the cessation of native forest harvesting in Victoria, the Victorian government is now having to subsidise active forest management and fire management to the tune of $72 million.
That wasn't the question I asked you, so let's not be too clever about this. Just answer the question.
Well, forest and land management is an expensive exercise, Senator.
I'm asking how much taxpayer money is spent on your forestry industry?
So do you mean public multi-use national?
I mean how much public money is spent subsidising the logging industry in Australia?
I'm not aware of any.
No.
So you're going to sit here and say that no taxpayer money, state or federal, goes to logging, propping up the logging industry in this country?
So the New South Wales Forestry Corp and other organisations like Vic Forests in Victoria carry out a lot of public good activities and manage invasive pests and manage the weeds and other things. And as we've stated, they
how much
often
money
do
you get?
A better job than the indicative amount for just for fire management.
I'm hearing a lot of words and not a lot of numbers.
Senator Hanson-Young,
indicative amount for fire management in Victoria when they closed down native forests was that we had to then, the Victorian government then had to provide $72 million annually to manage the fire activities that were previously being carried out by Vic Forests.
I still didn't hear a number.
Because I'm afraid we can't answer that. I'm not aware
How
of
much
any
taxpayer money is going to the logging industry?
I'm not aware of any taxpayer funding.
Well, you know that's not true because you have access to these programs, as you've just described. It subsidises your logging activities. How much money does the taxpayers spend propping up the logging industry?
I would argue that it subsidises that the logging industry subsidises the management of public native forests, and we saw with
you don't get any. So
with the closure.
They are refusing to answer the question, and I'm going to hold them in contempt of the Senate if they don't.
Senator Hanson-Young, I've been listening. Senator Henderson, I don't hold for a moment. I've been listening very carefully to both the questions and the answers. I think that they are endeavouring to answer your question.
Well, I haven't heard a figure yet.
Well, but I think they have given an answer to the question about how much support they get, and they're describing
as an industry
potentially the reverse in terms of management investments.
Yes, and I've asked about subsidies, and they're saying that they use the money for these other things. Well, I'm asking how much public money is spent on the logging industry.
Yes, I think I would say that the returns that...
It's not the question
for example,
I've asked
the Forest Corporation, New South Wales Forest Corporation makes, subsidises the management for public use of those lands.
Why are you incapable
and
of being upfront with the Australian people about how much of their money is spent propping up the logging industry in this country? You're embarrassed about it. You are embarrassed about it.
Well, Senator, if you'd like to give me the answer you might have, I'd be happy to take that away and
Well, we know that
test it.
tens of millions of dollars go out of the coffers of both state and federal governments to your industry.
Via what program?
Well, via numerous programs, because you've just mentioned all the things that you're paid to do.
No, the returns that forest corporations earn from the timber they harvest is invested in the public goods.
You're saying you get no, you never have your hand out for public money.
Not to my knowledge.
This is
not the state
reports after reports. State and federal government budgets show lots of public money being spent propping up the industry. And if you ultimately you operate at a loss, don't you?
Not to my knowledge.
Compared to national parks, we're much more...
I'm not asking about compared to national parks.
I think we're far more efficient land managers than national parks.
I haven't asked that
services
question.
But I'm pretty sure Sustainable Timber Tasmania made a very small profit last year. But I'll have to check that. I'm happy to take that on notice and come back to you.
Do you get any receipts of government funding? Does the logging industry receive any receipts of government funding in the country?
The federal government supports the Support Plantation Establishment Program, but I would say that's about planting trees rather than harvesting them. No, I'm not aware of any taxpayer-funded programs.
What about how much money does the Tasmanian government spend on propping up the logging industry in Tasmania? Across programs, subsidising.
I'd be happy to take that on notice. I'm not aware of any.
At all?
I'm not aware of any, but I'm happy to take that on notice.
Senator Hanson-Young, I'm just conscious that Senator Pocock would like to ask some questions as well.
Senator Pocock, I don't think we're going to get the answers from these people because they don't want to be upfront about what is going on.
I think it is correct to observe that we've probably reached a natural end to the fruitfulness of this exchange. But if you have one more question, otherwise I'll go to Senator Pocock.
I will have other questions, so I'm happy to share the call.
Yes, we will need to also move on though. So
well, maybe.
Senator Pocock.
Thank you, Chair. Thank you for your time here. Mrs. Hallam, you said to Senator Duniam that we're importing timber from places that have lower regulations when it comes to forestry. And I was interested how much timber from native forest logging operations are FSC certified in Australia?
Oh, a considerable volume. Actually have both, either both FSC and PFC or PFC alone. It's very much
FSC.
It's very much client dependent. So some clients will insist on certifications from one company or another. I'm afraid I don't know the actual number, but I'm very happy to take that on notice.
Not from plantations, from native forest logging.
Yes, we've certainly got some in Tasmania that are FSC certified.
From native forests?
Yes.
Maybe on notice if you could provide a breakdown. Thank you. My understanding is that native forest logging is now really struggling to actually get certified, which kind of flies in the face of some of the evidence we're hearing. You also said in response, I'm not sure if it was to Senator Duniam or Senator Hanson-Young, and talked about native forest logging being important for things like housing. And was looking at ABARES data from 2023, which says that 90% of all native forests goes to pulp and chips. And so just interested is ABARES wrong or are you...
Sorry, Senator. Our information from I'm not sure which ABARES report you're reading, is that 60% of the total value of native forestry can be attributed to saw logs, including veneer and ply logs.
Value or volume?
Value.
See, it's a very different thing. 90% of the volume is going to a very low-cost, high-output, pulping and chipping. And sure, a smaller percentage, 10%, actually is the value. So I'm just interested, why is 90% of our native forests being chipped and pulped
So that's, from my information, that is incorrect, but I will see what I can provide on notice. But as I explained previously, a lot of the chip comes from the saw lugs as a residue, because around 50% of that or 60% of that log, depending on what type of processing, whether it's veneer or engineered timber or sawn logs, the leftover residue makes up the vast majority of our chips exports.
Sure. I mean, I'm just going off ABARES data, so if you can maybe just take that unnoticed. I noted you also said that unmanaged forests are more flammable. I note there's over a dozen studies now showing that logged forests are actually more flammable. And so I'm just interested, are these scientists wrong?
Yes, I'm afraid empirical fire severity analysis does not support this claim.
Sorry, empirical...
Yes. Empirical fire severity analysis does not support this claim.
Who did that research?
Well, Professor David Bowman, reviewing the Australia 2019-20 eucalyptus forest fires, said that they are not the legacy of forest management. 3 major government inquiries into bushfires have not established any link between timber harvesting and risk. Dr. John Raisin, former CSO research scientist, has totally debunked Professor Lindenmeyer's research into fire and native forest harvesting. And we now have insurance products that are available on the market that will give you a lower premium if you are operating in a managed forest than if you are operating in an unmanaged forest.
Okay, well, if
So
on notice,
not only is the forest, not
on
only
notice,
is the fire,
if you can provide you evidence that debunks the over a dozen studies.
Very happy to.
Thank you. In New South Wales and Tasmania, native forest logging proceeds without federal environmental approvals or any effective oversight. And even when operations are driving species like the greater glider, the leadbeater's possum towards extinction. And I'm not interested in the objects of the EPBC Act, as you referred to earlier in an answer to a question, but I want to know if you accept that an exemption exists around federal approvals, monitoring and direct application of matters of national environmental significance.
I'm sorry, I'm still a bit stuck on the first part of your question, which I would reject. The regional forest agreements apply the federal environmental rules.
So you do not accept that there is actually an exemption around federal approvals, monitoring and direct application of matters of national environmental significance?
Well, under the bilateral agreements, the federal government reviews the regional forest agreements every 5 years, and that does occur. They're independent reviews. And I can just go back to the federal court finding, which said entry into an RFA does not result in a regulatory void with respect to matters of national environmental significance.
And so what federal assessments are there?
Well, there's the review of RFAs.
That's every 5 years.
That's right.
Yeah.
And they will then look at, well, the state government will provide the evidence. We also have environmental protection authorities that monitor that harvesting as it occurs. And the Commonwealth will also review those actions, or consider those actions rather not reviews, consider.
And as already stated, we're very happy that the environmental standards will be applied under the under the reforms, because we believe that the RFAs do implement the objects of the Act, and make sure that matters of environmental significance are considered and managed appropriately.
Sure. Okay. But if forestry wants to go and log an area, they don't actually need approvals under the EPBC Act.
Because that approval's being delegated to the states.
No, that's what I'm asking, yeah.
So when RFAs were established...
please, I don't want the history. I'm just asking. When you go into and say, I'm going to log this new coop, you don't actually need any federal approval to do that. You just do that under the current RFA.
Yes? So Senator, when they were established, 2.9 million hectares was put into extra was put into reserves to
I'm
meet
limited on time here. I don't need the history.
Sorry,
it's a pretty.
Yes,
I understand.
It's not approval by approval. It's not approval by approval.
That's all I'm asking.
It is delegated.
Yes.
To the states,
Okay.
and in the same way that a number of other operations are.
Thank you. So we've covered. There's no actual approval process when you go in and log. I understand what you've said earlier, but experts are unanimous that native forest logging has a devastating impact on threatened species like the greater glider and others. Why should we allow this exemption from EPBC, this carve-out, to continue?
Well, I would disagree that they are unanimous.
Please provide the evidence or notice.
I'll be very happy to supply you with the forest scientists we work with. That's no trouble at all. If you look at a regional forest agreement, it will say you cannot harvest in the presence of a threatened species as defined by the Commonwealth. So for that reason, if a tree has cultural heritage, environmental or biodiversity importance, it cannot be harvested by law. And if it is harvested, the harvester is prosecuted, and there's a prosecution underway in that respect. So,
well, we've seen, say, New South Wales Forestry prosecuted over a dozen times, and Graham Samuel on Friday told us that he hated the RFA exemption and described forestry corporations as criminal. We've seen former Liberal Environment Minister Robert Hill and Atticus Fleming note that the repeated convictions of New South Wales Forestry, including the judge's refusal to accept a low risk of reoffending in EPA versus Forestry Corporation New South Wales 2024, basically saying that you may have these objects in the RFA, but it's not happening. Do you disagree with Graham Samuel, the minister who actually created the RFA exemption, and Atticus Fleming?
I think interrogating some of those prosecutions provides some fascinating insights into what the offences are.
Maybe one or two, but over a dozen. Like these are rogue operators who clearly are just asking for forgiveness rather than permission. And I think that is the gist of why we actually need nature laws that include native forests.
Well, I would disagree that they are. I would disagree in many respects that they are simply seeking forgiveness. A recent prosecution, which was successful, was the result of a contractor not having an accurate map and a dozen trees being harvested outside the boundary, for which New South Wales Forest Corporation took responsibility, apologised and is remediating. We learn from the mistakes that are made, similar to traffic incidents. You don't close down the roads, you learn and you remediate and you make good. And that is exactly what a responsible land manager does. And I'd like to think that my members are responsible land managers.
Thank you. Just finally, do you accept that native forest logging is harming threatened species?
Well, I'd like to cite Dr Tyrone Benn of the University of Queensland, who observed the minor contribution of forestry as a threatening process for nationally listed threatened taxa in Australia. And it's consistent with other Australian studies that have highlighted invasive species, modified fire regimes, urban development, tourism and recreation as being far more important in threatening species.
But Mrs Hallam, that's like saying, don't worry about dementia because you're more likely to die from cancer. You do not accept that native forest logging is a threat to certain threatened species, mainly the forest-dwelling ones, you'd assume.
We are listed as number 11
across the country. This is a very big country. I'm asking.
This is the Department of Climate Change, Energy, the Environment and Water telling us in their modelling and reporting and research that we are number 11 in threats against forest-dwelling flora and fauna. Number 11.
Okay, so let's not worry about it then.
Thank you, Senator Pocock. I'm going to share the call with Senator Thorpe.
Thank you very much, Chair, and thank you for appearing today. Responsible land managers. Well, Aboriginal people don't manage the land. We've never managed the land. The land manages us. And if we don't care for the land, then there's no point in looking after future generations. So there's some learning to be had there after hearing some of those comments. Now, my question is, particularly for the Farmers Federation, we're also the oldest farmers on the planet for our own land. These bills rely heavily on consultation but do not require free, prior and informed consent from First Peoples whose country is being cleared or developed. And in your submission, you talk about the dual consent issues between state and federal assessments. But you're missing out on the most important element of approval, who must be giving consent and must be part of the process. So, given that we've never ceded our sovereignty to the lands and waters that you work and live on, do you support embedding free, prior and informed consent into environmental decision-making in a way that is legally enforceable?
Thank you, Senator. A couple of comments on that. So I think my first comment is that the enabling of free, prior and informed consent through UNDRIP is a pathway for free, prior and informed consent, but free, prior and informed consent is not only an artefact of UNDRIP. Free, prior and informed consent applies to a range of stakeholders, and we've got a range here and globally of small and medium farmers who are also entitled to free, prior and informed consent. So it's an issue that we all need to understand, and it goes to the dual consent issue where in many cases we don't fully understand the obligation or requirements of the EPBC Act because they're just simply poorly communicated, poorly mapped and poorly identified. The second thing I'd say is there is a range of opportunities evolving not only within this legislative framework but elsewhere to understand a pathway to First Nations engagement through an Indigenous engagement standard, which is under construction. And that's a pathway to adding that layer. The final thing I'd say is there is a whole range of tenure issues out there, and we deal with them every day through things like ILUAs, Indigenous Land Use Agreements, etc., all of which require engagement and consultation. So we're not accepting that there is no consultation. It happens on the ground through a range of processes, and you know that is what it is.
That is what it is. Wow. I'm just interested, and I understand free, prior and informed consent is a very important process to go through. The information has to be free. It has to be prior to destroying an environment or destroying something or giving permission to do something. Has to be informed and given time to understand the fors and the againsts, and then maybe you get consent or maybe you don't. Can you tell me, based on your response, what's the difference between the Farmers Federation free, prior and informed consent to the United Nations Declaration on the Rights of Indigenous Peoples free, prior and informed consent, and how your organisation follows the process of free, prior and informed consent for First Peoples of this land? Because I don't see the Farmers Federation or the farmers contained in the United Nations Declaration on the Rights of Indigenous Peoples. So can you give me your definition of the difference, or is it the same?
So,
in your view?
Senator, as I tried to articulate earlier, free, prior and informed consent is not only an artefact of UNDRIP, it's also an artefact of United Nations Forum on Forests and in other global engagement processes. So,
which others?
Well, I've just named one, United Nations Forum on Forests.
So that's the same as the UNDRIP?
It's free, prior and informed consent. Right. Free, prior and informed consent is not an artefact that's only confined to UNDRIP.
But I'm asking you, what is the difference between free, prior and informed consent for First Peoples of this land that you are on, and I hope you're paying the rent for being on stolen land, and the free, prior and informed consent that you're talking about for farmers? Can you tell me, do you understand that there's a difference, or do you think that they're the same?
I think each stakeholder, landowner, tenure holder, has a right to understand what's being imposed upon them, and I don't regard free, prior and informed consent as interpreted differently for any of them.
Okay, so landowner, not custodian. So you don't see a difference between a custodian and a landowner?
Well, the courts have continued to resolve those issues, and let's let the courts do that.
Wow, you got some cultural awareness training to do. I'll go to my next question. Across
and
the
Senator Thorpe,
country,
I'll have to move the
we're
call
seeing
after this as well,
powerful
so sorry to
examples.
interrupt you. So after this question, I'll move it on.
Sure.
Thank you.
Across the country, we're seeing powerful examples of landholders on stolen land and First Peoples working together to care for country through cultural fire, habitat protection and local agreement making. What role do you see the Farmers Federation, with their free, prior and informed consent, playing in supporting authentic, respectful engagement between farmers and traditional custodians, not just gammon consultation, but real partnership so that country is maintained and managed in a way that honours cultural authority, builds trust and improves the health of lands and waters for your generations too, sir?
So there's a number of examples of particularly large pastoral companies that are clearly and identifiably engaged in those artefacts that you've outlined. They are an employer, they are an engager, they are an embracer of Indigenous culture and are quite proud of it.
How are they embracing and proud?
They're working with them. They're working with them on country, as you've identified.
Can you give me an example?
Yes.
Of who?
The applications of savanna burning in the rangelands, the engagement of First Nations people within the business frameworks. There are shared business models out there. They exist with and without ILUAs, depending on the tenure and depending on how that arrangement is reached. Those negotiations are happening.
Thank you very much.
Just finally,
I'm sorry, Senator Thorpe, I do have to move us on. We're running very, very late. Are you able to...
A lot of people have had a lot more time than me, in all due respect.
No, that's
and I
true.
wanted to ask one more question.
Okay, one more question, Senator Thorpe.
Okay, thank you. My question is basically around habitat, and we heard about endangered species and logging. Now, if we look at the logging and the impacts that that's having on totems, now Aboriginal people cannot survive without totems. And like you hear the Greens calling it animals, and you hear a lot of white people talking about it as animals. Now, these are our totems that we rely on to survive as First Peoples in these lands. And I just want to know what your understanding of that aspect is, please.
Thank you very much, Senator. So we work very closely with a number of First Nations communities. The Dja Dja Wurrung in Victoria, and their concept of forest gardening has been incredibly instructful. We work closely with the Tiwi Islands and actually have a model of co-benefit with them. And then Wick Timbers in North Queensland is doing some fascinating work with native timbers. But I would say the most insightful element for me was travelling with New South Wales Forest Corporation into a coop on the mid-north coast recently, and I noticed an unusual symbol on a tree, which wasn't familiar to me, and they had gone through that coop prior to harvesting with First Nations representatives and identified which trees were not to be harvested, but where also there might be animals or flora of significance to the local community, and the harvesting regime was amended to reflect that. So it's not a case of hearing or asking and not doing. It's a case of active listening and respecting the instructions and insights we're given.
Thank you very much. Thanks, Chair.
Thank you, Senator Thorpe. I'm now going to Senator Hanson-Young for ideally 5 minutes, and then I think we're going to go to lunch a fraction early.
Thank you. Question to NFF. Do you across the changes in this proposal in relation to the water trigger?
No, I don't think I've read that deeply enough, Senator.
So under this new package put forward by the government, the water trigger would be effectively overruled in lieu of the state accreditation. I'm wondering, I know that number of farmers around the country have supported the introduction of the water trigger because of the impact, particularly that fracking and coal seam gas has had on agricultural land. If you're not aware of that, then I would like you to take that on notice, because that would be very helpful. But on principle, you're supportive of the water trigger, aren't you?
Yeah, Senator, I think given that I probably, out of the 1,400 pages, didn't read that bit so closely. In principle, we want to make sure we protect access and quality and reliability of aquifers, and if there are intrusions that harm that in any way, then we would be concerned about that, and I think we've been broadly consistent.
Yes, and the water trigger was brought in because farming communities were effectively being ignored in terms of the impact, right?
And I think it's been applied in a number of cases.
Yes. Okay. Well, could you take on notice? Could you have a look at that particular area? Because a number of other witnesses have raised with us that the removal or the exemption of the water trigger for state accredited processes may be leaving particularly prime agricultural land pretty vulnerable.
Thank you, and we would be very concerned if that was the case.
Thank you. In relation to land clearing, we heard last week from a number of our witnesses the very real concern of the impact that agriculture is having on land clearing, particularly in Queensland. I know it's also an issue in places like the Northern Territory. We've seen a number of cases where land has been cleared without approval and then kind of going around afterwards, begging for forgiveness afterwards. Are you worried that the current rules, as they are, it doesn't change anything under this package from the government, as the government's put forward, but under the existing law, are you worried that there is confusion?
Yes. Yeah, so, and Josephine might like to add. So our opening comments were about clarity and the dual consent problem. So the examples that we're finding now is approved clearing by whatever mechanism, by a specific approval or by an exemption as occurs in Queensland under the PMAV process. Risks offending the EPBC Act because there's no communication between the approval authority, which is a state jurisdiction, and the impact or the intervention of matters of national environmental significance, endangered ecological communities, etc. And so what we're finding, which is very concerning, is you can get a permission, undertake an activity, and then find someone knocking on your door from the Commonwealth going, by the way, we think you've offended a potential or some other type of habitat there. That's a fundamental problem that we need to resolve by getting the clarity in removing the dual consent and enabling lawmakers to be clear with us as land operators how they can go about not offending those provisions but undertaking those ongoing agricultural practices. So it's remarkably grey, and I've been in this chair for 8 years, and I've been complaining about it for that long, but I've been in other chairs for longer, and it's just not been fixed. It was identified in a Hawke review that it needed to be resolved, and it's been identified by Samuel and Craig that it needs to be resolved. So we separate that from the land clearing discussion because land clearing isn't actually regulated as we sit here today by the EPBC Act. It's a state body. So it's how we can better understand the impact and requirement of the EPBC provisions as they evolve, and help protect our members from getting caught in that very difficult position.
Good, thank you.
And if I may add, land clearing is not always negative because it constitutes many things: strategic thinning, reducing fuel load, establishing fire breaks. These are all critical aspects that custodians of the land would need to do in best management practice, and there is the differentiation between those aspects, and that I think is something that is unclear for producers because sometimes the state may advocate one aspect for best land management practice and for them to do their duty against their neighbours and so forth, but then something federally might contradict that, and or it might get captured within a MINUS area, and so this is where the confusion is and where we need that active engagement with agriculture to ensure that it is streamlined moving forward.
Could I ask, and I'd be keen to know what the Forest Products Association is on this as well, so it's a question to both of you. Have you seen the draft standards that have been released?
Yes.
And do you support them as they are?
I have to be honest again and say I've seen them, I've skimmed them, but I don't have to resolve them until January, so they weren't high on my list. They look broadly okay, but as I articulated earlier, that's another layer. So there's this hierarchy of legislation, enabling standards, and then implementing bilaterals. It's how they are fit for purpose for the bilaterals, and we need to have those multilateral discussions. I think the high-level answer is they don't look terribly different to what we saw during the process last year.
Yeah. It's just, I've asked halfway through the question.
Oh,
so,
sorry.
Yeah, that's okay.
I'd supply a similar answer. We've circulated to our members standards and seeking feedback. We're happy to live with best practice, but we also need to confirm workability. So we're seeking that feedback. But yes, in the main, they do appear.
Yeah. Chair, I just have final question to the Forestry Association. Given our exchange on the, you're not able to give us any figures on how much public money has been spent propping up the forestry industry from state or federal. I'd like you to take away and take on notice how much money the industry has received for various programs, including capacity, capability, innovation, quote-unquote sustainable supply, how much is being used to help with transportation, access to roads and other transport facilities, whether there's any support in terms of the industry support chain, what type of state-owned operations have received substantial taxpayer grants, particularly, of course, in relation to native forests, both across the country, in the states, New South Wales in particular, of course, and Tasmania. How much money has been received from the federal government? I mean, my quick look at this comes to about $600 million. So you can dispute that if you like. That's it. Thanks, Chair.
Thank you very much, Deputy Chair. I have a 13-word question from Senator Pocock, and then we are going to break for lunch. Senator Pocock, very quickly.
Mrs Hallam, I just want to come back to threatened species. And I note that Vic Forest lawyers have said in several court cases, essentially, if they couldn't log threatened species habitat, then they were unviable and they would go broke. So I'm interested are they wrong? You said that you weren't a big threat to threatened species. Are Vic Forest wrong, or are you wrong?
I'm afraid I can't answer that. I'll have to take that on notice.
Maybe on notice. Thank you.
Thank you. Thank you to the witnesses from the National Farmers Federation and the Australian Forest Products Association. You have taken questions on notice, so if you could please provide those answers as soon as possible. We are grateful for your submissions and your appearance here today and in advance for those responses on notice. We're now going to break for 45 minutes and return at 2:05 with the EDO and Neela, and then we will work on, in the break, how to recover the program because we're running a little behind time. But thank you very much all. Representatives from the National Environmental Law Association by video conference and from the Environmental Defenders Office in person and by video conference. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. Yes, nodding at the table, nodding online as well. Thank you. For the Hansard record, will you please state your full names and the capacity in which you appear today? We'll go to the people in the room first and then those online, please.
Rachel Walmsley. I'm the Deputy Director of Policy and Law Reform at Environmental Defenders Office.
Revel Poynton, Managing Lawyer of Policy and Law Reform at the Environmental Defenders Office.
Thank you. And
hello, I'm Sarah Lone. I'm Special Counsel, Policy and Law Reform with the Environmental Defenders Office.
Thank you.
Thanks. If that's all of EDO, I'm Mark Beaufoy. I'm the President of the National Environmental Law Association, and I'm here in the room with
Sarah Brugler, and I'm a Director at the National Environmental Law Association.
And finally, I'm Justine Bell-James, and I'm appearing today in my capacity as a Director of the National Environmental Law Association as well.
Thank you very much. Look, I'll invite each of the EDO and Neela to make a short opening statement, but you would have potentially heard what I've said to the other witnesses already, which is the shorter we can keep this, the better to get to questioning, and we're running a little behind time as well, so I say thank you for accommodating the reshuffle in the timetable. And then after that, I'll ask committee members to ask questions, but if you've got a short opening statement.
We do have a brief opening statement. Based on EDO's analysis, these reforms need to do two things. Firstly, it must address, not exacerbate, the failings of the current Act. Unfortunately, the current bills as drafted risk making it worse. We have amendments to fix this. Second, it must strengthen the proposed amendments to ensure we have national laws that will actually deliver outcomes for nature, community, a safe climate and future generations. The EPBC Act needs clear red lines to protect our most threatened species and values, particularly through effective unacceptable impact safeguards. Otherwise, the Act cannot achieve its purpose and is just reduced to administrative paper pushing. Australia needs laws that ensure protection of our nationally significant environments and species, no matter who is in power. And it needs an independent EPA that has the strength to enforce those laws. The laws before Parliament currently contain significant risks which can be easily abused to the detriment of our threatened species, World Heritage Areas and other nationally significant values. We have simple amendments to fix this. And the Senate has the opportunity to make sure the laws passed are actually a step forward and not a step backwards for nature. Rachel?
I just wanted to add a very quick personal reflection. For a lot of us, we have sat around this table for many, many years talking about the EPBC Act and how it's failing nature. So here we are again, and as I see it, we have three options. This Parliament could fail to pass legislation and leave us with the failed EPBC Act for another 5 years, another 10 years, which takes us past 2030 targets. It gets closer to the extinction deadline for koalas. The second option, this Parliament could pass these bills as proposed, unamended, or even weakened at the behest as recommended by industry. So that risks this Parliament actually having the legacy of making a failed EPBC Act worse for nature. Both of those options are unthinkable. The only viable option is for this Parliament to draft amendments to strengthen these bills to protect nature and actually deliver outcomes for nature, climate and communities. We have really talented people in Parliamentary Council. We've got a list of amendments and solutions right here, so it has to be option 3. Thank you.
Thank you. Representatives from Neela, did you have a short opening statement?
Yes, thank you, Senator. Thank you, senators in the room and online. I will just make a brief opening remark about Neela and who we are so that everybody is clear about the role of our organisation. And then I'll hand over to Professor Justine Bell-James, who will touch on, in a brief way, our submission that we've provided. So NELA, the National Environmental Law Association, is the national peak body for advancing Australian environmental law. We were established in 1982. We seek to provide national leadership and a strong, balanced voice on environmental law and policy. To reflect our balanced approach, NELA's board is comprised of members of the legal profession and the environmental law sector more generally, including representatives from commercial law firms, universities, environmental NGOs and industry. We're not here representing any particular industry group or interest. We're interested in good environmental law and governance, and that's the basis of our submission. During this reform process, NELA has made other submissions and participated in consultation, including publishing a number of issues papers, which are referenced in our submission, which is submission 72 before the Senate. Overall, it's not our role to take positions on particular issues, rather than to ensure that environmental law works in practice. In summary, one of the ways I like to look at NELA's role is to ensure that environmental law and environmental law reform satisfies the objects clauses in environmental legislation, including the object clause in the EPBC Act. So I'll hand over to Professor Justine Bell-James to talk to our submission.
Thank you, Mark. The first point I'd like to make just briefly is subject to the comments that we will make about the bills before us. We do welcome some of the elements of the package, including the creation of a new national EPA and the EIA as well, the mechanism to create national environmental standards, amongst a few other things as well. But our submission is that many of the details of these matters need further refinement, and our organisation urges the government not to rush these bills and to take the time to listen to urgent expert feedback, to make sure that we get the drafting right, to make sure that we've got clarity in how these things will operate. So the key points in our submission that we've sent in and tabled before you is that the definition and the criteria for unacceptable impacts needs to be clearer. While we think that the concept of unacceptable impacts itself could be a good step forward for the legislation, the current statutory drafting leads to a lot of uncertainty. The national interest exemption needs to be narrow and based on clear objective criteria, again, to create that certainty. We do have some concerns generally about the extent of ministerial discretion and how it's framed within the operative clauses of the legislation, which could lead to uncertainty and further challenges to decision-making before the courts. And in relation to bioregional plans, we submit that there needs to be clearer criteria for making these plans and priority given to consistency with national environmental standards and the avoidance of unacceptable impacts. So I'll leave it there and pass back to you. Thank you, Senator.
Thank you very much. I'll now turn to Senator Hanson-Young.
Thank you, and thank you all for being here today. I want to get into some of the specific areas that you've identified as being problematic. And I listened carefully to what you all said in terms of being worried that if some of these things are not addressed, this is going to take us backwards, not forwards. I did put to the government directly that even the things that seem good in terms of a definition around unacceptable impacts is then undermined by the lack of enforcement. Could I go to that first? And I don't know who's best placed, whether it's the EDO or others, but I'm interested to know, is that an example where it looks good on paper, but it's just not going to stack up when it needs to be used?
Saren, would you like to start on that?
Yes, I can. Thank you. Thanks for the question, Senator. So, as I'm in agreement with Professor James Bell that the insertion of unacceptable impacts in the legislation is a good forward step. We need a mechanism like this in our legislation to make sure that we've got the safeguards needed to protect nature and our matters of national environment significance. We've made commitments to halt and reverse extinction, and we're not going to be able to do that unless we have a mechanism like this in the legislation. But as drafted, we've got a number of concerns with how this mechanism is going to apply in practice. Generally, we've got concerns around the significant discretion in the way the provision would be applied in operation. So language like to the minister's satisfaction or things like that, which is a feature of the drafting across the bill, and we can talk to that again later. That kind of language means that applying the definition of unacceptable impacts is quite discretionary, and we need something like this to be objective, based on clear evidence and science. In relation to the terminology and definitions in the actual drafting of the definition of unacceptable impacts, I think there's agreement between stakeholders that there's a lot of uncertainty there, and that's stakeholders like ourselves and also industry stakeholders. And one of the things we need to see through these reforms is more certainty for stakeholders. And so we need those definitions to be tightened up and much clearer for everybody involved. It will mean that there's an upfront signal to proponents about the types of impacts that just won't be acceptable, and an opportunity for a quick no there. And it will also mean that at the other end of the process we'll have that safeguard come up and allow decision makers to know that there are certain impacts that we just cannot approve. In terms of the definitions themselves, they need to really be based on science and what the science is telling us is unacceptable. And so I would direct you to some of the ecological experts that you've already heard from, such as the Biodiversity Council, in terms of what the definitions need to be. It really needs to be what the science is saying is unacceptable and not what just is palatable to industry. And lastly, there's, as you pointed out, there are exemptions in the Act that allow some of these safeguards to be undermined, and the national interest exemption is one of those exemptions that comes to mind. As drafted, it's quite broad, and it would mean that something like the unacceptable impact safeguard could be undermined when the minister decides to use that national interest exemption.
Could I ask?
Just to comment from Neela's perspective.
Yes, if it's brief.
Yes.
I've got lots of questions for you all, that's all. So, yeah.
I'm sure you do, Senator. We agree with the comments that have been made by Siren. I think the key issue for us is that unacceptable impacts is a great concept. The place that it's put throughout the legislation as a requirement to consider is also well thought out, but it's the definition of unacceptable impacts itself and how the science is applied. And that might be done, we think, by, for example, a similar mechanism like the significant impact guidelines. Now, that's not a statutory instrument, but it does provide significant guidance in relation to how significant impact is interpreted under the current EPBC Act, and something similar could be developed based on science for unacceptable impact, in addition to protection statements and approved conservation advice, which are statutory instruments under the Act or the proposed bill.
Okay,
Thank
you. Could I ask you to reflect on the requirements in relation to the emissions disclosure that is in the bill? Firstly, we had the Business Council in front of us this morning, and they were arguing that there are some of their members who think that this means the climate disclosures would have to be considered as part of the decision making. And I just want to be your lawyers. They're not. Could we get a response for what is actually in the bill and what is required?
Thank you, Senator. There is only a requirement to disclose the emissions for Scope 1 and 2 emissions above a certain unspecified as yet threshold. There is nothing in the bill at the moment that requires actual consideration of those emissions in the assessment and decision-making process.
And in fact, is it that it's just silent on that, or does it say it cannot or should not be considered?
To my knowledge, there's nothing in the bill that prevents its consideration. So it may be taken into account, but there's also nothing requiring its consideration.
Yeah. And that is only for certain projects anyway, isn't it? It's not for everybody. It's only at a certain level.
That's correct. It's just above a threshold that hasn't been specified yet.
Yeah. Okay. Could I ask you about the water trigger? Because I'm worried about how this is the new draft laws are going to work in relation to the water trigger. A note that we had the Farmers Federation up in front of us before lunch, and of course they've a lot of their communities and the stakeholders they represent strongly support the water trigger because it was one of the only ways to stop fracking and coal seam gas on prime agricultural land at some points. So could you explain the concerns you've got around the overriding of the water trigger that this bill allows?
So the bill would remove an exemption that currently exists in the EPBC Act that prevents devolution of the water trigger. And so that would mean that states and territories or potentially other entities would have the power to be sole assessors of regulation of water in Australia. Water obviously crosses borders. We live on the driest continent on Earth. There is a reason that the water trigger was made a trigger most recently, and particularly for large coal mines and unconventional gas, who are some of the largest water users in Australia, and they pose significant risks to both groundwater and surface water. The reason for making it a trigger is to give the federal government oversight and power to make sure water is regulated well in Australia. And so proposing to devolve those powers makes that step defunct. Mm-hmm. States and territories have shown around Australia that they are not able to hold the duty and responsibility of regulating our water resources sufficiently for us to have faith that they will protect our resources, particularly when it's such a national interest.
Mm-hmm. Mm-hmm. Does anyone else have anything to add on the water trigger? No? Okay.
No, Senator.
Thank you. What about what this bill as currently drafted does for new coal and gas projects or expansions? There's nothing that stops any new coal or gas, is there?
No, that's correct, Senator. In fact, there are pathways introduced by this bill or amended by this bill that potentially at the moment could be used to facilitate fast-tracking of coal and gas projects in Australia. Principally, the streamlined assessment pathway, which is a new pathway. It is weaker than any other pathway that exists currently in the EPBC Act. As it stands in the current drafting, you could be a large coal mine, a proponent for a large coal mine. You could prepare a 5,000-page environmental impact statement all by yourself, and you could give that to the Minister and say, Minister, I've provided you with sufficient information for you to now assess me as a streamlined assessment pathway. I don't need to go through the staged pathways set out in the other processes. I can have this 30 business day turnaround of a decision. The community would have 10 business days to provide some level of comment, which would, under the law, be restricted to whether it actually should be assessed or not under the EPBC Act, not specifically on the quality of information in the EIS, let alone getting it through such a massive document in 10 business days, and no other consultation would take place. Even in the weakest assessment pathway currently in the EPBC Act, which is by referral information, there is at least a limit on the kind of projects that can be assessed. So you have to a limit on the scale and risk and also the level of public concern that is involved in it. And there is consultation on the referral and then consultation on the recommendation report. And none of that is provided currently around streamlined assessments. And so we have significant concerns that there's need for easy amendments that could actually just ensure that the streamlined assessment pathway is appropriate given the very, very fast processing time that it allows.
So, I mean, that's extraordinary, 30 business days. Putting your application, the Minister can, 30 business days later, give it a tick of approval. that 10-day requirement for public consultation, that fits within the 30 days?
No, that's outside of it.
That's outside of that.
Yeah.
And so, and you're saying that 10 days is just about whether it should be able to be within the fast track, not actually about the. No, explain to me the restrictions around the 10 business day community consultation.
Sure, Senator. So any project that is referred under the EPBC Act for assessment has an initial step of being put out for consultation on whether it actually needs to be assessed under the EPBC Act. And so it's limited to just that question of is this going to have a significant impact on matters of national environmental significance or not?
Okay, so it's just that. It's not actually about whether it is then going to impact on a particular threatened species or whether the emissions, there'll be no public consultation on whether the disclosed emissions should be considered.
On my understanding of the legislation, the bill, you would need to have the greenhouse gas emissions disclosed in the application put towards the Minister, as the particular point of public consultation prior to the streamlined assessment pathway isn't relevant to the quality of the information in the EIS or the documents put before them, though, including the greenhouse gas emissions.
Yeah. Thank you. What about the go zones and the no-go zones? Do you have any concerns about how they're going to be established, what the impact of those will be?
We do. I might throw to Saren on bioregional plans. Thank you, Senator.
Thank you, Senator. We do have concerns. The way the bill is drafted is we're going to have a new process for bioregional planning that's going to allow the Minister to make bioregional plans that will identify development zones and priority actions within the development zones, and also conservation zones and restricted actions within those zones. At the moment, there's no real requirement for the type of upfront assessment that's needed to inform those plans. So nothing about the type of information that needs to be before the Minister and what type of values need to be protected with the conservation zones, or what type of information is needed about what's appropriate for a development zone. There's just the ability to make these plans. And then the development zones, there's no restrictions on where they can be or what type of activities could be declared to be a priority action within those development zones. And on the other side, there's nothing that says what type of values we need to protect through the conservation zones. So conservation zones, or no-go zones, as you refer to them, are not necessarily going to protect all critical habitat or all Ramsar wetlands per se. It's going to be determined on a case-by-case basis per regional plan, and it's not going to be a mechanism to protect values holistically. The Minister will be able to say that there's certain actions that are restricted in those conservation zones, but it's not a blanket restriction on everything. It will only be what's prescribed. So again, they're not operating as a no-go zone like you might expect them to. And then there's also a power in the bill for the Minister to make exemptions to those restricted actions in conservation zones. So even if we're making conservation zones that don't necessarily protect all values and don't restrict all activities, there's still the ability for the Minister to make exemptions anyway. So we've got some suggestions about how that process could be tightened up as well to ensure that there's a proper upfront assessment of the values and the information we need to inform the plans, potentially putting restrictions on the type of activities that could be fast-tracked through the priority zones, and making sure that the conservation zones do the job they need to do to protect nature.
Thank you.
Would you like to add?
Yeah, if I could just add to that really quickly. So we also have concerns about the lack of clear criteria for the identification of these zones, and our submission would be that it should perhaps be redrafted to make the concept of unacceptable impacts much stronger within the provisions on bioregional planning, subject to the comments we've made, of course, about the drafting of unacceptable impacts itself. But that should be something that's really central to the identification of those conservation zones within the bioregional plans, making sure that development across the entirety of that bioregional planning zone is not going to have unacceptable impacts, and making sure conservation zones account for that. So that's our submission.
Thank you. Could I ask about the other exemptions that the exemptions that currently exist in the law. That's the exemption around the RFAs, the regional forest agreements, and the exemption for continuous use, which we know both of those have led to rampant deforestation and, of course, the logging of native forests. The government hasn't proposed to close those loopholes or remove those exemptions under the laws that they've put forward to date, have they?
There's nothing in the bills to reflect any higher protections for land clearing or RFAs, specifically around that continuous use as well.
Yeah. So when the minister says that RFAs, that the government is committed to having RFAs apply to the standards, what do you think he's talking about?
I might throw to Seren. Yeah.
That's a good question, Senator. I don't know what the minister's talking about. I've looked through the bill to see if there is a specific provision in there that says that the standards will apply to RFAs, and I cannot find one. I think we're all aware that the Samuel Review made that recommendation. The government committed to that, and I would also like to know how this bill delivers on that commitment.
Yeah. Have you seen the draft standards that the government released a couple of weeks ago? Yep. Have you got any comments to make on those? Because, you know, I feel like it's pretty unfair, frankly, for the Senate to be expected to sign off on a package as big as this, where the key rules by how the rest of the changes are going to be enforced sit outside the legislation, and yet we don't even have the final. These are just draft and not all of them. So I'm a bit frustrated about that. So I'd like to know what you do think of the standards that have been released in draft form.
Maybe, do you want me to, I might just start on commentary generally around standards, and I'll and then through to Seren. As we all know, standards were the centrepiece of Professor Samuel's recommendations. He makes that very clear. Like, this is the linchpin of how we're actually going to move forward with our environmental protections. Unfortunately, what we've seen in the bill is that the standards are subject to so much discretion, so many exemptions, that the clear enforceability that was so important when Professor Samuel was recommending these is not being provided for, even down to the fact that the minister is not required to even make standards. It's just a power to do so. And the standards don't all have to apply to all decisions. A regulation will prescribe which standards are chosen for which decisions later down the track. And so much depends on the strength also of the wording in the standards. And EDO, on reviewing the standards, is of the clear view that the standards do not meet the standards specifically set forward by Professor Samuel. And when we compare the draft MNES standard that Professor Samuel kindly enough provided in the report, the standard that has been put forward for MNES by the government is full of discretionary language around, if possible, where necessary, have regard to, where Professor Samuel's example provides clear, unqualified requirements that actually would be more enforceable. But I'll throw to Seren.
Thanks, Revel. I think that's right. The granularity that we're seeing in the standards that have come out for consultation now are not to the same level as Professor Samuel had recommended. And the other thing where they fall short is in terms of the ability to able to measure and report on those standards and whether the outcomes set in the standards are being achieved. And that was another integral part of Professor Samuel's recommendation, is we need to put these standards in place, and then we need to have a framework to make sure that we can measure and report on whether those standards are delivering the outcomes intended. And that framework doesn't appear to be there either.
Could I ask a question? Yep, no, go ahead.
Sorry, Senator.
Go ahead.
Just from Neela's perspective, we obviously consider that standards are a really important part of the framework. but it underlines why this shouldn't be rushed. There are submissions that can be made until the 30th of January, and Neela will certainly be making a submission, but it's an important part of the overall package. In considering the bill, I think those submissions on the bill and also on the standards should be considered.
And the only other point that I'd just quickly make is that even if the standards are drafted in a really robust way, the statutory language is that the minister must be satisfied that a decision is not inconsistent with them. So it still does leave the minister with quite an amount of discretion to make a decision that departs from the standards anyway.
Could I ask if the standards that were detailed in Professor Samuel's report, what I'm hearing from you is they are superior to what the government has released in draft form?
That's correct. They're clearer and would be more legally enforceable, as he recommended, is so important.
So do you think...
Professor Samuel also recommended other standards like the First Nations standard, the Community Consultation Standard, compliance... He had a suite of standards. So far we've only seen 2, but we'd also need the full suite of standards to meet Samuel.
And can you remind me, even though Samuel's suggested there needed to be those other standards, they weren't detailed in the same way as the national matters of national environmental significance were they?
I think it's just that MNES that has a draft, but we might throw to somebody online if they can clarify that.
Are you talking about the drafts that are out for exposure?
No, I'm talking about the Samuel review. The Samuel review. I think that's right. I think it was just matters of national environmental significance. Do you think the government could just pick them up and put them adopt them instead?
That would be...
I'm sorry, if I could just interrupt really quickly. I've got the Samuel review before me, and there was a draft standard for Indigenous engagement and participation in decision-making. So that was in the Samuel review. Yeah.
Okay, thank you.
We think they'd be a good starting point. And as Professor Samuel said when he gave evidence, the granularity and the detail is important. And he stressed that the standards need to be outcomes-based. Instead of having all this focus on discretion and process, which the bill's repeating, the way to cut through that is to have outcomes-based standards that are really clearly, objectively applied by an independent decision-maker like an EPA. These are the elements of the bills that we need to strengthen to take us forward.
And he also used the language of consistency with the standards, whereas the language in the bills is must be satisfied, it's not inconsistent. So he didn't have that discretionary language in how he couched that obligation to be consistent with the standards.
So that was actually going to be my next question. So in terms of how the language in the bill needing to ensure that there is a strong link to the standards, you're arguing that it should be that it simply needs to say that the decision needs to be consistent with, as opposed to the minister is satisfied that it's not inconsistent. Is that correct?
Yeah, I mean, if we look at the... sorry, you go, Rebel.
No, you go, Justine.
I was just going to say, in terms of consistency with the Samuel review, that was the language that was used, that it must be consistent with. Him and his team spoke at length about discretion and the fact that discretion has led to trading off of environmental outcomes. That's the language that's used there. And so his approach was that decisions should be consistent with the standard unless there's some sort of rare exception that's justified in the national interest. So that's what the review said.
I know the chair wants me to hand over, so just... I'll ask one more, if I can. Could I understand from a legal perspective why that the difference between a phrase like the standards must be consistent versus what the government has drafted, what the minister has drafted in this package? Can I just understand... Can you help us understand why that is important? Like, what is your lawyers? You get it every day, but for those of us who are not, why is that important?
I might just start off that it's a positive requirement to be consistent with something. The Hawke Review also was very clear that the use of a negative of not being inconsistent is a weaker test than actually having a positive duty to be consistent with each of the standards. And I know there are court decisions also that have specifically clarified that it's a weaker test to be not inconsistent than actual compliance with a standards or or consistency. Does somebody else want to follow up online?
The other side of that is just the assessment of whether something is objectively complying with the standard is strong, as opposed to a minister being satisfied that something's not inconsistent. You get back to that ministerial satisfaction issue again, and I think Professor Samuel, again, in his evidence, described a conga line of lobbyists at the door. If you have so much discretion that for a minister, that is not fixing the problems of the Act. What we need to take us forward is objective decision-making, that a project or whatever's being accredited actually complies with a clear national standard.
Okay.
I'll just add really quickly, Neela has a draft position paper that we can provide at some point on statutory language and discretion in particular, where we go through case law before Australian courts on the language of consistent with, not inconsistent with, and also must be satisfied, and how that introduces a subjective element.
Yeah.
It's linked to our submission 72, Senator.
Yeah, thank you. Thanks, Chair.
Thank you, Deputy Chair. Senator Dunham.
Senator Smith has...
Senator Smith.
Thank you very much. My question just goes back to some evidence that Ms Poynton gave to Senator Hanson-Young. I just want to be clear about what your interpretation is in regards to how greenhouse gas emissions will be what's the right word? Will be assessed. Is it a compulsory? I thought you might have said in your evidence that they may be taken into account. So a discretionary consideration. Did I hear that correctly?
As with the current Act, on the drafting of the bill, if a decision maker was looking at the impacts of a project, they can consider the greenhouse gas emissions impacts on a matter of national environmental significance. It's not required in the Act currently or the bill.
In the Act currently or in the future bill?
In the bill that's before Parliament.
Right, okay. Thanks very much.
Thank you, Senator Smith. If I can just ask some questions in relation to the EDO submission, but I'm happy for Neela to jump in if you've got something to add relevantly. One of the thrusts of the EDO submission was a concern around devolution of federal responsibilities. And my understanding is that the current Act requires states and territories to apply federal environmental law or meet federal environmental standards when they undertake an assessment of a project, and that would stay the case under the new legislation. Is that your understanding as well?
I'm sorry, can you repeat your question?
Please, my understanding about the current Act, the EPBC Act as it currently stands, is that states and territories, when they're engaging in the approval process that they're empowered to undertake, need to comply with the Act, essentially. They need to comply with the federal law.
When a state or territory is putting forward a project, they need to comply with the law? Yes, that's correct, Senator.
And the legislation or the proposed amendments to the legislation, I think, still require that same compliance with the law as states go through the approval processes.
Yes.
Are you talking about under a bilateral agreement? Because at the moment there's not.
I think he's...
No,
it's if they're a proponent.
That's
correct?
right.
Yeah.
So I can understand your evidence as well in the submission I took it that you were supportive of a national EPA proposal, and can I understand what are the primary rationales for your support for that national EPA?
one of the areas where we see this legislation, if it was amended and strengthened, that could take us forward. So the strength of it having a national independent EPA is that they could make decisions based on strong national environmental standards, because as we've talked about already, one of the key flaws of the current Act is the level of ministerial discretion that's failed nature for the last 25 years. One of the key strengths of an EPA is that independent decision making that would be objective. Back to your point on devolution, we see a key role of a national regulator to set the standards, enforce the standards, and have a role in decision making. Our concern with devolution is we work right across Australia. We have offices in every state and territory. We see state laws and how they're implemented, how they're enforced. And our assessment is no state or territory law currently meets even the bare standards in the EPBC Act. So the whole rationale of the Samuel report was you set national standards. That lifts the standards for all states and territories. So before we even talk about accreditation, whether that's possible, there'd need to be a whole lot of law reform in states and territories. There's a really key role of the EPA first and foremost to set those standards, enforce those standards, and do the national enforcement side of things. I think I've lost my train of thought.
Well, can I jump in there if you have just for a moment and just say, so I noted the point you made on page 5 of your submission, and it's, I think, recommendation 1 in the executive summary, which was accreditation of assessment frameworks must only occur if strong standards are introduced and the frameworks meet these standards. As I understand what you've just said, if you have the standards to the requisite degree of rigour that we're referring to, and you have an independent EPA, then that's a system in which the accreditation that was proposed in the Samuel review could operate.
We do. I've got my train back. Okay. My train is... Yes, that's a critical role, but we think that the federal government should retain their responsibility as the final approval because of the international obligations that the federal government has signed up to. There are ways to create efficiency in the assessment process. You have national standards, so states and territories and proponents and the community know the clear rules. They know if something is an unacceptable impact. If something is a no-go zone, if something is a red light, there's certainty because the law makes that clear. That would be the benefit of new rules. But what we're saying is create that efficiency for the assessment stage, but the federal government needs to retain the final approval on these big, high-impacting projects. We don't support accreditation of approvals. At this stage, we've seen no evidence that bodies like NOPSEMA, that under RFA exemptions, that other bodies actually can do that final approval and maintain environmental standards. Then,
may I turn to another part of your submission, which related to, and it's page 6. It relates to a recommendation to remove the new power for the Minister and the CEO of the National Environment Protection Agency to make rulings as to how standards should be applied. In terms of, that's at 3C on that page, in terms of then who would be giving depth and meaning to those things, do you envisage that going to courts? Is that the primary mechanism of giving kind of interpretation to those standards?
Ideally, the standards themselves have enough specificity, as Professor Samuel recommended, in terms of the granularity, clarity. They would speak for themselves and wouldn't need interpretation. The standards go through a parliamentary process. They have to be tabled. They're scrutinised. Rulings are on the whim of the Minister or the CEO. In essence, yeah, they are kind of subverting the process that normally would be a legislative process, and also, as you mentioned, a judicial process of actually this is what Parliament has stated is the law. It's our job to interpret that. Really, the standards should be speaking for themselves.
There's an explanation of our concerns about rulings on page 26 and 27 of our submission.
Thank you.
In case you haven't got there yet.
No, I've got there.
There's a lot of detail. There's a lot of good ideas in there.
Thank you. And we obviously, as a committee, appreciate your submission. Can I go to Professor Bell-James, please, in relation to something that you said earlier around some of the positive aspects of this legislation and noting some of the reservations that have been made by both the EDO and NELA. Just to clarify, you see the creation and imposition of national environmental standards, the unacceptable impacts test and net gain requirements as improvements on the current legislation?
Yeah, so we spoke about the concept of national environmental standards itself as something that we welcome because of its consistency with the Samuel Review, and certainly the other things that you mentioned there as well as concepts are things that are consistent with the spirit of the Samuel Review. But as we noticed, there's details associated with that we think need to be ironed out for greater certainty. And Mark, did you have anything to add to that?
Yes, can I just add in relation to accreditation of state and territory systems and bilateral agreements that, if the system works theoretically, that states can show that they comply with national environmental standards and their systems won't lead to an unacceptable impact, then that accreditation process can work. And so I think Neela's position is, provided that that framework is put in place and the states demonstrate that their assessment and approval process will achieve that, then we don't have an overall objection to bilaterals and accreditation.
Thank you very much. I'll now pass the call to Senator Pocock.
Thank you very much, Chair. Thank you for your time this afternoon. I just wanted to start, I guess, broadly with the package of bills that we have before us in their current form. As a world leader in mammal extinctions, is this going to turn things around? What's your assessment of them as they're drafted?
Unfortunately, as drafted, we're not confident that they will address the serious environmental issues that Australia is facing and trying to halt. There are far too many exemptions and loopholes and discretion that could be easily abused at the political whims of whoever is in power, which too often is not in favour of strong environmental protection, unfortunately.
EJA, do you want to...
So, Neela, yeah, I think the discretion that really permeates a lot of the key parts of the bill makes it hard to have that certainty that it would stop extinctions and reverse the trend of biodiversity loss.
Okay, thank you. I'm keen to dig into a few of the details that concern me and get your thoughts. One of them is the proposed introduction of a power to make rules, under which the minister can effectively override or stand in the shoes of the judiciary and Parliament by making binding decisions on how the law should be applied by other decision makers. Could you explain this power and is it cause for concern or is it okay?
There are currently, Senator, no limits on the use of that power. There's no requirement that the rulings be in alignment with the objects of the Act, with the new standards, the unacceptable impacts tests and whatnot. And essentially, as I was saying earlier, they are replacing what actually just should occur in the standards. The standards themselves should be enforceable and clear and not require some other level of oversight that helps clarify their interpretation. That should happen through the standards. I don't know, Neela, did you want to add anything to that?
I don't think we've looked at rulings in sufficient detail, unless you had any comments, Justine.
Is there
nothing to add.
Is there precedent for this sort of thing? Like, is this something you see in laws and regulations? Or?
If you look at page 27 of our sub, we understand there's a similar kind of power given to the ATO under Taxation and Administration Act. So we do draw a comparison there, but even so, we are curious as to how that would work in this bill, and we see it as another way to circumvent standards and potentially undermine standards. So we've got a range of recommendations to strengthen and close these loopholes.
And what about in the context of environmental law? Would this be unprecedented?
In the current Act, there is actually a power to make statements. This is an extension of that power I'm not familiar with other environmental laws that have a similar power to what's in this bill, no.
Okay. Well, one of the other things that really stood out to me and I'm concerned about is the offset model put forward. I think particularly in light of the New South Wales experience and just how scathing the audit office has been of the model in New South Wales. I'm interested if you share concerns about that or what your thoughts are about the proposed offset model.
Thank you, Senator. We definitely share strong concerns around the offset framework. I'll throw to Seren to dive into that.
Thank you, Senator. That's correct. I have the benefit of being in New South Wales, and I sit on the New South Wales Biodiversity Offset Scheme Stakeholder Advisory Committee, so I'm quite familiar with that scheme. We do have concerns with the framework that's proposed in this bill. Our biggest concern is this idea about introducing restoration contribution payments. They're often referred to as payments for destruction. What this means is that a proponent can satisfy its offset obligations by simply paying money to the restoration contributions holder. And then they're free of their obligation and they can go off and do their project and destroy nature. What then happens with that money is really important. At the moment, there's nothing in the legislation that necessarily says that the restoration contributions holder has to apply the offsets standard. That might be the policy intent, but it's not in the legislation at the moment. And my understanding, having had a quick look at the offset standard that's out for public consultation at the moment, is that while it will set rules for offsetting, at the back end it describes how those rules will be applied to the restoration contribution holder, and there's quite a bit of flexibility. So if the restoration contribution holder can't find like-for-like offsets, for example, they're able to use that money in a different way. The concern also is that that money is paid into the fund and then it may be some time before the restoration contribution holder spends that money on an offset. The restoration contribution holder might not be able to find a suitable offset, and then it's left with this obligation that's unfulfilled. Meanwhile, the proponent has gone and already done its project and created the impact. And so there has been no upfront like-for-like offset in that case. In New South Wales, my understanding is this idea of paying into a fund was originally introduced while New South Wales was developing an offsets market to support that model. And as that market has become up and running, the Independent Pricing and Regulatory Tribunal in New South Wales has now recommended that the fund be discontinued in New South Wales, that it no longer has a purpose. It also recognises the concerns that paying into a fund has for being able to deliver those environmental outcomes. The New South Wales Government passed legislation at the end of last year to tighten up the way its offsets are used, including payment into the fund. And the idea that the Commonwealth Government is now seeing that as a model to use is alarming, given the lessons we've learned from New South Wales.
Senator, I might just pass to Ms Brugler, who can comment on from Neela's perspective.
Just to say that, I mean, we haven't reviewed the offset standard in detail, but Neela has completed a substantial amount of work on what offsets, when done well, could look like in a statutory form, and we've included that in our submission, a link to that paper. And I don't think that Act is there yet in establishing some of those core principles if offsets are going to be included.
Senator Pocock, can I just give you a minute warning, please?
Sure. And in terms of offsets, I guess when I've raised this as a concern with government, I've been told, well, New South Wales maybe just didn't look hard enough for offsets. And so I'm interested in, with the New South Wales failed scheme and the Commonwealth looking to replicate it, how far away from a good model is the current bill? What would actually need to change to this offset scheme for it to deliver? The argument aside whether or not you can actually offset critically endangered habitat.
So some of the things we've recommended, I would get rid of the restoration contribution holder. I just think that model is a backward step. We don't have it now at the federal level. Introducing it is a retrograde step. If it was to proceed, there are some safeguards that you could put in place to address those exact issues that you've mentioned about not being able to find things. So some of the things you could do is before an approval is given with conditions that would allow you to pay a charge, the minister needs to consult with the restoration contribution holder, and the restoration contribution holder has to, give its concurrence or, indicate that it agrees that it's likely that an offset could be found. You could also have a list of excluded entities. So these are species where we know that they're so scarce that it's very unlikely that, something will be found. And if you say up front, well, you can't set a condition allowing payment if you're on that excluded list, because we've got the science, we know that you won't be able to find the offset. And unless the restoration contribution holder guarantees to us that they're likely to be able to find something, then you cannot put a charge on. And then you could also put restrictions on the other end about the time frame in which the restoration contribution holder has to meet the obligations, and potentially even saying that the proponent, even though it's paid the money into the fund, it cannot start to create the impact until the restoration contribution holder has satisfied itself that there's an offset in place. So there's mechanisms or there's safeguards that you could put in place that are not currently in the legislation.
And just on the...
Thank you, Senator Pocock. I've got to share it with Senator Thorpe. We're running very behind at this point. If you've got questions that you can put on notice as a potential alternative.
When will we get them back?
I'm not sure it's as soon as possible, but...
what does that mean? I'm still waiting for questions from the department. Well,
the department... we haven't set a firm deadline, I think, for this committee, but I can follow up.
We've got till March next year, though.
Yeah, apparently.
Well, yes, that's when the senators put the outside date. Senator Thorpe.
The government's listed it on the program for next
Senator
Wednesday.
Thorpe. Senator Thorpe, you have the call.
Thank you, Chair. It's nice to let the little black girl have a say. Given it's our land and it's all stolen.
Senator Thorpe, please come.
Senator
Thorpe, please come to your questions. Senator Henderson, I understand the point you're making, but let's just move on.
Just on the point of order.
Sure.
Just a point of order, and just on indulgence. Senator Thorpe,
I'm not listening to you, so don't tell me.
Senator Thorpe,
sorry.
Thank you very much.
I will take a point of
stolen land too.
I will take a point of order.
Senator Thorpe, the point of order will come to me, and I'll make a ruling on it. Senator
Chair,
Henderson,
on the point of order,
through me, please. Yep.
I do think that was disrespectful to you as the chair, and so it was very denigrating.
Get off my land. You're on.
Senator
so
Thorpe,
I would
please,
just say that I just think that was disrespectful, and
Senator Henderson, I appreciate
and regrettable that Senator Thorpe felt the need to say something like that. You've always treated Senator Thorpe with a great deal of respect, and that was just unnecessary.
Got your pearls on?
Sorry, hold on. Senator Thorpe. Senator Henderson, I appreciate the point of order and I appreciate the comments. At this point, my focus is pragmatically on keeping on moving because we're behind schedule. So I understand the point you're making. I appreciate it. Senator Thorpe, you have the call for questions to the EDO and Neela.
Thank you, Chair, and there was no disrespect to you, Chair, intended. Thank you. My question is for the Environmental Defenders Office, and thank you for the work that you do. But I'm happy for both witnesses to provide answers. The government has not introduced a First Nations engagement and participation standard, and there is uncertainty over whether we'll see it before the bills pass. There's always an excuse why we're, packed on the end and an afterthought in this country. But last week EGA said that it's hard to understand how FPIC can be bolted onto a complex process once it is established. Can you please describe some of the issues that might arise from introducing a First Nations standard down the track once a whole new EPBC framework has been established and the risks this might pose to First Peoples' rights, shared decision-making and protections of country?
Certainly, Senator. Thank you for the question. In terms of the risks around this, as you mentioned, there isn't anything in the bill that actually requires development of a First Nations engagement standard. There are hooks for how it might be developed, but nothing that actually requires it be developed, nor obviously a time frame for development. And so it could be kicked down the road for who knows how long before it is actually put in place. Professor Samuel made it very clear that this should be urgently developed. He was very strong on the need for Australia to improve in terms of consultation with First Nations. And so it is unfortunate that we are at the point that we may see a bill passed and no clue as to when the First Nations engagement standard will actually come through. In terms of your question as to how it might impact the Act, I think it's a good one, where the Act currently has specific timeframes for consultation, processes for consultations in the law. As you know well, and far more than I do, free, prior and informed consent requires a clear process developed sufficient time within an assessment process to ensure that it is properly entrenched in the assessment process and respectful of the cultural necessities for First Nations to actively be involved and give their consent, if they give it, to a development that proposed. And so unless somehow it's tacked on prior to the legislative process actually commencing, I can't see how you would build free, prior and informed consent into the legislation or bill as drafted.
Thank you. Your submission states there appears to be little in the current bills that would meaningfully strengthen the role of First Peoples in environmental decision-making under the EPBC Act, let alone embed the principles of UNDRIP. Aside from the First Nations standard, what other changes do you think are required for First Peoples' rights, as set out in UNDRIP, to be meaningfully embedded within the Act and in environmental decision-making?
Thank you, Senator. As you know well, Australia has endorsed quite a while ago the United Nations Declaration on the Rights of Indigenous Peoples, and it includes many principles that are recognised and Australia has signed on to better entrench respect for recognition and rights for First Nations peoples to be in the decision-making process meaningfully for impacts to their country. And there are a plethora of changes that need to be made to our environment laws to actually entrench those principles correctly. I mean, we've spoken to free, prior and informed consent and actually needing to actually have the elongated assessment time frame that would allow timeliness, the time necessary for that to be properly entrenched. In terms of the other principles, I would have to probably take on notice each of them, how they might be able to be brought into the Act or our environment laws better, unless somebody else online would like to, or Rachel would like to speak to that in more detail.
No, from Neela's perspective, we don't have anything to add except that we'd like to see the National Environmental Standard for First Nations engagement as soon as possible.
And it's just another reason not to rush the bills is to get these things right, and that is something that Neela's Biodiversity Working Group is very keen to work on, is to provide some of those practical suggestions for how the Act can better incorporate First Nations rights and interests, and we do have lawyers working on who are involved in biodiversity and cultural rights protections who are really interested in offering up some of those solutions, but we need the time to be able to do that because they're not currently in there at the moment.
And if I can just also reiterate that Professor Samuel did recommend that a full suite of standards be adopted immediately, and the Indigenous engagement standard was one of them, so it wasn't something to be split up as per his recommendation.
Senator, I might also just add, we do see in the bill that there is more inclusion of necessity to bring in First Nations knowledge into scientific considerations, but there is no reference to a need to protect the intellectual property rights of First Nations, which is such an essential part of when working with First Nations knowledge, as you know well. So we would love to see that brought into the bill when bringing in more First Nations knowledge into decision making.
Thank you. They want our knowledge, but they won't give us any rights to protect. So, thank you. And I'll just ask one more question in the interest of time and being fair.
Thank you, Senator.
I want to ask about the RFAs. Noting EDO's position is for removing the RFA exemption, which is quite clear. But I want to ask about the government's position in applying national standards to RFAs, even though they haven't done this with the current bills as they are. So can you elaborate on what minimum limitations and safeguards are needed to stop RFAs from continuing as a legal black hole and ensure that there is integrity and proper protections in place?
Thank you, Senator. I'll throw to Seren.
Thank you. Thank you for that question, Senator. I think Professor Samuel realised that the EPA Act was failing and that in relation to RFAs, what he found was that the review considers that environmental considerations under the RFA Act are weaker than imposed elsewhere and don't align with the assessment of significant impacts for matters of national environmental significance under the Act. And he also found that there was insufficient Commonwealth oversight and assurance and reporting mechanisms. So what he's recommended is that we bring the RFAs in line with national environmental standards. So if we had strong national environmental standards, that could be one way to do it. But as you've heard from our evidence today, the draft that we've seen out for public consultation at the moment isn't as granular as what Samuel had recommended. And so there's still questions about whether, what the government is proposing for their standards would be enough to lift the RFAs up to and provide the protection that it would need. But let's say that was the starting point, what Samuel recommended. We would really need to see strong environmental standards, and we would need to see a mechanism that allows for the RFAs to be amended or updated or whatever it was to be in line with those standards. And then we would need a strong role for our new National Environment Protection Agency to monitor and report on whether the RFAs are meeting those standards and to be able to undertake strong compliance and enforcement to make sure that forestry operations on the ground were meeting those standards.
Yeah.
Thank you, Senator
Great,
Thorpe.
thank you very much.
I'd like to thank the witnesses for their submission and their evidence here today. If you have taken questions on notice, which you may have, if you could endeavour to provide answers to the Secretariat as soon as possible, and you go with the committee's thanks. I will now welcome representatives of the Urban Development Institute of Australia and the Housing Industry Association, in person and by video conference. And I just flagged with senators I'm going to try and catch us up a little bit in the next couple of sessions. So I'll be gently prompting it at various stages. Yeah. Yeah. Okay. Thank you very much. As you find seats and name tags, I'm just going to continue, which is I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to the witnesses. That's correct? Yes, I've seen nodding at the table. Correct. Thank you. And not online as well? Yes, thank you. I see nodding there too. You will have heard me say, and a couple of times now, we're running reasonably far behind. We appreciate your patience. If you could keep any opening statements you have as short as possible so we can get to questions, that would be very much appreciated. I'll go to the Urban Development Institute and then the Housing Industry Association.
Thank you very much.
Sorry, you've also got to say your names. Sorry, I've skipped a line. For the Hansard record, will you please state your full names and the capacity in which you appear today?
Andrew Mino, M-I-H-N-O, Head of Policy and Government Relations for the Urban Development Institute of Australia.
Lucy Shea, assisting with the legal technical drafting for UDIA.
Mitch Taylor, assisting with environmental approvals, UDIA.
Simon Croft, Chief Executive Industry and Policy at the Housing Industry Association.
Sam Heckel, I'm the Executive Director of Planning and Development at HIA.
Wonderful. Thank you very much. The Urban Development Institute.
Thank you very much, Senator and Chair. Urban Development Institute of Australia is actually one of the oldest and longest established peak bodies in Australia that delivers housing, both affordable and at market. Our members are one of the largest users of Environmental Protection and Biodiversity Conservation Act applications and assessments. Our members support the environmental protection bills with a handful of crucial amendments that will prevent drafting conflicts from undermining the core government objectives. We support ministerial delegation with direction by the Minister for approvals and assessments. And the reforms are actually a crucial balance between protecting the environment and delivering the homes needed during our housing crisis. The industry members need predictable, single, clear and efficient EPC assessment processes and decisions to ensure that we can actually deliver housing that we need. For the purposes of this inquiry, our submission really outlines the necessary changes to make sure that the acts do not conflict with each other and do not conflict with government's intentions. We have, however, identified 5 critical issues that are inadvertent drafting errors that should be improved. Drafting difficulties with the definitions and circular definitions are inadvertently creating or will create more confusion and subjective negotiations that will undermine faster or streamlined assessments and accreditation. Drafting conflicts on avoid, mitigate and offset is a little bit confused between the standard and the EPBC Act. And we'll derail assessments if we don't make sure that the standard is in alignment with the Act. Ineffective drafting of requests for information rules and no upfront document requirements also undermines streamlined assessments. And there appears to be that drafting leaves out any ability to hold NEPA accountable on non-performance of delegated powers and functions, even though the Minister maintains control of those. And lastly, we really need about a 12 to 18 month review of these complex rules once they're in place, because no matter how perfect these rules are, there will be inadvertent requirements that need to be changed. The crucial changes, I'll just very quickly, you can get around a lot of the problems by making sure, especially with the definitions and unacceptable impacts, by making sure there's a ministerial referral for proposals where NEPA thinks that there is an unacceptable impact. This takes pressure off the definitions and also make sure that we do balance economic, financial and social issues along with the environmental. Provide one simplified test for the definition of unacceptable impacts, because that will actually mean that you won't have this web and network of definitions, and remove blockers to accreditation, which is absolutely fundamental to us getting streamlining. And this also includes, obviously, standards and guidelines dealing with the application and definitions. Given the limited time, I'll cut this relatively short. The only other thing that we would probably say you do need is second and subsequent RFIs should actually be at the proponent's consent, with the option to escalate to the Minister or proceed without the proceed on the RFI. So this guarantees that any requests for information are actually going to be essential. And then, of course, making sure that there is a review for non-performance for the CEO in relation to delegated matters. I'll leave that there and leave it to questions for the rest.
Thank you. HIA.
Thank you, Chair. Thank you for the opportunity for the Housing Industry Association to provide a submission to this inquiry and appear today at this hearing. HIA is Australia's only national industry association representing the interests of the residential building industry. HIA represents a membership of over 60,000 across Australia. Our members are involved in delivering more than 170,000 new homes each year through the development of new housing estates, construction of detached homes, low and medium density housing developments, apartment buildings, and the renovations of Australia's 10 million existing homes. HA exists to service the businesses it represents and advocating policies on behalf of further advancing new home building and renovating, enabling members to provide appropriate housing to growing Australia's population. With respect to this inquiry, HA supports the key reforms of the Environment Protection and Biodiversity and Conservation Act as set out in the tabled bills. We review the reforms particularly around strategic assessments, bilateral agreements and landscape and regional plans as key measures to modernise and overhaul this important legislation to both improve environmental and project outcomes. It's widely acknowledged the current EPBC Act is outdated and requires a major reset. We stress that the Act as it stands is a major barrier to holistic environmental management and simultaneously stalls private investment and housing delivery. Put simply, the current EPBC Act is failing to deliver the positive outcomes for the environment, industry or the community. The current Act is complex and cumbersome. It results in duplication with state and territory and development approval processes. This adds cost and uncertainty to businesses, often with little benefit to the environment. Since 2000, the time required for project approvals has doubled. We have examples of members waiting since 2017 for projects to be approved. Right now, estimates suggest that between 26,000 and 40,000 new homes are stuck in the system. The national housing crisis demands that all obstacles are removed to fast-track the delivery of housing projects and supporting infrastructure. While HA supports the principles underpinning this bill, our submission details recommendations to improve the functionality of the Act, and I'll quickly summarise those key bits.
If they're in your submission, very quickly summarise them, if that's okay, sir. Sorry, I don't mean to be disrespectful.
No, that's fine. So in terms of the statutory timeframes, we must see a demonstrable improvement in assessment timeframes, and we support the new streamlined pathways and making the recently established housing strike team a permanent feature of the operations going forward. Clarity on definitions and offsets, which a number of people have talked about today, is vital, and what we are suggesting the need for templates, guidelines and worked examples to support the new standards and those new definitions. Prioritising strategic landscape approvals is something we strongly support. We also are recommending exempting housing from the emissions reporting or adding a clause where it already would be required by another piece of legislation rather than it being specifically for housing, because it is a lot of unknowns at that point in time. Also about transition arrangements, whereas where current projects are stuck waiting for approval, how that will apply with the new laws about trying to say how we can transform those projects across and not have to go and resubmit them. So lastly, we just wanted to say that the proposed EPBC Act and supporting insurance are not perfect, but they are a far cry improvement and sensible path forward to achieve improvements across the core principles as identified in the 2020 Summary Review. We therefore want to see progress with these passing of the laws with our suggested improvements and others improvements and address the legislative limbo this Act has been in since 2020. Thank you for giving HA the chance to contribute to this important conversation, and we welcome the opportunity to answer any questions today.
Thank you very much. Senator Henderson.
Thank you very much, Chair, and good afternoon to you all. Mr Croft, you've set out some pretty alarming statistics, including a massive backlog of houses. So 26,000 through to 40, what was the exact figure, sorry?
Yeah, 26,000 has been the general reported number, but there's some that say that could be closer to 40,000 projects.
Closer to 40,000, and you're talking about these bills being complex and cumbersome, giving rise to additional cost and uncertainty. How serious is this situation given the country's housing crisis?
Yeah, it is a critical part to it, of the puzzle, and as we go forward with the available land that we have for building going forward, more and more projects will be required to follow through the EPBC. So we do know that since the Economic Reform Roundtable that a housing strike team has been established, and they've cleared something of those 26 to 40,000. We understand between 4,600 of those projects, or up to 8,000, have been cleared just since August of this year. So we think that's a really substantial improvement. As I said, some of those projects have been stuck since all the way back from 2017. So we won't want that one to be, going forward, just a temporary measure. We think, given housing is very different to some of the other, forestry or mining or renewable projects, having that dedicated strike team is something that we're strongly advocating for.
So you're pushing for a number of amendments to these bills. Can you briefly outline why these amendments are so important?
Yeah, there is, as a number of submitters have talked about today, the definitions in the legislation are fairly subjective, and they do hinge very strongly on those determination of those definitions and how they'll be interpreted. Particularly going forward, it might be right for the drafters of the legislation right now to have an understanding of what they mean by those definitions. But what we want to see going forward is that it's well understood by all. So we're thinking there's some improvements for the definitions, but some case studies, worked examples that could really support it and underpin it would be critically important. We've also asked for a 2-year post-implementation review to ensure that the things like the bilateral agreements, which do rely on the states being accredited, if that doesn't actually happen within that period of time, then it does undermine the effectiveness of these reforms alongside those definitions. So that 2-year post-implementation assessment is something that we would strongly advocate for also. And they're the probably key ones for us. The embodied emissions piece, we just think that there's already a number of other pieces of legislation requiring that, either through ESG or safeguard mechanisms. There's already, at a project-by-project level, there's already requirements in New South Wales under their BASIC's energy efficiency scheme to require that. And they're all going down different pathways to do those assessments. So what we want to see is, particularly for a housing, a more effective point in time will actually when you build the home rather than when you're doing, the assessment for the land subdivision or land approvals.
So just going back to those definitions, one of them is unacceptable impacts, the definition of unacceptable impacts. Why is that so important to get right?
It hinges on so much of the other pieces that go from this one, also the net gain from the offset, so the unacceptable impacts, about how do you mitigate against that for the new subdivisions or approvals around this one, and then also about that net gain, for all the offsets perspective, that will be, we already see right now that quite often you can get 2 environmental consultants in this space coming up with 2 completely different interpretations of how that might look like. And, you have a lot of reports that are very expensive reports and they're, about those approvals. So we do need to have it really clear to ensure that we don't get stuck in that, conversation between which consultant's right on the determination of these assessments.
So how should the definition of unacceptable impacts and net gain, how should they be amended? Do you have suggested wording which gives greater clarity?
I might refer to my colleague Sam, who's also on the line. He might have a more specific tour who's been... Yep.
Yeah, thank you for the question, Senator. We don't have any specific wording that we've put forward. And I think the real challenge here from a policy perspective with the EPBC Act is that we're actually regulating such a diverse range of species and habitat area that capturing what is unacceptable to every protected matter in a single definition is quite complex and difficult. So beyond further words and terms, we at HIA recommend some worked examples and templates to actually support the understanding of the definitions and what they mean in practice at that land development stage. The department have previously tried to give similar level of guidance. For example, there's significant impact guidelines that are available on the website now to determine what is a worked what's considered a controlled action or not. So supporting guidelines is, I guess, not uncommon for complex legislation, and that's what we're looking for.
So just going back to the backlog, can you just explain, are these houses for new developments, gone greenfield sites?
Yes, they are.
And what is this costing the prospective buyer in terms of these delays, the reviews, the millions and millions of dollars that some are spending on report after report, demand after demand, barrier after barrier? What is this adding to the cost of housing? Have you got it done any sort of work in that regard?
Yeah, the HA commissioned the Centre for International Economics to look at regulatory impost costs and taxes associated to new development. We commissioned this report both in 2011 and then we did it again in 2019, and then again in 2025 this year. That report, which we talk about the taxes, can be up to 49% of a new house and land package in Sydney is made up in taxes, fees and regulatory imposts. The biggest change in the cost from our last report was about the timelines to get approvals and the uncertainty and the holding costs, and the timelines was the biggest increase. We're happy to provide that as post.
Could you provide that on notice?
Yep.
Do you know, in terms of the regulatory impacts, the cost of that 49%?
So
what's the breakdown?
So if you're looking at a new house and land package in Sydney of 1.3 million, 49% of that, which was equated to $576,000.
And of that, so some is taxes.
That's right.
What's the regulatory impact?
So I'd have
the holding costs.
Yeah,
and
the
all
holding
that.
costs. I wouldn't put the number down, but I can provide that on notice, Senator.
I mean, this is out of control.
We did quantify that as part of this one, and as I said, the longest timeline around this one for us was about approvals, was the difference between our previous report in 2019 to the 2025 report. I think probably the last one I'd just add to your
Can I just say, this
Yep.
situation is out of control with the cost of housing.
Absolutely.
For a new home and land package in Sydney to cost $1.3 million is just shocking.
Totally agree.
Completely shocking.
Yep.
So if you had streamlined approvals, which you were able to get through quickly, what difference would that make to the cost of a new house and land package?
It would make a significant both financial, but also not just that, because then it also actually result in greater supply of new housing, because not being held up around this one. So it's not that for rentals become less, more housing supplied within it's a quantum that goes with that.
Can you
one.
quantify that? What the difference would be?
We'd have to go back look at our report on that one to see how we on that one. So I'd have to have a look at that one.
We're looking at a substantial reduction in the cost of a home, though, if these approvals were streamlined and shortened, dramatically shortened.
Absolutely, and it's obviously it's not just related to the EPBC. It's individual planning approvals and also building codes and regulations. Then it's also the taxes itself on it. Just probably the last one I mentioned, Senator, was about the definitions. We think the strategic assessments provide a very strong way forward around this one. We've seen it in Melbourne, where they've actually implemented some of those strategic assessments where you previously had to go through project by project assessment, where they've set out, future housing future housing precincts and priority development areas, that has then resulted in a more holistic approach to both environmental management and also approvals, rather than going down individual case-by-case assessments, which we think the strategic assessments under the new bill would be a far cry improvement.
And we've seen some reports just in the last day or so about the terrible impact that the 5% discount, the government's 5% deposit scheme is having on housing. Have you got anything to add to that at all?
The only thing I'd add to that one, Senator, is that scheme has been around since 2020 and has supported over 240,000 first home buyers.
But now it's open to everyone.
Now,
it's no longer means tested.
I think the probably bit we would talk about with that one is, a lot of people talk about the 5% deposit. What we see is an important part of that one is waiving the need to have the lender's mortgage insurance, which adds another $30,000 potentially onto first home buyers, in addition to these other taxes and regulatory imposts around it. So I think that there's probably some of the discussion on the 5% deposit rather than on that lender's mortgage insurance, which has been an important consideration. Yep.
So just going back to your concerns about greenhouse gas emission reporting, what impost would that place on you unless that was amended? The bills were amended and that was deleted.
Yeah, so we probably haven't put a cost on it, but what we have talked about in this one, we just think for housing, it's not the right time to be doing that reporting to actually make a meaningful contribution to actually informing about it, where when we build a home, there's 5,000 products that go into a home. We think it's a far more important when you're talking about housing, when you're talking about the embodied emissions, to be looking at the delivery of the house itself, not to be reporting on what the subdivision might do from an emissions reporting perspective. So we think it's just probably for housing, it's the wrong point in the supply chain.
And just, look, I'm probably going to have to share the call around shortly, but the government has listed this legislation for next week. We're not due to report until March next year. We are really alarmed about what the government is trying to do. They're trying to crunch this through the Parliament. What would you say to that, given the state of the bills at the moment? Have you seen any proposed amendments? Have you had any advanced discussions with government on what amendments might come forward to these bills? I mean, how can this possibly be passed by this Parliament next week, as the government is attempting to do?
Yeah, we've been trying to be pragmatic about the conversations on this bill, given the long history and it's what the current, and our members trying to navigate the current bill has been, or current act and legislation. So we have been trying to be positive about, let's remove the stalemate that it's currently been in for the number of years here. We think that housing strike team is a really critical part for us to try and clear the backlog. If we were to get one thing out of it to make that permanent around it, would be one of the big things, and those strategic assessments and bilateral agreements were really critical for us.
Just quickly, I'm sorry, to the UDIA, if I could just ask your concerns about the bills in summary, and do you have the confidence that these bills could be passed next week, given the state that they are currently in?
I'll start and I'll provide to my experts on a couple of those issues. However, on the broader approach, we're fundamentally very pragmatic about this as an industry. What we're really looking for is to make sure that whatever protections are put in place are actually able to practically be done in an efficient time frame, so that we can actually build the 42,000 plus houses that are sitting fallow, right, and bring down the times, which are as high as 1 to 5 years. That is made harder by the timeframes that are being given, and we've all been talking about definitions, etc. The reality is we're talking about a vast and complex piece of legislation, and because it's vast and complex, what we have said is the more time you can give us to look at that and to make sure that the definitions work, the easier it's going to be for us to wholeheartedly support you in what we're doing. We are actually in favour of this Act. We are in favour of getting it done. We have put in place examples of pragmatic changes that are actually necessary to make it work. So if there is an opportunity to get more time, it can only improve the process.
If we could, on notice, have a copy of what you've put to the government in terms of amendments that you're seeking, and
you actually already have those.
Oh, we've got those in your. Are they in your submission?
They are in my submission.
Okay, so nothing additional.
There is
anything else that's not in your submission, if you could provide
Sure.
to this committee and also to the housing industry.
Yep.
Housing Industry Australia as well. We'd be grateful.
And to that point, the simple reality is we are regarding this as a live and working document, everything that we've sent to you. So we will actually update as necessary because we have people working on this all the time. What we've provided here is what we can get to you in the time we've been given. Obviously, and I'll talk to, I'll give it over to my colleagues, but in answer to your next question, which was, summarise the things that we want, the reality that some of these are very, very simple changes. One of them is, this is really all about making sure that the industry understands what the government and the department wants, so that we can give it to you up front and we can get through the process. So yes, we are in favour of the concept of, if it is completely unacceptable, then a quick no is a great idea, right? But the problem is in how that's actually implemented, because the definitions are creating a network of problems. So, that is why, we are saying, look, give us the documentation requirements up front. Simple, obvious. This is why we're also talking about the RFIs, right? Absolutely, you need to be able to ask any questions you need, but if you give us the opportunity to know exactly what you need up front, that'll minimise that. And if you have a second or third RFI, then there should be the opportunity for us to be able to get the proponent's consent on that, or otherwise escalate it to the Minister to make sure that the RFI is actually required and necessary.
Okay, I'm going to have to be...
No, that's fine.
Yeah, no, I'll probably have to chat and move the call around.
All right, that's fine.
Have you finished your answer?
No, it's fine. I was actually going to pass over to Lucy just to give you a bit on the definitions.
I just wanted to make one point, if that's okay, Senator.
Yep.
I asked the question a moment ago about what's the actual implications around the definitions, if they're wrong, around the unacceptable impacts. I know a lot of people are highlighting that, but it's because it actually has implications on a number of different steps. So if we do get those definitions wrong, it can prevent projects even having the opportunity to be assessed right at the start. And there can be unintended implications for that if the test, as it's currently stated, doesn't actually meet that idea of clearly unacceptable. It's also going to cause more delays because the words that are there at the moment, the layers of definitions, for example, one of the criteria alone, one of the ones related to threatened species, includes the words significant impact, seriously impair, serious damage, and seriously alter for the worse, all within the one criteria, once you take into account the definitions. And the clarity around what's the difference between significant and seriously, for example, is not going to be apparent, which means that when officers are involved at the coalface in terms of working out what information is required and where this unacceptable impacts threshold is at, there is clearly going to be more delays rather than less. And that part, it's also...
So as the bills are currently drafted, this could lead to longer delays to build houses in this country?
There is more uncertainty around the words that are being used based on the current criteria and the layers of definitions. If those criteria, because there are 37 different criteria provided for different matters of national environmental significance, if they haven't had the opportunity to be tested with real-life examples of potential projects, we absolutely run the risk that there could be unintended consequences there and that they could cut off a project before it's even had the opportunity of being assessed.
So just in terms of... I'm sorry, Chair, just one quick one. Would you support, in terms of all of these definitions, which, as you say, give rise to such uncertainty, would you support a universal definition in the legislation and then perhaps supported by detailed case studies or examples as to what they actually might mean in practice?
Yes, we would. There are essentially two options there. With more time, then perhaps we would have the ability to rework the separate definitions for the MNES, but in the time available, in order to ensure that unavoidable implications are avoided, a universal definition which gets away from the need to have quite as many definitions and layer upon layer of definitions and uncertainty. And we have, in the time allowed, it's difficult to prepare drafting. It's a difficult task, but we have suggested some wording that perhaps could be used for a universal definition.
Right, thank you. I'll have to leave it at that. Thanks,
Thank
Chair.
you, Senator Henderson. Senator Anandarajan.
Thank you, Chair, and thank you for your testimony and your submissions. This is just to all of you. Can we just look at the status quo first? What are the current problems with the Act and how is it impeding an increase in housing supply?
Okay. Thank you very much, Senator. We'll keep this really short if we can. The simple reality is there is so much uncertainty about what the department actually requires that it means that from the get-go, applications for assessments are facing struggles with RFIs, that's requests for further information. The definitions and what decisions are being made by the department are quite opaque in many cases, and we are aware that they are trying to deal with that and they are getting much more positive results. But the reality is at present, we have arguments effectively going on of what the impact is going to be, whether or not the offset's going to work, all of these things. And it's like, fighting against water, because at the end of the day, different different officials within the departments can come up with different ideas on what they want. So you could bring almost identical projects and have different outcomes. Also, the additional problem this is a problem for the department. The department is trying to make sure that they're getting the best outcome for the environment, given that we also need to get development across the line. And we're completely sympathetic. It is a really hard thing to do. However, there is a tendency, rather than to deal with the issue, to ask for more information and just see whether or not an idea pops up that is going to get us where we need to go. So that would be in a nutshell. Does anyone want to add anything to that?
Thank you for your question, Senator. As a practitioner and having to work closely with the department on a regular basis, I acknowledge that they've put a lot of hard work in, and the Housing Strike Force team has accelerated some of the approval decisions. The unfortunate situation we find ourselves in is there's a regular shift in policy position at the department's level, and that's not a publicly available sort of position. So what we're often having to do is shoot into the dark as to what that position might be on any one matter, and that results in a lot of back and forth. And what we're looking for is a clearer, more decisive and interpretable definitions and guidance from this bill and these amendments and the National Environmental Standard, so as that we can provide sufficient information up front as an industry to help fast-track our approvals. We're not afraid of doing the work. We're keen to do the work. We just want to know where we stand so as that we can get through quicker.
And what are the strengths then? I know we've heard a lot of issues around criticisms of definitions and unacceptable impacts in particular, has garnered a lot of attention during this morning. But what are the strengths of the current Act compared to the status quo? In one, providing greater clarity and potentially expediting decisions.
Yeah. Yeah. Okay. All right. I'll go first. Very, very simply, one thing that it is a really big improvement on where we were going on the proposal is the fact that we are going to have ministers delegating authority in relation to the approvals and assessments. What this means is that the EPA or the NEPA, it gets to be the tough cop on the beat, and we have been very supportive of them being able to look after compliance and enforcement and being strong in relation to doing that. Nobody wants to see the environment being illegally degraded. So that is a big plus. If we can get the definitions right, we can actually have a fast knockout of unacceptable things, and then we can get a streamlined assessment process. But again, the point is all of these things that we've raised, which are largely conflicts of drafting or unclear drafting, which can be simply fixed, need to be done, and then we can get a much better outcome than what we have now.
So I might add, Senator, as identified by the Productivity Commission, the approval process for housing is complex and protracted and involves multiple tiers of government, and crucially the time expended on securing regulatory approvals significantly outweighs the actual time required for the physical construction. For us, the two key bits around this one, alongside, as mentioned, the Housing Strike Team, is the strategic assessments and the bilateral agreements. At the moment, we can often find that we've got duplicative or overlapping assessments happening between federal, state and then even at a local government level. If land is mapped and approved for housing, that should be a streamlined assessment process. And I think those strategic assessments, as I said in the example down in Melbourne, where we've already seen a much more holistic approach to assessment rather than a project by project and having completely inconsistent outcomes. I think those two are really critical criteria under the proposed new legislation.
Are you referring to the Queen Vic decision? Is that the one you were talking about in Melbourne?
There's that one. There's just in the urban growth boundary areas in Melbourne as well. We're seeing that occurring, and we think that there's a great opportunity to lean into some of those going forward, as we know that the land that we've got right now is going to be continually to expand as to where the footprint of housing needs to go to. So those going forward, it's really critical, but the regional plans as well and the landscape scale, with 1/3 of the population now living outside of our metropolitan areas, the growth in the regions is just as critical as on the outskirts of cities.
Absolutely. Just want to turn to offsets for a moment. I know that offsets are an issue. Can you just talk us through the strengths and maybe the advantages of the Restoration Fund proposal. We've heard some negativity this morning about it, but what's your view on this?
Thank you, Senator. I'll make a quick statement and then pass off to Lucy because she's got some expert views on this. But the offset is actually one of the advantages. In fact, as soon as I stopped speaking, there were three that I thought of, which were the opportunity for accreditation, which is actually necessary for one-stop shop, as well as the necessity of regional plans, which will take care of the balance. And offsets is a critical part to all of that because at the end of the day, we have projects that obviously need to think about avoidance and mitigation, and we need to make sure that they are thought about, but can simply not be able to do that. And so offsets become incredibly important because it is the way that you balance it off. And let's face facts, if we're looking at net positive contributions to the environment, the only way you're getting that is through offsets because you need to be able to build the environment up. So somebody, a developer, somebody needs to actually create those things. And you can't create those things just by simply stopping development. So that's enough I wanted to say there. I wanted to pass off to Lucy, who will give you a bit more of the technical detail on the offset.
Just in relation...
I'm interested actually also in the Restoration Fund and how that's going to be received by the industry.
Well, we're very positive on the Restoration Fund. It's incredibly important that you have experts who are actually going to create the offsets and the positive environmental effort needed. It is very difficult to turn a developer into an environmental expert. It is very difficult for them to get the resource that they need to be able to do it. It is far more efficient and effective to get a government to be able to do this. And, you know, we've heard the concerns in relation to it. It all comes down to simply making sure that the government, eyes wide open, goes in and determines an offset with the experience and the cadre of experts that they have at their disposal. So, Lucy, do you want to...
Just to add to that, there are some real positives around the fund and taking that approach, because often when it's project by project, just the practical reality is that often these offsets, if applied really narrowly, are very difficult to find in terms of the like for like, and that can certainly put a really significant additional cost onto housing. But whereas having this fund allows the opportunity to take a step back and it to be less of a checkbox exercise of, oh, I've got this land set aside, it'll be the offset. Is that actually the best way to improve the situation for the environment and to look at the particular species? Not necessarily. Looking at it by experts, taking a step back and looking at it at a more regional perspective has to be a better way to actually make net gain and actually make an improvement to the environment, and that's what the fund allows. It's not about, whilst there have been practical difficulties with some of the funds that have been set up, that's in the implementation. It's not in the system. The system allows for these things, and I know that what has been proposed does provide some flexibility in the acknowledgement that like for like can be difficult to find, by ensuring that where you have a threatened species that you are trying to improve the situation for, there might be other approaches that could be taken that could actually have the better outcome for the environment, and this allows for that.
Thank you. So, yes, go ahead.
Oh, sorry, I might just add, just from, again, a practitioner's perspective, the status quo is that you have this quilt work and patchwork of offsets that individual projects are sourcing, and they're not necessarily in an aggregated manner. Having a payment into a fund and having an expert panel, possibly panels bi-regionally, that are comprised of species experts, town planners, agribusiness people, that can achieve an industrial scale offset program in a coordinated and consistent manner will be far better than this quilt work or patchwork of offsets here and there. And obviously people are going to be wanting to try and find, under the current status quo, the cheapest possible outcome, which often isn't necessarily the best site for an offset, but if it gets through the process, it gets through the process.
They're great insights. My final question really turns to the imperative before us. In your submission, UDIA, you've mentioned, I don't know whether this is a typo, 310 1,000 potential Victorian houses are also without a pathway while environmental issues are being resolved. I'm really not sure if that's a typo, but that seems a staggering number of homes that are in a black backlog in a holding pattern, given the urgency of a housing crisis. Can you just talk us through why it is so urgent that we get this legislation done?
Yes. First of all, in relation to the 310,000, it's actually because of the Ehlers Dragon. They found the Ehlers Dragon in certain parts between Geelong and Melbourne. As a result of that, it put into jeopardy or put into question whether or not developments could be done over a very large area, and that encompassed 310,000 roughly potential homes and future homes, and that's where that number comes from. And we say it simply because we completely understand that you need to be able to make sure that the Ehlers Dragon is protected. Nobody disagrees with that. How long are you going to take to do that is the question, because you have got all these homes and it's a simple pragmatic matter. Nobody is saying bulldoze over endangered species. What we are saying is you need to have it streamlined because it will hold up 310,000 houses. If that is
costing millions and millions and millions of dollars.
Correct.
It's a 10-year plus delay.
And economic growth.
10-year plus delay. Not helped by the state government, I might say.
Yeah. So
well, we're trying to fix it, Sarah. We are trying to fix it. And I keep going, please.
It is a nightmare to develop
Okay,
and
thank
build
you, Sarah.
houses.
I'd like to hear from the stakeholders. Thank you. Please conclude. Why is it so urgent that we get this done?
It's urgent that we get this done because, quite frankly, you can't build houses unless you actually have the planning approvals and environmental approvals. So you can put as much money as you want into housing. If you can't get an environmental approval, you can't get a house. So if you theoretically had the $290 billion that you need just to do affordable and social housing over 21 years, if you can't get an environmental approval, you're not building it in some of the most important areas, because it is going to be on greenfields. It is going to be in those areas where your first home buyers, where people who are on lower incomes are going to be able to afford to buy, that this will happen. And, it's not a question of one over the other. It's not choose the environment over choose development. It's about making sure we get both. And I'm very aware, we've done a lot of talking, and Simon, I think you might have some points to make on this.
That's okay. Just last one for me, Senator, is we're 18 months into the National Housing Accord period to build those 1.2 million homes. Right now, we're only delivering 185,000 homes. We need to be building 250,000 homes year on year, every year going forward, not just these 5-year periods. And we're 18 months in, we're falling well short of those targets, and that only exacerbating the actual housing shortages in the country. So we said this legislation might not be perfect, but it is a significant barrier to greater housing supply, and we need to be able to pulling out all stops across all areas of policy. And this is one of those areas, alongside planning reform, building codes and many other areas, skill shortages, that they all need to work in a concerted effort to address those challenges if we are to meet our growing housing crisis in this country.
Thank you very much. Thank you for your evidence.
Thank you, Senator Anundraja. Thank you for our witnesses from the UDIA and the HIA today. Appreciate both the detail in the submission and the detail in the answers that you've given. If you've taken any questions on notice, if you could endeavour to come back through the Secretariat as soon as possible, and you go with the committee's thanks. So thank you.
Thank you, Chair. Could I just ask one quick question? In relation to further information, is there a time deadline? I'm aware that there is a very constrained timeline on all of this. So
no, we're not reporting until the end of March.
So we haven't set a deadline. So just, I think, in order to facilitate the Senator's interests and relevant considerations, as soon as possible is the way I would put it. So there's no firm deadline. I would now welcome... No, thank you. Thank you very much. I would now welcome representatives from the Central Land Council and the Northern Land Council by video conference.
I mean, it's extraordinary, really.
Can we just get
the
that?
Senate makes a decision.
We'll do that before you get started. Yeah, great. Great. As you're coming to the table and as we're getting, do we have the Northern? How are we going? Okay. We are currently in the process of dialing in the Northern Land Council, as I understand, but we will make a start, and I thank Dr Douglas and Ms Stewart for being here today in person. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. Wonderful, you're both nodding, so thank you very much. I remind senators the senators resolved an officer of a department of the Commonwealth or state shall not be asked to give opinions on matters of policy and shall be given a reasonable opportunity to refer questions asked to the officer or to a superior officer or minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policy or factual questions about how and when policies were adopted. If officers are making a claim that an answer would be contrary to public interest, it must be made by a minister and should be accompanied by a statement setting out the basis of that claim. For the Hansard record, will you please state your full names and the capacity in which you appear today?
Josephine Douglas, General Manager at the Central Land Council.
Thank you.
Georgia Stewart, the Policy Manager from the Central Land Council.
And I think we now have representatives from the Northern Land Council online.
Yes, good afternoon. This is Yusuf Dean, the CEO from the Northern Land Council.
And good afternoon, David Astalos, General Manager.
Thank you. Sorry, we just lost you at the end there.
David Astalos, General Manager, Northern Land Council.
Thank you very much. You would have potentially heard my statements earlier about opening statements, and we're running a bit behind. So if it's possible to give a very brief opening statement if you have one, and then we can try to get to questions.
Thank you, Chair.
Thank you.
I'll be delivering the opening statement. I'd like to pay respects to the Ngunnawal people who are the traditional custodians of this land on which we are meeting today. We are here today representing the Central Land Council and are joined by our colleagues from the Northern Land Council. Our concerns about the bill and processes underpinning its development are shared by the Andiliaqua and Tiwi Land Councils, and this is reflected in our joint submission. While with all Australians, we carry the weight and responsibility of this critical time in history where the protection of nature, so inextricably bound to our identity, culture and well-being, is teetering on a precipice. If we fail to get this bill right by taking another step in the wrong direction, our collective futures are bleak. In the Northern Territory, we live at the coalface of climate change now, and our trajectory, if quick and courageous decisions are not made, if quick and courageous decisions are not made now, will be harsh and likely irreversible. It is our view that with critical amendments, we can get the Environment Protection Reform Bill right. We remain positive. None of us want to be in Canberra in 5 years' time talking about why this bill failed our environment and our people. We do share a collective concern about the truncated process of public submissions and hearings under this Senate committee inquiry process, which will be wound up before the submission due date. The approach has left little room for proper review, engagement and scrutiny of complex amendments to a nationally important law. The nature, volume and complexity of materials presented through the reform process warranted early, open and constructive engagement with land councils and other First Nations representative organisations. Land councils, along with a vast array of other Aboriginal and Torres Strait Islander representative bodies and organisations, have had just over a fortnight to review and respond to 7 bills comprising over 1,000 pages. This is in part why we are the only First Nations representatives appearing at this inquiry. This rush process is entirely inconsistent with shared decision-making and improving how governments do business with Aboriginal people and Torres Strait Islander people under the Closing the Gap. It also diminishes the commitment to Indigenous voice so high on the government's agenda just 2 years ago. It also disregards traditional owners' millennia of custodianship and expertise and risks incomplete legislation and with adverse outcomes. We take this opportunity now to urge the federal government to delay tabling of the bill until this important inquiry has run its course, and for this committee to extend opportunities for submissions to be made within a reasonable time frame with additional hearings in the new year, and for its recommendations to be carefully considered when finalising the bill. Our submission identifies a number of key issues that need to be addressed in the bill, and we make specific recommendations. We think they are important and achievable and include, and I'll head towards the end now, Chair, ensuring participation of Indigenous peoples in all key processes, decisions and determinations under the reformed EPBC Act, expanding the water trigger to all projects with a significant impact on ground and surface water resources, ensuring environmental integrity through better balancing ministerial discretions, transparency, devolution and the clear, certain and robust application of national environmental standards, and requiring key decisions and determinations to take account of the changing climate and related risk modelling and adaptation planning. It is imperative that the environmental reforms deliver, in closing, critical protections and gains for the environment, including species, ecologically and culturally, and significant water resources, protections and pathways or Indigenous participation embedded in the Act, requirements to consider and transparently address the views and expertise of traditional owners, as well as other experts in the community in relation to key processes and decisions, and outcomes consistent with Australia's international commitments to reduce emissions, including minimising the impacts of climate change on Indigenous people. Thank you, Chair.
Thank you very much. Sorry, I'm just blanking for a moment. The Northern Land Council, do you have an opening statement or a brief one, if possible?
Chair, the opening statement that was delivered by the Central Land Council also covered our views as well.
Okay, thank you. Thank you very much. I'll now give the call to Senator Hanson-Young.
Well, I've just seen that Senator Thorpe's come online, so
if you,
I'm happy for you to go to her first if you'd like.
Oh, yeah, okay. Thank you, Senator Hanson-Young. Senator Thorpe.
Thank you, Senator Hanson-Young, for that, and thank you, Chair. And thanks to the Land Councils. This is certainly something that we all have in common, that's protecting land and water. So my question for both the CLC and the NLC, you both have stated that the government process for these bills has provided little or no genuine engagement with our people. So can you outline precisely what consultation did or did not occur and what the government should have done to meaningfully engage First Peoples before introducing national environmental reforms of this scale?
Thank you, Senator Thorpe. In regards to consultations, I can speak for the Central Land Council. We had a Teams meeting with ministerial and department staff, which we sought, and that was for an hour on Zoom. We had some provision of information 1 to 2 days before the introduction of the bill into the Parliament. We had a short meeting with Minister Murray Watt for about 15 minutes, approximately 2 weeks ago, after the introduction. So in summary, Senator, we've had very limited consultation with this, and I think it's the 4 land councils from the Northern Territory. After we issued a public statement, we have had some outreach to us, but a general feedback around this process is that it has been wanting and it hasn't been good enough.
So in your views, sorry, did you want to say something as well? CLC.
Sorry, Senator. The only addition to the CLC's experience, or rather, I just support the CLC's experience with the consultation process. We were part of that consultation or limited consultation process as well.
So, does this fulfil FPIC, free, prior and informed consent, which the government hangs their hat on and says that they do quite well?
In our view, it does not fulfil the requirements of FPIC, and the timeframes within the reform bill will not facilitate free, prior and informed consent, let alone fulfil the statutory requirements of consultation that's required.
If I might add, Senator, supporting what the Central Land Council has expressed, it does not meet the standards that are expected in terms of free, prior and informed consent. It doesn't meet the standards that are set by land councils when we try to ensure that free, prior and informed consent needs to be achieved in that informed decision-making space. And it also fails the priority inform area of the Closing the Gap framework in terms of a partnership approach.
If I may, I'll add a comment as well, that the fact that we are the only Indigenous organisations present at the hearings, we are statutory entities with more resourcing perhaps than some, and there are a range of Aboriginal organisations, Indigenous organisations who have been bypassed in these processes as well. And for that reason, we would hope to see an opportunity for this inquiry to be seen through to its endpoint, and that there is an opportunity for additional hearings for those who are still in good faith making submissions to this process.
Can I just also add, Senator, we are very concerned in terms of the new streamlined assessment processes that are being proposed. We're concerned about streamlined processes, and this is a significant and concerning change from the current Act in terms of publication or public comment on streamlined assessment recommendation reports would no longer be required prior to the Minister's approval decision. So this is significant and a concerning change from the Act. For this reason, land councils do not support the proposal for undemocratic streamlined assessment processes, especially for fossil fuel projects. We want to see engagement with traditional owners on projects that affect them, their country and the environment, and it has to be genuine and it needs to be tailored to the impacts of a project and the cultural concerns of each particular group. And sometimes this engagement can take time, but once the engagement's done, there's certainty for proponents, certainty for business, and certainty for traditional owners and native title holders.
And on that point, we may need to add too that when it comes to bioregional planning, it's extremely important that traditional owners whose country may be affected are involved in the initial consultations, but that extends also to specific project recommendations. And I say that not with the intent of halting projects, it's more to do with the nature of cultural values. And an initial cultural values assessment is one thing, but specific projects, particularly large and complex industrial projects, for traditional owners to ensure the minimal harm or minimal change or impact on sites of cultural assessment or cultural value, that process needs consultation. But there are pathways for that that don't need to slow things down if there was a co-design process between traditional owners and developers to look at how that might work, the best placement of roads, the best placement of infrastructure in a development zone, then that's highly possible, but it's also really crucial that that consultation continues.
Thank you. And I agree it's shameful about free, prior and informed consent and also witnesses. I did provide a list of other witnesses and was told that there wasn't enough time. So us southern blackfellas didn't even get to the table, unfortunately. And, you know, we're still blackfellas down here. And the government, you know, chose not to hear from people this way. So just want to ask some questions around the Heritage Protection Alliance. The government says all its First Peoples engagement is happening with the First Nations Heritage Protection Alliance, which both CLC and NLC are members of. So my questions are, how often does your organisation attend meetings of the Alliance, and who from your organisation is invited to these meetings, and how often do they meet?
Thank you, Senator. The work of the Heritage Alliance is an alliance which we respect, and the Central Land Council has a representative on the alliance, and they have been attending the meetings regularly. It is really important to note, though, the work that has been done by the Heritage Alliance for the Aboriginal and Torres Strait Islander Heritage Protection Act was done prior to the release of this bill, this reform bill for the EPBC Act. In terms of the national environmental standards in relation to First Nations engagement, that NES needs to be fit for purpose for the EPBC as well as for the reformed Heritage Act. No versions of a draft standard in terms of the work of the Heritage Alliance has been signed off yet, and we have, as you say, had input into the development of that. But I make my point, I return to my point, that the work of the Heritage Alliance was specific to the Heritage Act, which was supposed to come in first. Government is now putting the EPBC Act first. It's the first piece of legislation going forward. What was done for the NES in terms of the Heritage Bill was for that, and there are new things within this reform bill that need to be consulted on. So we would like principles of engagement that this bill is widely consulted on and widely agreed to by Aboriginal and Torres Strait Islander organisations and peoples around Australia. Thank you.
Senator, if I might add to that, the NLC is involved. You're correct in your observation that the NLC participates in the alliance activity. We also respect the alliance's work, including the fact that the alliance was formed in response to the destruction of Juukan Gorge. As Dr. Douglas mentioned in her response, the challenge of using a piece of consultation work for a different piece of legislation in terms of the Aboriginal and Torres Strait Islander Heritage Protection Act is problematic. It seems to be trying to paper over the cracks of the deficiencies within the current reform piece of the environmental related act.
Thank you. So I've been told that the Alliance doesn't have all its members at all the meetings, and sometimes only 2 reps are talking to the Minister from the Alliance because not everyone can make it to the meetings. Is that correct?
Senator, that question would have to be put to the Alliance. I can say for the Central Land Council, our representative attends meetings regularly and has contributed to the work of the Alliance. So those questions about attendance of members is best be put to the Alliance.
So, sorry, Dr. Douglas, does that mean that your members attend every meeting?
I would have to take that question on notice in terms of attendance at every meeting, but I can say our member has attended, most of the meetings, yes. But I will take that question on notice, Senator Thorpe. Thank you.
Thank you.
And Senator, if I might add to that, the question around representation at Alliance convened meetings, whilst again that's a matter for the Alliance to respond to. From my observations, there is an internal sort of governance structure matter that those members of the Alliance that might meet with the Minister maybe select representatives from a broader representative base through the two-staged approach of the Alliance, how the Alliance operates in terms of its consultative approach to responses to policy and legislative reform, so on and so forth.
Thank you. I just have one final question, Chair. We know the government wants to streamline things so that proponents just have to talk to one group or just one person to pay them off and get signed off. And we know that, vehicles and money and jobs are offered in return for a signature to sign off on some pretty destructive industries that destroy country. This means that handling all consultation requirements with land councils and saying that meets FPIC requirements. Do you support changes that will prevent individuals outside of land councils or rep bodies from making a heritage claim? So, I belong to a couple of native title bodies down here in South, and if a family clan group says that they want to protect the Japarung trees, for example, and birthing trees, 800-year-old birthing trees, but the corporation at the board level say, oh no, we're going to do $1 million deal with the government to widen the road to save 6 minutes off the highway. Do you support the government's approach in shutting down family clan groups that have genuine concern about the destruction of their land? Do you think that they should be overridden by these changes?
Senator, land councils are statutory bodies. We have statutory functions under the Land Rights Act and under native title. We all the 4 land councils work to a standard of free, prior and informed consent, and we would like that to be reflected in the national environmental standards, particularly around First Nations engagement. In terms of the government's approach, I'm unaware of that approach, and I would say that we have really clear processes and ways of working in the Northern Territory with traditional owners and native title holders.
Thank you.
Thank you, Senator Thorpe. Senator Hanson.
Oh, sorry, I just wanted to hear from
sorry,
Mr.
I didn't mean to cut you off.
Yeah.
Oh, thank you, Senator. Adding on to what Dr. Douglas mentioned, the situation or the circumstances are that that the Northern Land Council and the Central Land Council operate within our jurisdiction, and originating from the East Coast, being a First Nations person from Northern Australia, far north Queensland, I appreciate the fact that decision making, particularly from a customary law point of view, changes as you move through each jurisdiction. Therefore, from our perspective as the Northern Territory Land Councils, we can only apply the frameworks here, and the frameworks will depend on the decision-making, the customary law decision-making of the traditional owner groups that we consult with.
So just a follow-up question, Chair. So I visited Borroloola and MacArthur River Mine, and I heard from family clan groups that they didn't agree with the desecration of a sacred site, but the Land Council did. So if we talk about different laws on different countries, that seems pretty similar to what goes on in this country down this way. So how do you rectify, how do you consolidate that if a family clan says, no, we don't want this river, MacArthur River Mine to happen because it's destroying a sacred serpent, and yet the Land Council says, oh, but we've done a deal, we've got an LUR, and we think it's going to be all okay because they've put a fence around it. They've diverted the river, which destroys Songline, but however, the deal's too good.
Senator, I can't speak to that particular example, but what I can say is that we have a statutory responsibility to protect sacred sites. The second point to that is it's not a Land Council's decision around what traditional owners determine on country. Our particular role is to create a space for informed decision making. And in areas like Borroloola, the traditional owner groups or the custodian groups are very much geared towards customary law decision making. Therefore, we respect what those decisions are, and we abide by those decisions in terms of how we implement those decisions, not only to protect sacred sites, but also other matters on country as well.
And just to pick up on that point, there were family clans that didn't even know about Land Council meetings. They weren't picked up by the bus to the meetings. They had no idea these decisions were being made on their behalf. So I just want to let you know that there's a whole Jukan report that articulates how those family clans were left out of free, prior and informed consent, and that, you know, this not allowing individuals to raise issues and just going through the corporate structures, I think is a real danger, and I hope the Land Councils can see that. Thank you.
Appreciated, Senator. We always take on board the feedback from countrymen as well.
Thank you.
Thank you. Thanks, Chair.
Thank you, Senator Thorpe. Thank you for that. Senator Hanson-Young.
Thank you. I think Senator Thorpe actually asked a lot of the questions that needed to be about the level of consultation so far, and I've heard you really clearly that you feel like you haven't had enough consultation and haven't had an appropriate process. It begs belief that you had to ask for a Teams meeting with some ministerial staff when so many of these changes are going to impact directly on projects that are on your land. So I understand that frustration. And I'm also concerned of what you're saying, that actually there's numerous other First Nations communities who have been left out of this totally. So I think we need to consider that. What I did want to know is in Graham Samuel's report, he spoke clearly about the need for more engagement with Indigenous communities and making sure that there is a genuine process of consultation, that it's not just lip service. There was a draft of put forward in his report of standards for how that consultation could happen. Have you seen that? I know it was 5 years ago, but I'm interested as to whether you think that is a good basis, or whether you've got, or whether you think we would need to start again, given the government hasn't put anything forward.
I'll partly respond to that. In terms of the standard, we think that there's been a good start and that there's been good processes, but what we're keen to see in the entirety of the reform bill is a number of measures, some of which Josie's already referred to with respect to consultation and free, prior and informed consent, but also with strengthening the IAC. We feel like the IAC at the moment is a body that advises the department and advises the minister. It should have greater powers. It needs to have more teeth, and it needs to have jurisdictional representation as well as expertise. It should have the power to call on expert advice. And there's a very particular role it has in monitoring the impact of all of the standards on Australia's First Nations peoples. So that expanded functionality and role for the IAC is critically important to ensuring consultations happen well. But in terms of the Graham Samuel's work, none of that needs to start from scratch because we all have done considerable work on what good consultation looks like. But it does require, as we've said before, that the standard that's already been developed through the heritage work is put through the wash-through of this bill to see what language needs to be tightened up, particularly in the context of environmental law. Ambiguity is not a positive thing, and so we want to have strong standards and clear and strong legislation, and that applies too to consultations.
And I see that in the submission that you've called for the role of the Indigenous Advisory Council, the IAC, to be strengthened. I would imagine that actually needs to happen prior to signing off on what a First Nations consultation standard would look like.
Yes, the IAC would play a significant role in ensuring that consultation happens.
Okay, so that really is a matter of urgency, isn't it?
It's a matter of urgency, and I think one important point is we don't want to see the NES for engagement with Indigenous people lagging and delayed. When that bill is enacted, that standard, along with all the others, need to be ready. It's more that work needs to be done. It needs to be done urgently, and it needs to be done well, but it doesn't need to be a blockage to having a standard ready once the bill's enacted.
And then in terms of, just to follow on, if I may,
yeah,
Senator, then in terms of the engagement standard, looking at it from an environmental lens and certainty in terms of environmental laws, we want words like may, we find words like may and should deeply concerning. And for certainty, we want words like must and will to be used to ensure accountability and compliance. And I think that is critical to us as First Nations representatives, that the wording needs to be prescriptive and not permissive. So language is incredibly important, and looking at an engagement standard through an environmental legal lens, we want certainty. And if you have that certainty, it's certainty for all, really, in terms of best outcomes for First Nation people, for environmental, social, cultural outcomes, and for business and industry. You can get it right, and now is the time for government to get it right.
Thank you. I think they're all very good points. We are running up against the clock, but I just have one last question, if I could, Chair, and that is in relation to the changes to the water trigger in this bill. I assume you're across them, given the significant impact that may have on your communities. Could you give us a response to what the government has proposed here, which is effectively an overriding of the water trigger?
That's right. From our perspective, inland Australia is really protected by groundwater in particular, and that's at a landscape level. And at the moment, we have projects in the Northern Territory lined up to extract large quantities of water. In the case of Singleton, the largest ever extraction of water for an intensive horticulture project. So it's not a coal seam gas and it's not a fracking project, but it's an intensive horticulture project. The impacts are the same through taking the water, and in fact, across 30 years, with 40 gig per year being extracted, it will drop the water basin by 50 metres. So for groundwater-dependent ecosystems, which are inextricably bound up with cultural sites, values, dreaming tracks, soakages, it's like land clearing by stealth. So from our perspective, we don't have a government at the moment that can deal with water in the way that's needed. We don't have statutory water plans. We have a territory coordinator. The powers under that Act enable step in across 32 pieces of legislation, including planning and water acts. And we have a government that's diminished the Sacred Sites Act. So for us, these decisions need to sit with the federal government, but they also need to be expanded to look at the impact of projects, not the type of projects. We support what happened in 2023 to accommodate people's fears around fracking and water use, but we think that it's sort of environmentally inconsistent to have that without it impacting on other types of projects.
So just to be clear, so I understand you, what you're saying is you're worried about the overwrite, that the water trigger could just be handed back to the territory government. But in addition, you're also saying actually it's not just fracking and gas projects that are the problem here. There is an enormous amount of water extraction that's being used for other industries.
That's right.
Massive agriculture without any consideration for the water quality or sustainability of that water supply going forward.
That's right. And as we were saying, it's crucial. The National Groundwater Strategic Framework has highlighted how increasing demand and ongoing inconsistencies in jurisdictional management and deficiencies in data are undermining best practice and putting groundwater resources at risk. And they also acknowledge that groundwater systems are critical across most of inland Australia for future drinking water, but also for sustaining many critical environmental habitats and refuge, climate refuge sites. So it's a no-brainer to us that should be consistent and it should be rational with respect to environmental protection.
I get that, and we can't trust that the Northern Territory government is going to do the right thing at all.
No, not at all. And we have also put forward some criteria that we think could be considered as threshold criteria for the sorts of projects that would be referred, which we think are sensible and achievable.
Okay, all right. Is that in your submission?
Yeah, it is.
Yep, okay, great. Thank you. Thanks, Chair.
Thank you, Deputy Chair. Senator Henderson.
Thank you very much, Chair. Good afternoon to you all. Look, I just was also concerned about the lack of consultation in relation to the bills. How would you characterise that in terms of seeing where the bills are at now? Does that reflect a complete lack of consultation, the fact that the bill, so much more work is required in the bills, do you think?
Well, there were consultations around the nature positive laws that we all participated in, and a range of groups would have participated in. But when this bill landed, we really had at most 18 days to respond and engage with that, which we've succeeded in doing as far as we can, but we are an organisation with more resources.
Well, that's not very much time given the scope of the issues that you need to deal with. And so what is your, as you look at the bills now, what further work do you believe is required to get them into an order where you feel that they can get your support?
Well, first of all, I think we need to use the time available to this committee in terms of the reporting period is March. We note that there's been 3 days of hearings made available and people in good faith have put their submissions in, but due to the truncated time frame, we would like to have more hearings and opportunities provided to groups and people around Australia so that they can also have time to review the 1,000-page reform bill across 7 bills with attached memoranda. And so that's what we would be seeking, is that the time frame be extended. And I
so
think
there should be more hearings next year, enabling a much broader range of Indigenous organisations to make submissions and to be heard?
Yes, correct, Senator.
So it's placed big constraints just for you to be here today, but for smaller and less resourced organisations, it's a very big barrier.
Correct, Senator.
What would you...
We should be going to the Northern Territory.
Well, we could do that.
Let's do that.
Yeah. Yeah, we absolutely could do that. And
Not before next week, though, Chair.
No, we can't do that. So,
what are you doing this weekend?
I mean, it is in stark contrast. It just seems extraordinary to me that we've got an inquiry into these very complex bills. We don't report until March, and the government is treating the whole process with contempt by listing the bills for consideration and we assume trying to pass them next week in the Parliament. I mean,
I want to get them through with you guys. What are you going to do?
Well, let's just hope they don't do a deal. Let's just hope they don't do a deal with the Greens, Senator Hanson-Young.
Senators, these are very fascinating conversations, but given the timing,
the Treasurer wants to
Senator
do the
Hanson-Young,
with
Senator
Susan
Henderson.
Lee.
Let me just interject
anyway,
and say,
yes,
let's stick with the questions,
Chair. I have
and if
the
we're
call.
able to.
So in other words, this, excuse the little bit of hilarity on the sidelines, but in all seriousness, this is a big issue for Indigenous groups, and we did raise the consultation issues, including with Professor Samuel. And so are you aware of other organisations that haven't even had a chance to get their head around these bills?
Yes, there are. And I need to make this point in terms of the National Environmental Standard in regards to First Nation engagement. We don't want to see that. We want to see that incorporated in terms of this legislation and not kicked down the road to be dealt with later on.
In delegated legislation or the regulations?
No, in regulations. We want to see the core national environmental standards agreed on, and that they be included and written into the reform bill. And I think we should avoid mistakes of the past. This presents an opportunity to get it right and to do the necessary work to get it right. We are, willing to work to do what's necessary to provide advice. We've put in a substantial submission with recommendations in that submission, but we really need to see the in national environmental standards strengthened and to be part of this reform bill process, not delegated to regulations.
Well, thank you very much. Thanks, Chair. No further questions from me.
With that, I'd like to thank both the Northern Land Council and the Central Land Council for your evidence today and the work that's gone into the submissions. If you've taken any questions on notice, could you please provide answers to the Secretariat as soon as possible. But once again, thank you. The committee really appreciates the effort. So, we're going to have a short break now for a comfort stop and a glass of water, but it's probably, well, it'll only be 10 minutes, so we will start promptly at 5 to 5. Thank you. Its inquiry. I welcome representatives from the Environment Centre, Northern Territory and the Conservation Council of Western Australia. Thank you, by video conference. Thank you for being here and dialling in today. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you?
Yes.
That's right. And you're nodding as well from the Conservation Council, so thank you very much. For the Hansard record, will you please state your full names and the capacity in which you appear today? We'll go in the room first and then video conference.
I'm Kirsty Howie and I'm Executive Director of the Environment Centre of the Northern Territory.
I'm Bree Arns. I'm Senior Climate Campaigner at Environment Centre of the NT.
Thank you.
And I'm Matt Roberts. I'm the Executive Director of the Conservation Council of Western Australia.
Thank you. Now, if you've been paying attention to this hearing, you've heard me say this a number of times today, we're running a fairly long way behind schedule, so if it's possible to table your opening statement, that would be wonderful to allow us to get straight to questions. If it's not and you'd like to make a short opening statement, then I would gently and respectfully ask that it be brief.
Thank you so much, Senator. What I will seek to table is not a statement by my organisation, but a joint position by the 8 state and territory conservation councils across Australia, of which the Environment Centre of the Northern Territory and the Conservation Council of Western Australia are 2. And I might just give a brief opening statement orally, which gives a bit of a Northern Territory flavour to what's in that statement. And we've come a long way to be at this inquiry and are grateful for the opportunity to present here. And the Northern Territory faces a specific and quite existential threat from climate change specifically. And I note that much of Northern Australia will quite literally be unlivable within a zone of that is incompatible with human habitation within a generation unless we take urgent action. Similarly, and somewhat contradictorily, Northern Australia and the Northern Territory are ground zero for fossil fuel expansion in this country. And really, the LNG export hubs in this country are dotted across Northern Australia in areas which will be unlivable within a generation or 2 unless we curb emissions urgently. We're also facing industrial scale development from other industries like cotton and mining. And we have a Northern Territory government that is intent on slashing protections. And in that vein, in the last few months alone, we've had a number of rolling scandals which show the complete ineptitude of the Northern Territory government to regulate the environment. A 20-year methane leak from Santos's Darwin LNG export hub. INPEX underestimating their benzene emissions by some 13,400%. Leaking US military fuel tanks that are not built to cyclone code. And I note that a cyclone is bearing down on Darwin right now as we speak. So against that context, I just want to highlight 3 things that we're concerned about in these laws. First of all, we're concerned about the king-making discretion that is embedded almost throughout sort of every section of the proposed laws. This is the antithesis of what the Samuel Review proposed and recommended. We also want to draw attention to the numerous ways in which devolution and expansion of decision-making powers to states and territories is facilitated by these reforms. And this is deeply problematic in the Northern Territory as well as other jurisdictions for the reasons I've just outlined. And the third thing I want to raise is the way that these bills will fast-track developments, and this was raised by Northern Territory land councils recently. And what is not mentioned in this fast-tracking discussion very often, and we have nothing we don't suggest that quick approvals are a bad thing, but what is on the table will also gut community rights to have a say over developments. And that is not a message that is getting through, and we are organisations that represent our communities, and whether it's fossil fuels, which will be fast-tracked, whether it's mining, which will be fast-tracked, whether it's renewables projects, which will be fast-tracked, community rights are gutted. We are the State and Territory Conservation Councils, and I'll just end by saying we are the best placed organisations as peak bodies of our respective jurisdictions to say we do not want devolution of EPBC Act powers to the states and territories. Thank you.
Thank you. Matt, did you want to?
Yes, thank you, Senator. I appreciate the time constraints, but just a brief statement because I do bring a particular WA perspective. So I am here obviously to represent WA environmental concerns, and I am aware that our responsibilities do not stop at our state border. The environment is a collective responsibility. I would note that we have a state-based funding system that does require states to make decisions in their own interests for financial gain through a royalty system, and it is a system that sets up our states to make decisions in their individual financial interests, often in favour of industry and at the expense of the environment. The current degradation of the Pilbara region in Western Australia does speak volumes to this. So we do need laws that balance our role as a nation against the international and local obligations and challenges we face, and we need that to be above the drivers of potential financial conflicts of interest that sit at a state level. We acknowledge that the EPBC Act is not achieving its purpose. Australia's environment and cultural heritage are frequently damaged by projects approved under the Act, but CCWA holds many concerns about the proposed amendments, not the least of which is the potential devolution to the approval of state and territory bodies. We have a state government that famously took credit for sinking the last round of attempted reforms, and these reforms have wide-ranging ways to give powers to states. And in Western Australia, we often see our state approvals end up weaker than the conditions brought on by the Commonwealth. The latest example was regarding the North West Shelf decision, where the conditions in the Federal Environment Minister's own statement of reasons far exceeded what the WA Minister had imposed. There was an attempt to put that down to new information, but the WA government held firm on its view even in light of that new information. And I think that the fact that we're having an argument over these reforms means that nature has already lost. This is not a case of the enemy being the perfect of the good. When we get into the weeds of clauses and semantics, we lose the heart of what's gone wrong with these reforms. They do not protect nature. I will add that we have a similar EPA setup in WA as is proposed here, and it has not worked to halt the steep decline of nature in WA. I welcome the opportunity to answer any questions that the committee might have, and thank you for allowing me to appear here.
Thank you both. Senator Hanson, yeah.
Thank you. You've both mentioned the devolution of powers to the states and territories, and I think given you're from WA and the Northern Territory, I understand from an environmental and climate perspective why you would be particularly nervous about that. Is there anything in how the government has talked about the reasons why this devolution and how it's been drafted that gives you any hope that a Northern Territory government or WA government is not going to use this to fast-track fossil fuels?
Thank you, Senator. We were deeply alarmed when we first read the draft legislation and saw the multiple new pathways to devolution that were proposed. They are akin to the former coalition government's one-stop shop proposals, and they actually extend them in significant ways as well through what I might call devolution by stealth, things like the bioregional agreements, strategic assessments, and other methods as well. I can see absolutely no barrier to the Northern Territory government, or to take an example that's come up today, the newly appointed Territory Coordinator, a former gas industry executive in the Northern Territory who has got the power to exempt 32 Northern Territory laws from being accredited, from his processes being accredited under the EPBC Act under these new proposed laws. Not only that, there are such kind of gaping holes in what is proposed by way of devolution pathways that it's going to lead to compromised protections for nature and climate. There's no question about that, but it's also going to lead to incredible complexity. I just cannot see how a federal EPA can possibly enforce 8 separate accredited arrangements, which might accredit guidelines, rules, policies. It seems almost impossible. and it's a really sound rule to maintain a basis to retain decision-making responsibility with the federal government. My colleague Matt mentioned the North West Shelf, dynamic tension between the WA government and the federal minister, and how it does lead to often better decision-making, more rigorous decision-making thanks to Commonwealth intervention. We have plenty of examples of that in the Northern Territory as well. One example would be MacArthur River Mine, which has also come up recently, where we just need that additional level of scrutiny, and where we have a local government that is intent on fast-tracking development, exempting laws, streamlining fossil fuel and other developments, and gutting community rights. It's crucial that we maintain that federal oversight, and it's devastating that that could be lost to communities across the Northern Territory.
Mr Roberts, are you worried that this is going to be used as process for Premier Cook just to ram through more fossil fuel projects and expand them?
It certainly is a concern and something that could occur. I mean, we're currently seeing a committee hearing at a state level around the role of gas exports in decarbonising Southeast Asia and Asia more broadly, and with sort of the commitment to back in gas exports and the gas industry, it does demonstrate that there is a priority to keep those projects going in Western Australia. And I suppose for industry where there is any potential for the laws to back them in, they will be used. We also have a similar circumstance as to the Territory. They currently have a Coordinator General. We have laws in front of our state Parliament that would see a similar role put into WA, which would allow them to prioritise projects and fast-track them in the name of priority projects that are deemed suitable by a minister or the Premier himself, giving sort of high concentration of power in order to back in the projects that they see fit. So given what we're hearing about what they're backing in of fossil fuel projects, it is a deep concern.
Could I ask about the streamlined assessments? Because, Dr. Howie, you've mentioned there's actually various ways that devolution happens to the states, but the streamlined assessment pathway, which is the new one, which is meant to be quick and dirty, get it done, 30 days, bang. The department last week told us that 60% of applications they expect will go through that process. And that could actually increase once people realise, start working out how to streamline their own process in order to then be able to get into that section. So 60% plus applications going to go through that. We know that that's only a 30-day turnaround with limited public consultation, community consultation. Could you talk to the risk of that in terms of what are some of the current applications before that are looming down in the Northern Territory right now? Because we also heard from the department last week that existing projects could pull out of their application and then just go through the streamline once the streamline's put through.
Yes, so you're absolutely correct. The number of projects that could be fast-tracked or streamlined is the majority of projects that would ever be referred under the EPBC Act. A 30-day turnaround of extremely, in some cases, complex, environmentally, culturally, socially, projects, it simply beggars belief. It does not pass a sniff test for communities for whatever development. And in particular, I note in the Northern Territory, we are looking at fossil fuel expansion on quite a significant scale. We've been fighting to get federal scrutiny of fracking in the Northern Territory, specifically under the water trigger. And we fought tooth and nail to get that expansion in the EPBC Act a couple of years ago, which we're grateful to the Parliament for passing. At the moment, that's a decision that sits with the Minister it's proposed that the protection for that to remain federal would be devolved to states and territories, so that's the first blow for that. Even if that doesn't happen, we would foresee that fracking proposals, even if the water trigger was applied, would be fast-tracked. There'd be a 30-day turnaround and a 10-day comment for the public. How on earth do you, as a community organisation as we are, get out to communities to inform them about this, acquire and obtain the relevant expertise, including scientific, to be able to scrutinise them? You can't. So this is a fast-tracking that absolutely guts community rights and guts scrutiny. And what it does is it undermines a fundamental principle of environmental assessment legislation worldwide, which is that it needs to have a component of public participation. The public needs to be able to influence decisions. And what we're seeing here is a gutting of that. And it's unacceptable and, you know, deeply concerning for communities across the country, not just in the Northern Territory. Another project I'll point to, which would be streamlined, is the Lee Point development. It was assessed at a public environment report level. It's hugely controversial. It shouldn't have been approved in the way it was. It is critical habitat for endangered Gouldian finches and other species and has up to 300 bird species at the site. That would, under this new proposal, be fast-tracked and turned around within 30 days.
And that woodland in particular at Lee Point is, you know, some of those trees are 400 years old.
That's right.
And how does that get taken into consideration in a process of a 10-day public consultation?
It can't. It's laughable, and this is actually going to cause more problems than it solves, would be my guess.
I would imagine that the government's and business, because they seem to be on the same page here, response to all this is they want to provide a way for simpler projects to get approved, that they don't want things tied up in the courts, that this is to limit people complaining, that kind of using the term, you know, lawfare. What's your response to that?
Well, I think I mentioned before, we have absolutely no argument with fast approvals. But what this does is it guts the ability for community scrutiny. It guts the ability for genuine engagement on the science and on the impacts to both nature and climate. And, you know, business and industry may say that this is necessary, but my response to that would be that there are so many other ways in which you can achieve that outcome of faster approvals without imposing completely arbitrary, unrealistic timeframes that gut community rights and will lead to more problems. One simple example that the Productivity Commission has pointed to in the past in inquiries is resource the regulator. Actually get staff into the department at sufficient scale, numbers, resources to be able to undertake the assessments in a timely manner. And if discretion was tightened up, as we've suggested, if standards were robust and strong, if unacceptable impacts definitions were tightened up and more clear for both industry and community, that would go a long way to speeding up the process without creating fast-tracking of projects like Lee Point, fracking and Santos's Barossa pipeline through Darwin Harbour.
Can I ask about the standards? Because we had Professor Samuels in front of us last week, and he's obviously very attached to his report and the recommendations that were made. I understand that. And he made it very clear a number of times that the standards themselves were the crucial element of all of this. However, he hadn't seen the standards, the draft standards. I'm wondering whether you've looked at the draft standards and what you think about them versus the standards that were in Graham Samuel's report itself.
So the first thing I'd say is that it's really difficult for anyone to comment on standards that haven't been released and will be released next year. So sort of the notion that the whole thing hangs on robust standards and that these laws will achieve, moving towards a standards-based system is undermined somewhat. It's impossible to engage in the process when you haven't seen the vast majority of the standards. I have had a look at the standard on matters for national environmental significance and offsets. My impression is that both of those standards are weaker than the drafts that were put forward by Graham Samuel in key respects, and I'm talking particularly about protection for nature and MNES. But the other thing that's crucial here is whatever the standards are, however strong and robust they are pretty much meaningless if they're only applied in a subjective way in the legislation. And at the moment, what we have is the ability for the minister to make decisions that are highly subjective and discretionary, and he only needs to be satisfied that standards have been complied with. And the standard isn't even that one of compliance, it's that they're not inconsistent with. And that just creates such a great deal of uncertainty, discretion and power that it undermines the whole purpose of the standards to start with.
Thank you. Thanks, Chair.
Thank you, Senator Hanson-Young. Senator Pocock.
Thank you, Chair. Thank you for your time here this afternoon. Dr. Howie, in the context of environmental laws that are potentially going to devolve powers to the NT, I've seen a lot of media reporting over the last few months about some concerning behaviour in the gas industry in the NT and what looks like some failures of the regulator. I was wondering if you could just outline at a high level what's been happening.
Yes. What has happened in the last few months has been deeply concerning and upsetting, particularly for residents in Darwin and Palmerston. There was a revelation in September that one of the largest and most significant gas export hubs in the country, Santos's Darwin LNG facility, had been leaking huge amounts of methane, highly polluting, highly harmful to the climate, for nearly 2 decades. The Northern Territory EPA made a choice to instead, and they'd been turning a blind eye to this for 20 years, not just at a Northern Territory level, but also at a federal level. And instead of requiring Santos to fix the problem, they renewed the licence. We've similarly had a situation in the last month or so where INPEX has disclosed that they have been emitting much higher quantities of cancer-causing benzene than they had previously reported. And we're talking huge disparities of 134 times more benzene was being emitted. Now, we've been told that there's an investigation ongoing about that, but really very little information has been given to the public, and the public is justifiably scared and worried. The third incident involves the gas industry as well, but it's to do with US military fuel tanks in the middle of Darwin Harbour. They are leaking. They have not been built to withstand over Category 3 cyclones, and they were also constructed illegally. Again, this has been brushed over by Northern Territory regulators. So people in the Northern Territory are feeling desperate, they're feeling worried, and they're looking to the federal government to provide leadership here, amid these disasters. And instead, what we see are proposals that could enable devolution of powers to the Northern Territory government and to agencies within the Northern Territory government. And it's deeply concerning.
And what do you think the outcome would be? Would they faithfully implement the devolved powers, or based on the evidence we have, how do you think that would go?
Well, I think the trust in Northern Territory regulators' ability to regulate is at rock bottom. They're struggling to implement the laws, the weak laws that do exist in the Northern Territory. We'd have a lot of concerns about their ability to implement federal laws And we note that there's just such a lot of flexibility in those devolution provisions as proposed. So I'll give you one example. There would be an ability, if these laws are passed, to accredit non-laws, so things like guidelines, rules, things that are in writing. And that just opens up, a complete Pandora's box in terms of what we might see accredited and the ability to hold those entities to account. I just can't see it happening.
I know we're pushing on time, so one of the other concerns I have is just how unconstrained the national interest exemption is. And when I look at some of the projects in the NT, from Beetaloo to Middle Arm to Lee Point, I've heard politicians at every level talk about many of these things being in the national interest. And I'm just interested what you think about that when it comes to defence housing or gas, or what's that going to mean for these projects, and how do you think that national interest should be constrained to ensure that it is not just used in that way?
Well, yes, the national interest test has been pilloried, I think, by most people, including Graham Samuel himself. It's deeply concerning. It seems so broad. I'll mention the Middle Arm Gas and Petrochemical Hub specifically, which is undergoing a strategic environmental assessment under both, Northern Territory system and the federal system, the EPBC Act. That is a disaster of a project for climate, community, health, harbour, etc. There are a lot of concerns about it, and buried in there in the strategic assessment amendments, which I found on the weekend, is an ability to apply special national interest exemption to strategic assessments specifically. So we can see this playing out in multiple ways in the Northern Territory, particularly with the expansion of the military in the Northern Territory. We're seeing that, we're experiencing it. The US fuel tanks are a manifestation of that. And, what is possible potentially is that we'd see environmental protections, community protections, air quality protections compromised for some unconstrained national interest. And it's very concerning.
Incredibly worrying. Well, thank you, Chair.
Thank you, Senator Pocock. Mr Turner? Mr Roberts, sorry. It's been a long day. I'm confusing myself now.
I would just add to that. I echo what Kirsty has said, but just mention that in Western Australia, we also have the added concern with the AUKUS deal and what's going on with defence down in our southern suburbs. Similarly, adding that concern.
Thank you very much. May I say to both the Environment Centre for the Northern Territory and the Conservation Council of Western Australia, thank you for your evidence today, for the effort that went into the submission. If you have taken any questions on notice, could you please provide those answers to the Secretariat as soon as possible, but you go with the committee's thanks. So we appreciate your work.
And thanks for coming all the way.
Yes.
We really appreciate it.
Very much appreciated. Okay. I now welcome representatives from the Bob Brown Foundation and the Lock the Gate Alliance. If come to the table, please. Thank you. And just before we start the formalities, I acknowledge the presence of a former Australian senator and an illustrious one in Dr Brown. So welcome back, sir.
Thank you.
I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. Yes, I'm nodding at the table. Thank you. For the Hansard record, will you please state your full names and the capacity in which you appear today?
My name is Robert James Brown, and I'm here as patron of the Bob Brown Foundation.
My name is Jenny Webber. I'm the Campaigns Director with the Bob Brown Foundation.
Scott Jordan, Takina Campaigner at the Bob Brown Foundation.
Georgina Woods, Head of Research and Investigations, Lock the Gate Alliance.
Wonderful. This may be the 6th or 7th time you've heard me say this today. You're invited to make a short statement if you would like, but I think given the interest of people to ask questions, and respectfully, the shorter the better.
Thank you. This legislation is an insult to the environmental conscience of Australians, and the body politic which is charged with looking after the interests of Australia should throw it out. The fact that the Minister for the Environment is prevented from taking action on the biggest threat to the environment, which is climate change, is analogous to a treasurer having no power over taxes. And I say that must be taken seriously, because that's how the situation is. Furthermore, the embedding in this legislation of the regional forest agreements, which we know have been the biggest cause of destruction of the habitat of so many rare and endangered creatures in Australia, is an affront to the rights of Australians in the future. And I just want to talk about that for a second. If this was legislation to protect children, and it is legislation to protect their rights, it would protect children. It wouldn't let off the hook the primary sources of abuse of children. It wouldn't deprive the minister of the power to act against the biggest cause of abuse of children. And yet this legislation is being treated as with the indifference and contempt that our children don't deserve to have. And finally, I would say this. It must be taken seriously, the spiral down of environmental indices here and globally. And I point to just one of many studies which are available to this committee and to the whole of this parliament. And that's the British Institute and Faculty of Actuaries and the University of Exeter, which is known as the world's expertise centre on climate change. Actuaries, by the way, are those people who seriously look at risk, and they inform insurance companies and pension funds around the world. They are the best assessors of risk. And when they look at a 2 degrees centigrade rise in temperature over base levels by 2050, and we're going to overshoot that on current estimates, with Australia at the forefront of putting greenhouse gases into the atmosphere, given a tripping of tipping points like the melting of Greenland, which we're seeing at the moment, and the failure of the Amazon to absorb carbon, but in fact become an emitter, which we're seeing at the moment, continuing, the worst case scenario is a 25% collapse of the global productivity, that is the global economy, by 2050. That's when our children now are 25. We're not talking about grandkids, we're talking about our children. And 2 billion people dead. Thank you.
Thank you, Senator.
Thanks very much, Senator. I'll truncate my opening remarks just to say Lock the Gate is embedded in regional communities who experience the impacts of coal and unconventional gas mining, and the communities we work with are already experiencing the impacts of global warming-fuelled extreme weather. And so we are very intimate with the operation of the Environment Protection Biodiversity Conservation Act, and so are the communities that we work with. So I guess our evidence today is very much sort of from the practical perspective of the quality of the process, the quality of the decisions, and the quality of the assessment, and how people experience that and what it delivers for the landscapes, the water resources, and bushland that they love. We also part of the 130 organisations that submitted separately a statement about our very deep and wide concerns about the consequences of this bill. And our chief, concerns that I will hope to speak to today is really about, as the Environment Centres, the Cons Council said, the handover of decision-making of matters of national and international significance to the states and territories, the extreme fast-tracking under the streamlined assessment, which, as the Senator Hanson-Young pointed out, is anticipated to apply to most projects assessed under the Act, and the extreme executive power being vested in the Environment Minister to do damage to the environment without accountability. And we share the concerns of small and large environment groups and people around the country about the consequences of climate change, and are frankly baffled at the resistance to include the consequences of climate change in consideration of those impacts in Australia's national environment law.
Thank you. Senator Hanson-Young.
Thank you. Thank you all for being here. Thank you, Dr. Brown, for being here. It must be a bit weird sitting on the other side of the table. I'm sure you would have liked to have been here asking the BCA and the Forestry Association some questions earlier today. I am worried that the government seems intent on pushing this legislation through this year. They've listed it on the Senate notice paper. This inquiry is actually listed to go until the end of March. However, that's the government's agenda. But our job is to actually look at what's before us and try and work out if this is dealing with the problems we've got. Is there anything in this bill that helps with the destruction of our native forests?
Well, I might just say about the BCA, which you mentioned, Senator, that they employ about the same number of people as our foundation does full-time, but they've been entertained in extensive consultations with the Minister for the Environment, the Honourable Murray Watt. He's refused to see us. We can't have any comment. We're a key environmental organisation in Australia, and our Minister will not see us. That having been said, this legislation is black pudding, but it has a few pearls of barley in it. But if you concentrate on those, you're missing the point, that it's repugnant to the job it should be doing, which is protecting the environment. The devolution of further powers to the states, as we've just heard from the previous witness, runs counter to what corporations have always wanted in Australia. They've been fighting for uniform laws and uniform standards. And they come in here and they tell this Senate and this committee that we must have different standards, we must devolve this to the states. That's because they can pick off the state governments, as the previous witness said, so much more readily than they can do a federal government in the glare of federal publicity. So we have the fox in the chicken house here, and it's leading to a spiral down. And if the legislation proceeds this year, that will be with the coalition, and that can only be with a further degradation of the weakness that's already there. In other words, an appalling piece of legislation which sells out the environment will be even worse if we get an outcome by next week as scheduled for these Senate sittings. When it comes to looking for some improvement as far as the lot of forest is concerned, no, there are none.
So if I might add, thank you, Senator, from the forests, let's take us all into the forest where we spend a lot of time, is right now there's a logging coupe in Tasmania where there are 3 known nests of critically endangered swift parrots together breeding. That is forests that we found in 2023 to have fledgling swift parrots in the same forests that are still on the logging schedule. So the logging industry was told by our scientists that those swift parrots were there and the forests were not removed from the logging schedule. In New South Wales, where the endangered greater glider is, it's up to the citizen scientists to recently find across 7 forests 900 greater glider dens, where the New South Wales Forestry Corporation found 42. So what we are living in the forests of Tasmania and New South Wales is the exact example of the problems with devolution of powers to the states. Because of the appalling exemption for logging in native forests from the EPBC Act is the ongoing flattening of forests, and we're pushing species to the brink of extinction because of that. So what's a problem with these EPBC bills is that it does not remove that exemption of native forest logging from the EPBC Act, but it also proposes for the examples of regional forest agreements to be allowed to happen across.
That's a good point. RFAs are effectively already this devolution of power to the states, and look how that's going. Ms Woods, could I ask you, I'm particularly concerned about this, the concerns that have been raised by Lock the Gate, but many other organisations, of the overriding of the water trigger. What does that mean for the communities in rural and regional Australia who have been up against big coal and gas companies who want to protect their land for farming?
Thank you, Senator. Yes, I mean, across the Lock the Gate movement and network, water is the thing that unites everybody. It's the issue that most of our communities are most exercised about. And as the senators, I'm sure, would all know, the water trigger was created in response to profound concern and activism from the farming communities of the Liverpool Plains in New South Wales about coal seam gas and two large coal mines that were proposed on a very fertile food-producing region. And really, the water trigger has been crucial in being able to exercise some check and balance against the sort of rapacious approach that state governments tend to take to mining, because they do have an income stream from it. And in the instance of the Liverpool Plains, for example, I mean, the coal mine, the first of those two coal mines, was approved under the EPBC Act after assessment under the water trigger, but conditions that were imposed at the Commonwealth level by Minister Greg Hunt at that time essentially, tested the company's plans to such a degree that it had a contributing influence on them pulling out and stopping that mine, and that region is mining free for now as a result. And so it is absolutely critical to our communities that the Commonwealth maintain its oversight and control to prevent the damage of open-cut coal mining, underground coal mining, fracking and coal seam gas extraction on aquifers and rivers.
What do you think the farming community and regional communities would think after being told that there would be that someone in Canberra could at least have a look at what was going on, to now be told, actually, we don't care about you having access to that pathway anymore, or that check and balance, that it'll just be up to the state government? Do you think they'll feel betrayed, seeing as this was put in place to help them feel like they had a voice?
Yeah, we certainly know that our communities in regional areas who are facing the damage of coal and unconventional gas mining do look to the Commonwealth as a sort of a somewhat more distant party to assess and consider the impacts of mining on water resources. And certainly the expansion of the water trigger to include all forms of unconventional gas a couple of years ago means that the communities in the Beetaloo Basin and in the Kimberley now hope that there will be some Commonwealth oversight of the fracking industry. I mean, everywhere I turn, people in business and the commentariat, the corporate world generally, and politics are deeply enthusiastic to start the exploitation of the Beetaloo Basin. And the extension of the water trigger to all forms of unconventional gas, people up in the north are absolutely hanging their hopes on the additional scrutiny and protection that will offer.
Thank you. Perhaps to the Bob Brown Foundation, I'm interested in, you made some key points in your submission. You raised the issue of the pay to destroy program under the offsets model. Obviously, we've had offsets. These are biodiversity offsets. We're not talking carbon offsets. Talking biodiversity offsets here. There's been forms of offsets already. They already exist, but this is a new element that allows for the payment to offset, as opposed to a physical, nature-based offset. Could you explain why you think that that's problematic?
Well, firstly, it's important to understand, Senator, that this is similar to legislation that the Labor government, Keir Starmer, brought through in Britain just a few months ago. That at the end of the day, if it's a contest between the environment and the corporation can pay a get out of jail amount to the government and go ahead and destroy the environment. And there was enormous criticism of that, but again, it shows how corporations hand to governments around the world at the moment, in this corporatised world, similar legislation which then appears before parliaments in different parts of the world saying exactly the same, with exactly the same clauses. That said, a corporation will be able to pay a sum into a government fund to destroy a national heirloom, a unique piece of woodland with rare and endangered species, if it can't find an offset. And then offsets are a farce. We've seen similar proposed schemes in New South Wales and Queensland which are not working, but we know that each area of this wonderful country of ours and this brilliant little planet of ours is particular to the natural ecosystem of that area, and buying another area and hoping that unique species which are not in that other area can be transplanted from this one to that one is incomprehensibly absurd. But that's now being put into legislation because corporations want it. They can either get an offset if that's cheaper, and if they can't, then they'll be able to put a tax-deductible amount of money into the government coffers and destroy forever a unique piece of Australia's environmental heritage.
If I could add to that, under the current offset scheme, which is incredibly flawed, and the Samuels Review talked about that in great detail, if you were going to destroy habitat of Tasmanian devil and effectively wipe out that population of Tasmanian devil, you have to offset with a mechanism for protecting another population of Tasmanian devil. Now, Bob often sums this up as you start an agreement where you start off with two things and agree to have one. Under this new scheme, it doesn't have to be Tasmanian devil.
It's not a like for like.
You can wipe out both populations of Tasmanian devil and then maybe do something nice for something else down the track. It's a bit of a lucky dip because at the time you put the money in, you don't actually know what it is you're going to protect. And the decision makers can't know what it is you're going to protect. It's effectively just a licence to destroy. It makes our environment law an accounting mechanism, not a protection mechanism.
Thank you. You were here, I think some of you were here for the evidence we had from representatives from the Central Land Council and the Northern Land Council about, and they're obviously concerned that despite Indigenous community consultation being a core issue to deal with, as Graham Samuels has reported and recommended, that's kind of off for some time in the future. Have you got any reflections on what that means for the communities that you work with to ensure that Indigenous communities, First Nations communities have a say in the decisions that are being made on their land?
Well, it's as if they don't exist, Senator. It's worse than the native title legislation, which gave Indigenous communities no veto over protecting their land. Ultimately, the mining industry, etc., got the say. But this legislation is bereft of recognising the 65,000 years of relationship with the land of Indigenous communities and the knowledge they can bring to the impact of invasive developments on that land, as we've heard from the representatives themselves. It's a step back.
Might I add, the Tasmanian forest industry has highly controversial companies out of Sarawak. Ta'an and Shinyang operate, and so in times past, Bob and I have travelled to Sarawak and we've met with people who have not been engaged in free, prior and informed consent about their lands being logged in Sarawak by these companies. In this day and age, for Australia, to be operating where they're not going to prioritise free, prior and informed consent for the First Nations people of Australia is absolutely obscene. It's obscene in Malaysia, it's obscene for the people of Sarawak, and to see it now is an absolute embarrassment that the Labor Party would do such a thing.
If I could, on this question, I guess I would put aside for a moment the word consultation, which is obviously very important, but really what Australia has committed to internationally and what Professor Samuel recommended was involvement of Aboriginal people in decision making. So it's not just what do you think about this and then we'll just go and make the decision without you. It's, it's actually inclusive decision making that is necessary. And, it's really interesting, I guess, to us that the bill that's in the Parliament has, measures to involve the Aboriginal Advisory Committee in the listing process and the recovery process for threatened species, but no measures to involve the Indigenous Advisory Committee in the assessment process or the decision-making process about harm. And, that's uneven. And it is my genuine view that we will get better quality decisions if we take seriously the government's apparent commitment to involving Aboriginal people in environmental decision-making, because it brings a completely different lens to the question. And rather than doing the accounting process that Scott described, where you just add up how many hectares of forest you're going to clear, is 50% of it okay to clear? Maybe we should just clear 45%, and that's probably not going to be an unacceptable impact, this very numerical approach to assessment. We would actually start getting decisions that account for a much more holistic understanding of the value of the environment and how to take care of it. So, yes, we're very strongly supportive of participatory decision making.
Thank you. Yes, that's fine.
Thank you.
Senator Pocock. Thank you, Chair. Thank you all so much for your time. Dr. Brown, we've seen a lot in the media about the politics of environmental law reform. Why does protecting nature matter? Why should we have laws that protect nature?
We are all part of nature. We've come out of the forests. The curl of this ear is to pick up the faintest sound off the forest floor, and it's embedded not just into our physical structure but into our mental well-being, that is our soul. The simple example there is that if you give a bunch of flowers, which are of course nature, to your loved one, they get the message. Give them a bunch of artificial flowers, no matter how brilliantly they copy it, and you'll get a very unhappy return. It's why we put pictures of nature on our wall. It's why we want our children to be watching Attenborough, not some crime show. But as a doctor in the past, seeing 50% of people at least who were suffering from anxiety, the great restorative alternative to that is nature. And now in Scandinavia, the doctors are prescribing a walk in nature rather than more tablets. But we've become divorced from nature, and the problem for that is that we're destroying it at the greatest rate in history when we have less left than before, and it's simply thieving from our children. Nature is the wealth of this Commonwealth. It's the wealth of our nation. But this legislation discounts it to $0 value. It's priceless, but has no value. We have to take into account those values, like beauty and love and wildness and our children's interests, the intergenerational equity that we know we're responsible for, but it is not in this legislation. It's missing.
Thank you. Obviously, a lot of your work focuses on the forests, particularly in Tasmania. And earlier we had the AFPA here, the Australian Forest Products Association, and that you mentioned, Ms. Webber, that there's logging of swift parrot habitat. They told us that there was actually no native forest logging. I think they said within 100 metres of any tree that had threatened species in the tree, and then they even told us that actually native forest logging wasn't that much of a threat to forest-dwelling species. It was number 11. Number 11 of the threats. And so I was just interested if you could maybe respond to that.
So just as recently as 2025, there is exhaustive evidence that's come from swift parrot experts that are saying that 50% of swift parrot habitat has been lost due to logging since 2014. So not even that long ago. And more so, the parrot is on the path to the brink of extinction because of native forest logging. The Difficult Bird Research Group called the swift parrot difficult because it is unable to determine where it will land to breed. The only place it breeds is in Tasmania, but it does land in threatened forests, which once it leaves to come back here to Canberra to feed over winter, the logging continues in its forest, so completely flattening. We are still seeing clear felling of native forests in Tasmania that is mast owl habitat, that is swift parrot habitat, that is habitat for the Tasmanian devil. And we're not only seeing the clearing by logging, we're then seeing the incineration of those forests in autumn, incredibly insane carbon bombs. And most recently, we've also found evidence of a Tasmanian devil charred in one of those burns. So it's an outrage that anyone can say that the native forest logging industry is not sending the threatened species to the brink of extinction, because it frankly is.
One of the other things that we discussed as sort of looking at the RFA exemption, which Graham Samuel said he hated, was subsidies, and Senator Hanson-Young was asking a lot of questions of AFPA, and they said that they don't receive federal government subsidies for logging. I was just wondering if you could maybe clarify what's happening in that space. I was so hoping you would ask that question, Senator. The native forest logging sector in Australia runs on subsidy. They dress up the accounts every year, and you know, I think this morning the AFA representatives tried to claim Tasmania, or Forestry Tasmania, had made a $5 million profit this year. We crunched those numbers. To start with, they received $12.7 million in government grants. If you put 12.7 in, you get 5 point whatever out. That's a loss. You then take into effect that there was revaluations of trees. So the trees we didn't cut down, we decided they're worth more this year, so we put that in an income on the books to inflate the numbers. When you log them, you make a loss, so you have to write that off. There's unpaid superannuation liabilities that are continuing to grow because that money doesn't exist. We just put it on a ledger, pretend it's paid, and then at some point Treasury has to bail them out. The real loss for Forestry Tasmania this year wasn't a $5.8 million profit. It was about a $27 million loss. And add to that another $25 odd million of unpaid superannuation liabilities. That's money coming straight from the taxpayer, going into logging forests that are destroying that heritage, that value, that wealth that Bob's just talked about, but also driving those species to extinction. The robber barons of the timber industry are rolling, laughing their way to the bank. We're covering the loss. The taxpayer is cutting those forests down and delivering it to the wood chip mills. And to answer your earlier question, the vast majority does go to wood chips. In fact, last year, Tasmania's the percentage of wood chip increased by about 10%. The saw log, the veneer log, all of those other categories dropped. The market is walking away from those things, so the government is just chipping more. Chip it and sell it at the cheapest possible price.
They tried to dispute that too.
Yeah, they disputed a lot. I really wish these hearings were under oath.
Well, they are actually.
Well, I think you've got some work to do with.
Well, I'd like you to take that on notice and get back to us, because I want them to be held to account for the lack of truth that they gave this morning.
The Tasmanian logging industry's had more than $1 billion in subsidies from federal and state governments since I came into the Senate in 1996.
Sorry, Senator Pocock.
Sure.
I'm sure you would support getting them to have to admit that they've either misled the Senate or hold them to account for deliberately misleading the Senate.
I think the Senate should enforce its powers.
That's just the state government logging agency. That's not the freight subsidies. That's not the various grants that went to retool sawmills. And I honestly think that if we added up all the money we've given to sawmills and chip mills to actually buy their equipment, we'd probably own them by now. If we had an equity stake in that. The reality is this industry is completely funded by the taxpayer. And at a time we have a housing crisis, hospitals crisis, we're in desperate need of money into social services, and we're funding the most expensive work for the dole scheme in the world.
We saw in Victoria in court, Vic Forest lawyers essentially say, listen, if we can't log threatened species habitat, we're going out of business. There's not enough timber left. And so I'm wondering if the RFA exemption was removed in Tasmania, what's the plan for those small number of jobs that are still in native forest logging? What's the transition plan look like?
Maybe before Bob answers that, I would love to point out that the Victorian situation is quite dire right now because they're importing timber across the Bass Strait out of Tasmania to keep Australia's largest sawmill running, which is 49% owned by the Victorian government. So talking about subsidies and absurdities, that's a classic case.
One more question.
Sure. Yes,
I was just, there's in the order of 300 people involved in cutting down the forest and taking them to the various mills. It would be cheaper in the long run if they were given $1 million each. I had a logger come to my house quite recently and say, you're blockading my forest. Boys are thinking of coming and blockading your house, Bob Brown. And I said, well, bring them in because we'll give them a cup of tea. But I got talking about it, and he genuinely didn't have the ability to take on another job. But when I spoke to him about $1 million per payout per worker in the industry, he said, yes, but we won't get it, they'll get it. The corporations who are skimming the taxpayers for this money. And I said to him, well, we'll have to work together to ensure that doesn't happen. New Zealand did this in 2002, and now it's exporting wood to Australia.
Just, can I ask Lock the Gate one question? Yes. Thank you, Chair. And I just disclose that I did serve on the board of Lock the Gate in another life. One of the things that really concerns me is around the devolution of assessment and approval powers. And it seems to me that the only time farmers or anyone in regional areas ever gets a win is when they challenge through the federal system after New South Wales or one of the states has greenlit a project. And so I'm wondering, can the devolution of powers as they're currently drafted be improved? If so, how? Or is it just something that we shouldn't be looking at?
Well, accreditation of state approvals and other approvals is already available in the EPBC Act. So I suppose, it's the changes that are being proposed are to get over some hurdle that's currently preventing that from happening. And our read of it is that those hurdles are that there are stringent requirements. One of them is that's being taken out, which is so confusing. At the moment, you can only do it if the agreement that you enter into will promote the survival and or enhance the conservation status of each species to which the declaration relates. That's going to be removed, right? So that will no longer be needed. And obviously, the water trigger is a special case because Tony Windsor, negotiated that would not be available to be handed over to the states. So there are protection. It is a process that's available right now. But it's a process that comes with checks and balances and some stringencies. As Dr. Howie said, you can only accredit a thing that is a law. You can only accredit a decision by a government agency. These things are what the government is proposing to change to essentially make it easier to hand those powers back and remove the checks and balances that are currently in place.
Thank you.
I could add to that what happens now in terms of currently in Tasmania, like many states, the assessment side of an application can be managed through a devolved process through a bilateral agreement. In 2014, I was part of a case where there was a proposal for a strip mine in Takona, in the beautiful rainforest, and the company that had sought its approval was put through to a bilateral assessment. So the state government, EPA, managed the assessment with the federal minister still holding the power to make the decision. Now, the state government decided, even though it was required under federal government law, it didn't want to assess the cumulative impacts. That company had 3 proposed mines within a 15-kilometre radius. So they didn't do it. The minister got that report from the state government saying, no, it's all good. We didn't look at this bit, but it's all fine, and then went ahead and approved it. We had to take that case before the federal court, and the federal court ruled that the current act is so weak that even though they hadn't completed the full assessment by not doing the cumulative assessment, the approval would stand. Now, under this proposed system, they get to make the decision in the first place. The minister doesn't even get a second look at it. If they decide that there's bits of the federal law they don't want to look at and they don't do it, the court status, and there's nothing in this legislation that would overturn that without legislation to make it explicit that they can't avoid parts of the system. They're free to choose which bits they want. And so that's the real world reality of what this bill delivers for us.
Thank you, Senator Pocock. Senator Duniam.
Very brief question. Dr. Brown, you and I have disagreed on things in the past, and I'm sure will into the future, but I think one thing we will all... Yeah, very amicably, yes, that's the nature of our disagreements. One thing I think we will agree on, though, is you are a respected leader of the environmental movement, not just in Tassie or Australia, but globally. And as former leader of the Greens, I want to know, you've had some very strong views on this legislation as it sits before us today. Is there a world in which you could see these laws passing without the coalition support, that is with the Greens' support?
Of course there is. And you might know, Senator, that I was a leader of the Greens when we signed the Labor-Green Accord in Tasmania in 1989, and that required us to agree to almost 3 million tonnes of wood chipping a year, a cap on that. But politics is the art of compromise. And if the government, as seems unlikely, is not going to make an arrangement with the coalition but tries to get the Greens to come up with a form that's acceptable, which will necessitate some major improvements on the UPBC instead of going backwards as this one does, that's their job. And I'll be urging them to do the best they can for this nation to try and make a silk purse out of this sow's ear.
Thank you. Senator Grogan.
Thank you, Chair. And thank you for your time today. I do really appreciate it. Dr. Brown, as Senator Duniam just said, you're a highly respected person across Australia. You've worked very hard in the environment space for a very, very long time. You were very critical of the consultation process. I'm just wanting to understand, you are aware that the Minister has met with a lot of environmental representational groups, ACF, Greenpeace, WWF, AMCS, Climate Council and the state con councils. And there was also significant consultation, even though we'd have to admit there were some issues with it in the preceding 2 years. Are you saying that the consultation was insignificant or ineffective because you weren't meeting with the Minister at this point in time?
As far as our foundation is concerned, it was there was no consultation. There has been no consultation. I'm very pleased to know that environment groups are being involved, but from what I read in the press, the Business Council of Australia and the logging industry and the mining industry are engaging a great proportion of the Minister's time. And the question has to be put, how would it be if we were, instead of discussing environment law, we were looking at reform of corporate law, and the Minister there was spending most time with environmentalists discussing how those laws should be rather than corporations? There'd be outrage. But when it comes to...
But Dr. Brown, I know we're short on time. That's you making an assumption.
No, that's me.
Reading headlines in the press. I assume you don't have access to the Minister's diary.
No, I'm not making any assumption. I'm saying what I read in the press tells me that. The Minister's been here, and if you've asked him if that's not the case, that'll clear the air, or he could come back and answer for himself. But I'm telling you that's the impression I've got, and so have a huge number of other Australians at the moment.
Well, I think I'm pretty confident that he's had a fair hearing across the board. And the views of the environment and the views of business and the views of the community are all critically important to this.
Oh, well, thank you, Senator. And if you dismiss my testimony...
I'm not dismissing, Dr. Brown. I'm really not dismissing at all. I feel like your characterisation is maybe based on media headlines.
what else do we do but base our characterisation on the evidence before us, Senator? That's what this inquiry has to deal with. And
thankfully, this inquiry will not be making its decisions based on newspaper headlines.
Well, you asked my opinion and you got it, and I'm very glad you've taken it into account.
I appreciate it, Senator Grogan.
Thank you very much.
I have something to add to this, Senator Grogan, if I may, because I think it's probably not sort of wholly accurate to represent this as something that only the Bob Brown Foundation is experiencing, and they're sort of asserting that they. No, I know, but I just for the purposes of the committee, the statement that we lodged with 129 other organisations about our concerns about the bill. Those organisations also, only saw the legislation when it was brought to the Parliament. So we have had we haven't had, the chance to discuss with the government what we think is wrong with the EPBC Act and how it could be fixed to serve communities and the environment. And in our experience, process is really, really important for trust and consensus, and people feel angry about, and because they love their local environment so deeply and feel quite often that they have to fight the government to protect it, they're not giving people the opportunity to discuss and share and have input into the process actually just kind of heightens the emotional intensity of what the government might now be experiencing in terms of people being very upset about the content of this bill.
Yeah, so maybe, Ms Wood, one of your submission and your evidence today, just to be clear, you've raised a significant number of concerns that relate to core recommendations from the Samuels Review, so rulings, devolution, state accreditation, etc. Would it be your position that the government should not be implementing the recommendations of the Samuel Review?
No. There were certainly elements of Samuel's recommendations that we didn't wholly endorse. There were things that he didn't recommend that we thought would be useful. There were things he did recommend that we didn't like. But I don't believe the government is implementing the recommendations of the Samuel Review. I think the bill that has been put forward very selectively responds to some of the recommendations of the Samuel Review. But I have quite a number of things here because Samuel did say in his review that the lack of opportunity to substantively engage in decision-making under the Act further erodes trust. He also said that companies and actions should transparently disclose the full emissions of their developments. He also said that on average the process, that is the assessment process, is under the management of proponents for at least 70% of the time. So the idea that the government process is costing business time is actually debunked by the findings of Samuel. And yes, he did recommend an exemption power, but in fact he called it a public interest exemption, not a national interest exemption. And throughout his report, his use of the phrase national interest only refers to the necessity of protecting the environment in the national interest and the importance of the government doing that. He did say that there ought to be, in limited circumstances, a public interest exemption, and I think possibly our concerns would be less profound if that phrasing were used, because it is a less political phrase. There's other examples, but yes, I don't think that the government's bill actually does implement the recommendations of that review.
Okay. Thank you so much. Appreciate your time. Professor Samuels himself has said that he believes the bill should pass, even though he, has a couple of things. It might be worth watching his testimony as well. But I really appreciate your time. Thank you so much for coming along today. Thank you, Chair.
Thank you, Senator Grogan. Now I'm going to go to Senator Henderson briefly, and then we're going to wrap up.
Well, Chair, thank you. And in contrast to the Minister, Dr Brown, I consider your organisation to be one of the most significant environmental organisations in the country. So thank you very much to you and also to Lock the Gate for your appearance here this afternoon. We do appreciate it. Dr Brown, are these bills before the Parliament fixable? And do you think that there is any prospect that they could be passed in the next week?
I think the only way in which they could be passed in the next week, as the Prime Minister wants, would be for an arrangement with the opposition. But there would have to be a huge suite of changes to the legislation. And primarily, I note the Greens have said this, there has to be some form of climate trigger or some sort of form of dealing with the biggest threat to the environment instead of a complete inability to deal with that. And with forest, to end native forest logging and woodland clearance, which are the biggest causes of extinction and leads to extinction in Australia. The schedule here has been set for no good reason, and we've just heard from my colleague at Lock the Gate that a lot of organisations feel frustrated that they haven't been able to, and we've heard it from previously from other organisations. But that said, it will be up to the Senate, and I wish the Senate well in those deliberations, but I think there's a lot of wisdom in the Senate, and I think the government's on a hiding to nothing at the moment.
Dr Brown, I've raised some concerns, major concerns about the impact that various renewable energy projects are having, significant environmental impacts. I raised these in the context of wind farms in Western Victoria, the damage to the Brolga population. You've raised very significant concerns in relation to Robbins Island. Can you make any comments about the impact, the environmental damage of some renewable energy projects in the context of these bills?
Yes, Senator, I was commenting earlier that my teeth were cut on ending a renewable energy project, which was a dam on the Franklin River. And you see, we have to be...
I remember that one. You did a good job on that one, I have to say.
With many others. But we have to be sensible and not have a broad brush approach to this. And there will be occasions where we do need renewable energy to get us out of the extraordinary crisis that humanity's in at the moment. But that can't be a broad brush approach, and there are exceptions to that, and the government should be taking those into account. That appears not to be. That having been said, I am amazed that energy efficiency is not on the agenda. That could provide a proper energy efficiency program could provide for Australia as much energy as nuclear power. It means saving energy. It's free. It creates lots of jobs, and it passes new power into the country at lower prices. But also with renewable energy, there are great options, and a little one. Today, flying into Melbourne and then into Canberra, there are vast acreages of roofs which have no renewable energy. I'm talking here about industrial roofs, and at the same time, massive housing estates with black roofs going on. Now, if we want to solve climate change, we should very simply make sure that people have light-coloured roofs so it deflects the heat back into the atmosphere. I'm not talking about a little thing here. I'm talking about thousands and thousands of new houses going with almost black roofs. But what is it that prevents those hundreds of acres of flat roofs on the big factories around all our major cities from being occupied by solar arrays, for example, if not wind towers? We don't have a great deal of broad scope look at the problem, and so it all goes into one basket, and when you do that, you run into trouble because some people get hurt unnecessarily.
And just on a related issue, we raised concerns about the 9.75 billion square metres of land that have been approved for clearance for renewable energy projects. Now, they were approved by the former Minister, Ms Plebiscite. So that's a very big, alive issue as well. And if you look at what's happening in Western Victoria with the Western Renewables Link and the impact that that's having on farming communities, on food security, those high voltage transmission towers are absolute blight on the landscape. And so it just seems that under this government, Dr Brown, there is no regard for the environmental harm that renewable energy projects can cause to precious parts of the environment.
On the other side, we have to recognise that, to quote a former Liberal member of this parliament, we're in deep doo-doos if we don't utilise renewable energy to...
no, that's not... Look, I'm not contesting that. It's just that in relation to the environmental harm caused by some renewable energy projects, it just appears that that is not on the government's radar.
On the other hand, there is a pretty strong movement to prevent all renewable energy because it's bad, and the alternatives end up being coal and gas, and they are the biggest single threat to this planet at the moment.
Senator,
do you have anything to add, Ms.
I do
Brooks?
actually, and it's sort of after 5 o'clock, so I can speak outside my remit because we work on coal and gas, of course. So, but I do think that it's good that you raised this because all of the fast track mechanisms that we are very concerned about for coal and gas mining could also be used for renewable energy, and I think probably are intended to be used for renewable energy development. I mean, I agree with Dr. Brown that obviously we need a renewable energy system. We need urgently to act on climate change. But as one example, I'm not sure you might not know as a Victorian, but one example of the federal government actually refusing a project that was approved by a state government was a wind farm right next door to the Wet Tropics World Heritage Area in Queensland. And so that's a really good example for why devolution of power entirely to the states is going to put the environment in harm's way, and that the Commonwealth does need to retain this oversight. And I think you're right to be concerned that these fast tracks could be used to do harm to the environment in the name of the clean energy developments.
Thank you so much. Thank you all very much for your evidence today. Thank you.
Thank you, Senator Henderson. Thank you, Deputy Chair. Well, thank you for your evidence today, both the Bob Brown Foundation and Lock the Gate. If you've taken any questions on notice, could you please provide answers to the Secretariat as soon as possible? That brings us to the end of today's hearing. Thank you to all the witnesses who've appeared and made submissions, to Hansard, to Broadcasting and the Secretariat for their assistance. I also thank, as ever, my colleagues for their patience today and their cooperation, and the committee stands adjourned.